This is the House Judiciary Committee. It's Tuesday, February 25th, a little after 1 o'clock. Good afternoon. We're going to hear some bills, I think. That's why we're here, I think. House Bill 139 is going to be our first bill. This is Delegate Young's bill. We're going to hear from Delegate Young, Jamal Turner, Clyde Boatwright. All are in favor, along with Ashley Devon, who is virtual. Yes. Okay. So if I've called your name and you're in the room, Jamal Turner, Clyde Boatwright, come on up to the table. And Delegate Young, please go ahead, 3 minutes, and we'll go from there.
Thank you, Madam Chair. Excuse me, Mr. Chair. Starting off wrong, Mr. Chair. I'm sorry, Mr. Chair. Lord, can we start over, Mr. Chair?
Next bill.
I'm normally tight. I appreciate you, Mr. Chair. Thank you so much, as always, Madam Vice Chair and members of the Judiciary Committee, Delegate Young, 45th District, here in support of House Bill 139. House Bill 139 seeks to help remedy some of the challenges that we've seen as it pertains to the timelines of investigations. As you all know, under House Bill 670, the Maryland Police Accountability Act of 2021, when a complaint is submitted by a complainant, there is a year and a day from the time that that complaint is submitted to the time that a decision has to be made by the Administrative Charging Committee. That has determined to be a challenge, at least in Baltimore City, where we've seen an average of 50 weeks for a complaint to get to the charging committee. There are instances where that has been less than 3 days, and special accommodations have had to occur to make sure that those cases did not lapse. Under 670, the charging committee is supposed to have 30 days to make an initial decision as it pertains to a decision, or whether they would use the subpoena power to ask for additional context. But again, as you well know, and based on what I just shared, it's probably not so it's not so clean, it's not so easy, rather, to do that work when you only have but a few days to determine. First off, when you receive the complaint, to review the complaints, and each investigatory file takes hours to clear up, and we've got folks from the Police Accountability Board and Charging Committee to speak to that. But at the end of the day, we just want to make sure, with the goal of the bill, it's written as 9 months for the investigation, and then it leaves the remaining 3 months and a day for the charging committee. Let me tell you what my goal is and what I'm asking of the committee. Is simply that wherever you land that investigation, whether it's 9 months, whether you give them a year, whether you give them 10 months, it doesn't really matter to me how long y'all give for the investigation. But I'm seeking a strict and bright line from when the investigation ends and is given to the charging committee. The charging committee then at that point has its own time, its own clock to start. So under the bill, that is a 9 month and 3 month split, where the investigation must go to the charging committee for it to begin its work. I leave it to you all to decide if it needs to be 9 months and 3 months, or if it's 10 months to 2 months, or whatever that might be. But that split has to happen, because the charging committee has to have the full complement of its time to be able to achieve its work. Right now, under legislation, under the current law, it's a 30-day timeline for the charging committee. There is an amendment that was submitted that I do see as friendly that would extend that to 90 days for the charging committee. So again, to conclude, I'm specifically asking that we split the timeline from the investigation for the charging committee to have its own time, and if you see fit, to expand that time for the charging committee to 90 days. Thank you, Mr. Chair.
Okay, I can go next. So thank you, Chair and Madam Chair as well. I want to say first, I'm Jamal Turner. I'm the Chair of Baltimore City's Police Accountability Board. And accountability cannot be subject to a ticking clock. Right now, Maryland's year-and-a-day rule is a roadblock to real justice. It allows police misconduct cases to be automatically dismissed, not because the facts don't support the action, not because an officer is innocent, but simply because an arbitrary deadline has been passed. The rigid deadline also undermines thorough investigations. Some misconduct cases take longer to uncover, whether because of internal delays, lack of immediate evidence, or the complexity of the situations. So let's be clear. No other profession that holds power over life and liberty operates under such a short accountability window. We don't give doctors, teachers, or government officials immunity from consequences just because a year has passed. So why are we giving it to officers entrusted with the authority to enforce the law? House Bill 139 is about fixing a broken system. It ensures that complainants are judged on their merits, not dismissed on a technicality. It gives victims time to heal and speak out. It gives witnesses the confidence to report wrongdoing. And it ensures that our accountability systems are not just performative, but effective. 1 year and a day is not enough time for justice. I urge you to support House Bill 139 because accountability should not have an expiration date. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Clyde Boatwright, and I'm the president of Maryland State Fraternal Order Police. Our testimony here today is simply to support this piece of legislation, House Bill 139, with the understanding that we want to have our police officers get due process in a timely manner. That's our sole position here. We want our officers to be free from having the I guess the haze of an investigation over their head for a long period of time. We think that it's important in order to have accountability, but also to gain trust that these investigations are done in a timely manner. So we're simply saying, if you have an allegation against a police officer, make it a priority to get it investigated and get it to the charging committee so they can make a determination whether the charges should move forward or not. So we're here in support of this legislation to give, to kind of make sure that, due process is intact. So we ask for a favorable report for this House Bill 139.
Thank you. Ms. Devon now, please, for 2 minutes.
Good afternoon, Chair, members of this committee. Last year, when the Public Safety Police Accountability Bill for investigating records bill hearing was heard, we learned a lot about the administrative investigative process. One of the things we learned is that Maryland practices is what hinders the timelines of investigations. The FOP testified last year that anytime there is a criminal case and there is also an administrative case, the administrative proceeding is held up to align with the criminal adjudication proceedings. We also learned that many of these administrative investigations have been used as bullying tactics to keep officers from seeking new employment and furthering their career with other departments and agencies. We're going to hear later today HB 885. And I will say that this particular bill puts a statute of limitations that stops the bullying culture within police departments and really brings the police department further aligned with professional standards that we have grown to know through every industry here in Maryland. And for those reasons, we urge a favorable report on this bill.
Are there questions for this panel? Are you sure? The Vice Chair?
Sorry.
Vice Chair.
Thank you, Mr. Chair. I'm not sure who to direct this question to, but my question is, what is the average amount of time that it takes now, and why? I think Ms. Devon might have been getting there, but I'm not sure.
My understanding is it varies around the state. The most acute challenge is in Baltimore City, where that average is roughly 50 weeks.
50 weeks?
That's correct.
As in almost a year?
That's correct.
Okay, thank you.
If possible, I did want to add just a bit more of context. It depends. So if a criminal case is accompanying an investigation, typically the investigation will not be completed until the criminal case is also concluded. However, if a civil case is accompanying an investigation, the administrative investigation will conclude before the civil suit is heard. And so that presents several issues as it pertains to providing the appropriate due process for officers.
Valentine.
Mr. Chair, and thank you, Delegate, for bringing the bill, and thank you for the panel for being here today. My only question is, and I just want to be clear, this does not change the year. This just simply states that this investigation will be done, forwarded to the appropriate committee, and give that committee the appropriate time, whether it be 2 months, 3 months. Is that correct?
Under the draft as presented, it's 9 months and 3 months, and that is the goal. But again, I leave it to the committee to decide if that 30 days is good, so it'll be 11 months, 1 month, or however you might break it down. as long as, again, we try to create that stark difference in the timelines.
So you don't run into you have 3 or 4 days to make a ruling.
That's
That's
correct.
correct. That's what I've understood.
That's the goal, yes.
Thank you.
Thank you, sir.
Delegate Sample Hughes.
Thank you, Mr. Chair, and actually, thank you also to the delegate. I wanted clarity on the year and the day. I was just making, because the testimony was a little different. It sounded like we wanted to shift that year and a day a little bit longer, I think, from the gentleman on the end, but I just want to be clear on that one. But what I also would like to know, what have you learned has been some of the hindrances? And I don't know if Mr. Boatwright might speak to that, because what I'm aware is that maybe the state prosecutor's office may be taking a longer period of time sometime in some of these cases, and you may not have any resolve until the 50th week.
So to answer your question, and thank you for your question, it goes into the priority of the police chief and the investigative staff. Most of the cases are backed up because there are not enough investigators to investigate the high volume of cases that are coming in. And I'm not saying that all of these cases need to be charged, because you'll see a large number of the cases are not charged by the ACC. However, it's when you have a member of the public involved, and the priority has to be set by the police chief or commissioner or sheriff or whoever it is to have sufficient investigators in place that can handle the number of cases that they're seeing in order to get them to the administrative charging committees in a timely manner.
But before it gets to go back to the chief, there may be some variables in between as to why it hasn't gotten back to the chief. And then my last question is, what is going to be the repercussions if this is still same as usual practice and waiting until the 50th week?
Well, that's that's what the goal of the bill is to try to achieve.
Right, but what happens when they don't
There's
meet that?
there's no remedy, and there's no recourse as it currently states other than public pressure. I mean, that's what you've seen in the
Okay.
city is the public pressure when those come. But let me answer your first question as well, which is, like you said, it's 50 weeks. There's questions about whether it should be longer, 52 weeks in a day. There's questions about whether it should be longer. So just to summarize for everybody, current law, 1 year and a day, investigation and decision all together.
Yeah.
The bill seeks to bifurcate that. I leave it to the committee on whether this is an appropriate bifurcation or a different bifurcation. There's also an amendment that's being submitted that would mandate 90 days for the charging committee. Under the current draft, it provides that 90 days. But if you did not give it 90 days, or if you wanted to give the investigation still a year or a longer period and not 9 months, then if you did both of those things, then you might go beyond a year and a day. So it's a few options, but at the end of the day, as drafted, what we're trying to seek is a bifurcation at minimum.
Okay, thank you, Mr. Chair.
Seeing no further questions for this panel, we thank you all very much.
Thank you.
Thank you.
We're going to go to those people who have signed up to testify favorable with amendments. Sarah Sample, Jesmyn Riggins, Raym Kelly, Sergio Espana. We could have all of you come up. And then there will be 2 people in opposition here in a minute. Whoever would like to go first, go right ahead.
All right, thank you to the chair and members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendments House Bill 139. It's been about 5 years since, or almost 5 years since Maryland Police Accountability Act has been implemented, and we now, in the last 2 years, have a lot of reports that are telling us about what's going on locally on the ground, but also we have a GOCAP report that was done independently that's given us even more information. I've found that incredibly useful this session as we're looking at a lot of these bills. But that's to say that we think enough time has passed that some of the major concerns that need to be fixed are rising to the top, and timelines is absolutely one of those. We would say that we think that separating the investigation timeline and the review timeline is absolutely important. Our concern, though, is that 9 months for some of our larger jurisdictions, especially a jurisdiction like Prince George's County, which has a number of municipality police forces, they're not going to be able to make that 9-month deadline. But we do think that there should be a separation. We're proposing 11 months, so that way the ACC has at least 30 days to make sure that they can review it, issue subpoenas if they would like to, ask for further documents and things along those lines. I don't think that's a perfect solution, but that's something that we wanted to offer just as something to to make sure that this committee knows that we do want to make sure that there is that separation and that there is a thorough review process and that civilians do feel like that this is a process with integrity and we're able to actually do it right. So we would support with amendments for those reasons. Thank you.
Good afternoon, committee, and thank you for hearing my testimony today. My name is Ray Kelly. I'm the vice chair of Baltimore's Administrative Charging Committee, the community policing expert for Maryland's Police Training and Standards Commission, and the executive director of Baltimore's Citizens Policing Project. We fully support the concept of timely and thorough investigations of police misconduct as proposed in House Bill 139 and urge the Judicial Proceedings Committee to report favorably while considering the proposed amendment to remove the 30-day adjudication requirement imposed upon the Administrative Charging Committee. Though the United Nations defines effective police accountability as involving many different actors representing the different layers of modern-day democracies, including government representatives, the legislature, the judiciary, civil society actors, and independent oversight bodies, such as the National Human Rights Institution, the process primarily is relying on the efficiency of the police department. Accountability should primarily remain a system of internal and external checks and balances aimed at ensuring that police officers carry out their duties properly and are held responsible if they fail to do so. Such a system is meant to uphold police integrity, deter misconduct, and restore or enhance public confidence in policing. Police integrity refers to normative and other safeguards that keep police from misusing their powers and abusing their rights and privileges. HB 139 would serve an important role by ensuring that investigations into police misconduct are completed within 9 months of receiving the complaint. This timely approach is crucial in maintaining public trust and ensuring that justice is served without unnecessarily delays. However, we propose a 30-day adjudication requirement imposed on the Administrative Charging Committee.
Thank you very much. Whoever would like to go next, please.
Yes, my name is Jesmond Riggins. I'm a member of the Police Accountability Board of Baltimore City and also a member of the Baltimore City Administrative Charging Committee, and I'm a former supervisor for the Baltimore City Civilian Review Board. So I support this bill with amendments. I actually think that the 9-month timeline is actually too long. I actually believe that for a jurisdiction like Baltimore City, who's already under the federal consent decree required to complete their investigations within 90 days, which they've been unable to do since the establishment of the Civilian Review Board in 1999, I think it would be more appropriate that 6 months to complete investigation would actually be more appropriate and more reasonable. If there are exceptions that need to be made, I do think that could actually be something that could probably be sort of amended into the bill. I also think that to provide a sort of a timeline that is described in months, I think it's rather than days. I think that won't allow for proper benchmark, and I actually think that the timeline should actually be in days instead of months. So, for example, 6 months would be 180 days from the time that the law enforcement agency receives the complaint. And another amendment is that the bill doesn't necessarily account for when officers or when the police department discovers misconduct outside of a complaint. So, for example, when they're doing body-worn camera review or some other audit that may potentially flag misconduct, and that that is something that probably should also be built into the bill, which is to capture both when a complaint is filed, but also when the police department discovers misconduct outside of a complaint.
Thank you, Chair, Madam Chair, members of the committee. My name is Sergio Spagna. I'm a proud Baltimore resident, District 41. I'm here representing the Campaign for Justice, Safety, and Jobs, a coalition of over a dozen organizations based in Baltimore that provide direct services, advocate for justice, and help to empower residents to get more politically involved. And we're here to support HB 139 with the suggested 90 days amendment. We know the facts. Baltimore City is safer than we have been in several years, thanks to the efforts made by our residents, our elected officials, and the support of state legislators, in particular this body, the Judiciary Committee. And so just generally as a resident, appreciate those efforts. Since passing the Maryland Police Accountability Act in 21, we have seen a drop in crime in most jurisdictions and unquestionably in Baltimore City. That package of bills that many of you worked on helped ensure that our publicly funded, public service-minded policing institutions would have the infrastructure, including independent civilian oversight, to make sure that police departments across the state are focused on enforcing the law and living up to their set standards and regulations. But as has been mentioned, there is room for improvement, and we're starting to see that the timeline in particular is crucial. Administrative charging committees were established in every county. We already talked about that. Just for the sake of time, we'll get into it. As seen from the work that Baltimore ACC, PAB members have been doing for the last several years, they are living up to that goal, but they are limited by not having enough time to ensure ACC members have the capacity to thoroughly review each case. Because of how seriously, and I've heard over again firsthand, how seriously they take this responsibility, they are working much longer hours than initially asked for in order to meet the deadline. And just holding above water and reviewing cases, as there have been several instances where BPD, as an example, shares cases at the last minute. This is why I'm grateful Delegate Young is introducing this bill, including with the brief amendment to extend ACC members' time to review cases to 90 days. For those reasons, our coalition supports this bill with amendment. Thank you for the time.
Questions for the panel? Vice Chair.
Thank you. Mr. Riggins, I have a question for you. I just want to make sure I'm summing up what your position is. Do you believe essentially that more time means more time or more delay?
Yes,
Okay.
I believe more time means more time.
All right.
Yes.
And so I just wanted to make sure I understood that. So you're on the Baltimore City PAB now, right?
Yes, and the ACC.
And ACC. I'm going to ask you the same question. What are you finding to be about the time frame in which, and things are getting taken care of now?
I think that, we're under a tremendous amount of pressure. We are a part-time outfit, and we reviewed over 1,000 cases last year. A substantial chunk of those came last minute. We've had less than, at times, a couple of days to actually review a case, which requires us to go through body-worn camera. Actually, if we, read the investigative report, go through other evidence, if we had the opportunity, we absolutely have no time to do any of the other things that the law gives the AZC the ability to do. We can't subpoena because we don't have time. We can't ask for a more thorough investigation because we don't have time. We simply have to accept what we're giving and ask questions to hopefully get some clarification before the case expires. But there are times where, the Baltimore Police Department will give us answers via email that may not be responsive to what we're actually asking, and then there are times they just don't respond. Mm-hmm. Yeah. Okay,
so let me ask, are you finding that when you say you're rushed to make a decision, do you feel that, is that decision more often than not leaning towards whatever the agency already decide, or are you finding that it's in the opposite direction, or are you just finding that it's, I'm just trying to get an idea of the result of the brevity of time and how that's affecting decision-making?
Yeah, I think that's a hard question to answer because it really depends on what we actually receive. Yep. Right. So there may be times where we have a limited amount of time and we may actually disagree with the disposition designated by the police internal affairs. Mm-hmm. Right. And then there are times where we actually agree. Which is easier, right? Because, but in those instances where there may be issues here, or there may be material documents missing that's referenced in the investigative report, but we can't find it in the evidence to actually double check to see if how this thing is being described was actually, is actually what was done or what was said. It's very hard for us at times to do our job properly. We do our job, but at times it can be very difficult.
What happens, this is my last question, Mr. Chair, what happens when that happens, that scenario? Can you give me an idea of what happens when you ask for something, you didn't receive it, and the time ran out? What was the result in that scenario? If you can recall.
Right.
No worries if you can.
Yeah.
So we have had instances, so it's been our practice to, on behalf of our community members, to do our due diligence to adjudicate every case. So we have had instances where we've received a brand new full investigative summary the day before. Because of who sits on our ACC and their commitment, many of us have stayed till 2 o'clock in the morning to make sure we can get this case heard before it expires. I think the big issue is the fact that we do about 100 cases a month, 30 cases a week, where essentially the 30 days would never relieve the pressure on us or the support staff to actually create case dockets that allow us that time, because as it stands, we have 30 days essentially to do 100 cases.
Right, well, you had me at 2 a.m. Thank you.
Are there further questions for this panel? Seeing none, thank you all very much. Go to those people who are unfavorable now. Russell Hamill from the Chiefs and Sheriffs. And Debbie Levy, who is virtual from the Office of the Public Defender. Mr. Hamill, whenever you're ready.
Thank you, sir. Is the mic working? Okay, thank you. So good afternoon, Chair Clippinger and Vice Chair Bartlett and this honorable committee. I'm Russ Hamill. I'm here representing the Maryland Chiefs and Sheriffs Associations opposing House Bill 139. Our main concern with this is the proposed bill imposes strict and arbitrary deadlines on the investigative process, creating a higher risk of errors, overlooked evidence, and incomplete investigations, especially with complex cases. By mandating the investigatory files be forwarded to the ACC within 9 months, this bill would prioritize speed over thoroughness. Investigations to police misconduct, particularly those involving serious allegations, require time to properly analyze evidence, interview witnesses, and analyze all further relevant facts. Rushing this process could lead to wrongful conclusions, whether in favor of the accused officer or the complainant, ultimately undermining public trust in our systems. The current framework allows for investigations to be conducted thoroughly without undue pressure, ensuring that disciplinary actions are based on comprehensive and well-substantiated findings. Changing this system risks diminishing the quality of police accountability and could lead to both unjust discipline and wrongful exoneration. We would respectfully request that this an unfavorable report from this committee. We would also, hearing some of the amendments this morning, I was jotting them down. We'd be more than willing to discuss those as well. And I would be remiss if I didn't note that I was advised yesterday of a recent survey of ACCs throughout the state, and this seems to be centric to one location. This is not an issue in other locations. Thank you.
Good afternoon, committee members. I want to first thank Delegate Young for bringing this bill. Although the Office of the Public Defender issued an unfavorable report, in spirit of this bill, we are 100% in support of it, and bringing law enforcement investigations to a close in a timely manner so that ACC can do its job is a top priority for the Office of the Public Defender. Our concern is the same that Delegate Sample Hughes raised. What happens if there is no consequence for law enforcement agencies continuing not to finish their investigations on time? And we would propose a sanction be imposed for police departments who are not prioritizing this. I think it was Mr. Boatwright who said chiefs and sheriffs need to prioritize these investigations. And perhaps if there was a financial consequence, just like the Department of Health has to face if they don't move an individual when there's a bed unavailable for them at a hospital, if a police department cannot prioritize this and finish those investigations, then a sanction should be imposed. And our concern is that by shortening the timeline, which I think is a reasonable idea and we support finality, if we're going to shorten them so much that more investigations are not done, then we're really taking a step back. So we support giving the ACC the appropriate amount of time for these excellent public servants to do their job. We're concerned about a lack of a consequence. In conversations with Delegate Young, I think OPD has reached the conclusion if this works, if shortening the time works, then we've accomplished the objective. And if not, we'll come back and ask for more serious sanctions to be imposed against local law enforcement officers. And to the gentleman's point that just spoke before me, I have found instances of ACCs complaining around the state that they're not properly staffed. So I think that that's not entirely confined to just one jurisdiction. I think this is a universal problem. Thank you.
Questions? Delegate Simmons.
Thank you, Mr. Chair, and welcome. Can you give me an idea of how many investigations are launched per year and how many are concluded?
Sir, I don't have that information across the state. I can speak for my agency that we have not run into this problem, our investigations, and they vary year to year, how many we do, but we get them there in a timely fashion. If the ACC has questions, my staff gets them answered. We make sure we get the information to them as quickly as possible. So we have not run into this issue that we're hearing.
Okay, so specific to your department, how many per year, let's say for your department, and are they concluded?
I don't have that off the top of my head how many, but I do know we conclude them, and we've not run into this issue.
All right, so who's conducting these investigations?
So I have a captain in charge of internal affairs. He conducts the more serious ones. We also parse them out to supervisory staff to handle other cases.
Thank you. No further questions.
Thank you, sir.
Thank you.
Sure. Thank you, Mr. Chair. Thank you for testifying on today. Can you just repeat for me, who conducted that survey?
I was advised of that. I don't know who conducted it. I was advised of it by the Training Commission.
Oh, the Training Commission made you aware of it. Okay. And then my other question is, and I know it is case by case, but with some of the investigations that occur, has there been a theme of where the process maybe is stifled to get to this point of cases being decided upon or go to the ACC at the last minute? Any particular theme across the state? I know I'm just not talking about your agency.
Opinion, is that okay?
Sure, yes,
So
indeed.
opinion, I think this was a process that is still fairly new, and it's a vast change from the original processes. So I think anything's going to experience growing pains. I think the issues we've seen were the growing pains.
Okay, so nothing that's glaring for you?
No, I don't see anything glaring. No.
Okay, all right. Thank you, Mr. Chair.
Thank you. Delegate Embry.
Thank you. I just want to make sure I understand. Are you disagreeing that the Administrative Charging Committee does need time to consider the materials and make their decision? Or you're just objecting to, it sounds like your testimony is you're objecting to shortening the 1 year and 1 day for investigation. You're not objecting to the Administrative Charging Committee having.
No, we're just objecting to the shortened time period to conduct the investigation. That's all we're objecting to from the Maryland Chiefs and
So this bill would
Sheriffs.
still maintain that, but added some amount of time for the Charging Committee to review the materials. You would not object to that?
I don't think we would
Thank you so much.
be opposed to that. That's why I said earlier we'd be interested. I was trying to track the proposed amendments, but was going a little faster than I can write.
Further questions for this panel? Seeing none, thank you all very much. That concludes the testimony on House Bill 139. And we're going to move on to House Bill 186. 2 people signed up to testify in favor, Delegate Young, of course, and then Ray Kelly. Raymond Kelly, please. He was here a minute ago.
Which bill number?
We're going to hear from the 2 of you. If you'd like to go forward, Delegate Young, then we'll go to 3 people testifying favorable with amendments, then 3 unfavorable, and then 1 person information.
Mr. Chair, can you just clarify, 186, correct?
I'm sorry?
186.
186.
Thank you, Mr. Chair. So, Mr. Chair, members of the committee, Madam Vice Chair, Delegate Young, once again, House Bill 186. Now, I will admit to you, first and foremost, what the goal of the bill is, and then I'm going to tell you the updates literally since I walked into this room. The bill, as drafted, is sought to make sure that we did not have any challenges as it pertains to having enough administrative law judges on the trial boards. You know, again, Baltimore City's got a lot that's coming. The Office of Administrative Hearings already is inundated in a certain way with regard to how many administrative law judges they have and need to do the work. Understanding the tsunami coming their way, this bill sought to expand the qualifications beyond just administrative law judges and to any lawyer who would qualify to be a district court judge in the state of Maryland to be able to also serve as the chief of a trial board. Since walking in this room today, I've had the opportunity to have a really strong conversation with the Office of Administrative Hearings. And from that conversation, here's what I learned, which is that most of these qualifications are the qualifications that they use to hire the administrative law judges that they do have. And that the challenge that I was hoping to solve, we can probably solve if we can get some pens over into that office so they can make additional hires. So I say that to say that, there are those who came down to testify, so I want to make sure, Mr. Chair, that they, have that opportunity. I don't want to, I didn't want to just withdraw and waste their time. So, but that being said, I do think that there may be a different solution that we're going to continue to work on. Do your thing, man.
Okay. Good afternoon again, Ray Kelly. I'm here today to express my strong support for House Bill 186, which aims to alter the composition of trial boards responsible for adjudicating matters of police discipline. As the executive director of the Citizens Policing Project, I believe this legislation will have an immediate and positive impact on the efficiency and effectiveness of the police discipline process in Maryland. One of the most significant benefits of House Bill 186 is the reduction in the amount of time it takes to adjudicate police discipline cases. By allowing qualified attorneys to serve as trial board chairs, the bill leverages an existing pool of legal professionals who are already awaiting appointment for an administrative judge. This immediate access to a list of qualified lawyers ensures that the trial boards can be convened more quickly, thereby addressing the current backlog of cases that have been a persistent issue in our state. The convenience of using these qualified attorneys cannot be overstated. They bring with them a wealth of legal knowledge, integrity, and wisdom, which are essential to the fair and just adjudication. Their involvement will not only expedite the process, but also enhance the credibility and transparency of the trial boards. Maryland is currently facing a tremendous backlog of police discipline cases, and HB 186 offers a practical and immediate solution to begin alleviating this issue. By streamlining the trial board composition and utilizing the expertise of qualified attorneys, we can ensure that cases are handled more efficiently, ultimately leading to a swifter justice and improved public trust in our law enforcement agencies. I urge you to support HB 186 and help us take crucial steps towards a more effective and timely police discipline process. Thank
Questions for the panel? Seeing none, we thank you both very much. We'll go to those people who are favorable with amendments now. Russell Hamill, Sarah Sample, B. Andrew Bright. We'll hear from these three, and then we will switch to those people unfavorable, and then we're going to hear from Debbie Levy again in informational testimony. Ms. Sample, you're the first to sit down. If you'd like to begin, please, for 2 minutes.
Thank you to the chair and the members of the committee for having me. My name is Sarah Sample, here from the Maryland Association of Counties, and we support with amendment House Bill 186. We think that the flexibility this bill offers is a good thing. We have a number of jurisdictions that we're happy to see this bill. The only thing we have in terms of amendments is that we want to make sure that the standard for the individual, the eligible attorney, is just a little bit higher. When we initially were talking with a handful of our attorneys, they were looking at some state documents that were used for recruitment for ALJs, and some of the standards that they had in that document are very different than what is in the bill. And we'll continue to talk with the sponsor about what additional things could be added, but some of the things that our attorneys had suggested was maybe 5 years of civil experience, Also, potentially to address that sort of integrity, wisdom, and knowledge line that's in the bill, maybe something that you have to have a certification that no discipline has been handed down to the attorney from the Maryland Attorney Grievance Commission. And then another suggestion was a certificate of good standing from the Maryland Bar Association. So that was the First Amendment. The second one is we think it probably would be wise to add explicitly that any jurisdictions that currently have their ALJ process that is working and they're happy with it and it's not creating a backlog, that they would be able to continue moving forward with their ALJ process, and this wouldn't preclude them from doing that. But other than that, we just want to make sure that changes that are made do not erode the integrity of this process, and we think these suggestions could help. So we're favorable with amendments on House Bill 186.
Good afternoon. My name is Andrew Bright. I'm the legal advisor for the Washington County Sheriff's Office, and here on behalf of the Maryland Sheriff's Association and Chiefs of Police Association. My clients support, with certain amendments, House Bill 186. We would, on I guess a matter of universal agreement, say that the administrative law judges have done an excellent and balanced job in chairing trial boards in all experience that I'm aware of. However, in the remoter part of the state, Washington County, further out, we're paying ALJs to travel and have accommodations when there are a wealth of experienced attorneys in our county who are more than capable of chairing an administrative hearing and have done so in other areas in zoning, animal control, license commissioners, and the like. And so we do believe that adding this qualification or this possibility for chairing would broaden the pool of potential chairs. So the amendment we would favor would be to make explicit that the trial board could be chaired by either an ALJ, a retired judge, or an attorney meeting those elevated criteria. We do have a concern about the language from the Maryland Constitution concerning an attorney that's most distinguished for integrity, wisdom, and sound legal knowledge. I believe that comes from the Constitution and deals with circuit court judges. We believe that the qualifications for an ALJ make perfect sense when appointing a private attorney to chair the trial board. So with those amendments, the chiefs and sheriffs would support the bill.
Yes, sir. Good afternoon again, Chair Clippinger, Vice Chair Bartlett, in this committee. Russ Hamill again for the Maryland Chiefs and Sheriffs, supporting with amendments House Bill 186. In hearing what the other testimony has been, I could probably cut this to the chase. Beginning at the end of 2023 to the present day, trial boards have been chaired by administrative law judges or a retired judge. We find that they've brought both knowledge and experience presiding over cases to each hearing and have benefited the other board members, the officers, the agencies, and the community. Because these judges may and have chaired trial boards across multiple jurisdictions, they are able to also bring some measure of needed uniformity to the police discipline process as well. We fully support the ALJs staying on board on this. We also agree with a change in the language for an attorney to be appointed, much to the discussion that's been here already. We'd be open. The ALJ definition's fine with us. And for the record, because somebody did ask me this, no, I'm not supporting this because I am a lawyer. I have enough work to do. I will not be trying to do this at this time. So thank you.
Seeing none, thank you very much. Now go to those people in opposition to the legislation. That's Mike Davey, Michael Shire, Bernice Werner. Whoever would like to go first, that would be fine.
I'll go. Go ahead. Ladies first.
Good afternoon, Mr. Chair and Madam Vice Chair. My name is Saida Hamptonell. I am an Executive Administrative Law Judge and the Deputy Director of Operations for the Office of Administrative Hearings. Ms. Werner is our Chief's Executive Assistant, so she signed us up. We did submit written testimony, and when I did come into the room, I did speak with Delegate Young just to express why we were testifying unfavorable. It's been 8 years since we've taken a position on any bill before whether this committee or any other. We oppose this bill because it would remove the Office of Administrative Hearings, administrative law judges from the trial board composition. That is against the state government article 9-1604, which outlines the powers and duties of the chief administrative law judge, noting that he can appoint and remove ALJs, not private attorneys. ALJs, by statute, are special appointments in the State Personnel Management System, or SPMS, and they receive compensation as provided in the state budget. We currently have 52 administrative law judges. We actually just hired 4 more, so that'll be 56, and those 4 will begin on March 19th. We conduct an extensive hiring and interview process. Part of my duties is to serve as the chair of the hiring committee. We review every application. We narrow the initial applicant pool down to a short list. We interview those individuals. In our written testimony, it's very detailed about that interview process. And then those individuals are narrowed down even further to receive an interview with our chief administrative law judge and others. Contrary to the fiscal note, the OAH does not have a shortage of judges available to serve as the chair of the trial board. Since passage of this bill, we have signed 19 MOUs with various law enforcement agencies. We've received 126 cases. 85 have been completed, 62 cases from Prince George's County, and 21 cases from the state police. We look forward to working with the delegate in terms of what he stated, and anyone else who has questions, we are here and happy to answer any questions. Thank you.
Good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting an unfavorable report on House Bill 186. The main passage, or one of the main reasons for the passage of the Police Accountability Act of 2021 was the General Assembly felt that having 3 officers sit on an administrative trial board just may not be fair to the department, that they might always rule in favor of the officer. So the MPAA kind of overcame that when they said the chairman of the board would be either an administrative law judge or a retired judge from the district court or the circuit court. It works. Wasn't sure it was going to, but I've done a number of them now, and it actually works. It's fair. It's an unbiased panel. I know it's hard to believe, Delegate, but I'm admitting it. So I should get credit. So do I get credit for that admission? You got it. So, in all honesty, I've done a number of them now. It's been fair. What we would be concerned about if we got away or added now a lawyer with minimal qualifications to now hear these cases, we would be going back to where we started from. We may or may not have police chiefs, sheriffs, now handpicking attorneys who they want to rule in their favor. And that's kind of what we got away from 3 years ago. We are clearly unfavorable. We're requesting an unfavorable report based on that. The system is working, and there's no reason to change. Thank you.
Good afternoon. I'm Mike Shire. Thank you to the chair, vice chair, and the members of the committee. Representing the Maryland Fraternal Order of Police. I've been a police officer for 21 years, and I'm also a practicing attorney. As Mr. Davey mentioned, we are opposed to this legislation. The ALJs have extensive experience in adjudicating these types of matters, and their experience is building every day as we go through these. They also mentioned, and I think it's important to highlight, the extensive hiring and review practices that the Office of Administrative Hearings goes through, and these are trained and sworn neutrals. Their entire job is to be a neutral third party to ensure that level of fairness. That level of fairness cannot be assured if you're going to be able to bring in any old lawyer, myself included, or the chief, or whoever, as chair of an administrative hearing board. So replacing those trained, detached professional third parties just has too much of a possibility of tainting the neutrality of the system. So we do appreciate Delegate Young seeming to understand that and understanding that the Office of Administrative Hearings is able to build this process. It has been running well. We've seen a number of them now. I do agree with Mr. Davey, shockingly. The FOP is seeing these trials being run professionally, fairly. If somebody could help the chairman over there, we'd appreciate it. We do have a long day today. We don't want him to pass out. So injecting just any lawyer into this process has too much capability to taint the process one way or the other. It could be in favor of the officer or it could be against the officer. And as the FOP always has been, shockingly, we have always been for proper police accountability. We are seeking fair procedures and practices. That has been something that we have maintained through its entirety. So for those reasons, we do oppose this legislation. Thank you.
Question. Vice Chair.
Last two gentlemen, please repeat their testimony, please.
No. Any other questions? Seeing none, thank you all very much. We'll go now to Debbie Levy.
This is Debbie Levy from the Office of the Public Defender. I am equally in shock. I actually thought of the Mike Davey scenario where Mr. Davey might apply to sit on one of these boards. And so we were concerned also and had recommended at least that if there was a lawyer allowed, that the committee would consider that that lawyer have not represented a police department, a police union, or represented a police officer in police misconduct litigation. So I'm not going to waste your time on all the things that have already been said, that this should be fair. More pins for ALJs sounds like a fantastic idea. And on that, we defer.
All right. Any questions about deference? All right. Thank you very much. That concludes the testimony on House Bill 186. We're an hour in and we have two bills done. Great. House Bill 122. Let's see how we're going to do. Delegate Young.
I get y'all once a year.
Virtual. She's in. Jamal Turner. Doris Terrell. Is she here? Doris Terrell. Terrell. She's making her way up. Delegate Young, please go. Whoops. Delegate Young, when you're ready, please go ahead and begin for 2 minutes.
Can you confirm the bill number, please, Mr. Chair?
I'm sorry?
Can you confirm the bill number?
122.
122. Thank you. Okay, so Mr. Chair and to the committee, again, I do want to thank you all. You know, I come to y'all a lot and I try to be as quick as possible. Today, not so much. So I just want to once again appreciate, I know how long y'all are in every single time. House Bill 122, probably the more difficult of the four today as we hit the second half of the show today. This one is two things that I want to talk about. First, the bill as drafted opens up the entire process beyond just members of the public, but for law enforcement officers to also use the process. I certainly expect certain folks to be in opposition. I think that's appropriate. That being said, the impetus of the bill is really what I want to talk about and where I hope the conversation goes to. I submitted the bill to get all of the conversations in, but the goal really comes from concerns that were raised as it pertains to sexual assault and misconduct amongst officers and opening up the opportunity for a separate process in certain circumstances so that way folks can use this separate process as opposed to the internal process when there might be just a general issue of fairness therein, because everybody knows each other, and especially when you get into smaller agencies, it can be very difficult. So again, the bill as drafted is very broad. And I recognize that, and I understand that, you know, it may not be appropriate to pass the bill as broadly as it is, but to engage in the conversation about where is it appropriate to open this up for officer-to-officer interactions, being able to engage with the PAB. So again, the first ones that come to mind is sexual misconduct and assault, et cetera, et cetera. Additionally, when we think about maybe corruption or financial mismanagement, that might be another opportunity where we would want to have that conversation. And so again, this bill today is to bring everybody to the table so we can start having that conversation and see where it might be appropriate, if it's appropriate. And so my panel will talk about where they feel it might be appropriate as well. And I thank you, Mr. Chair and committee, for the time.
Good afternoon again, committee. I'll be brief. Throughout this country's history, we have seen countless instances where police departments have struggled to police themselves effectively. This inability has often led to a lack of accountability and justice, not only for the public, but also for the officers within the force. Officers, like all individuals, are human beings who deserve equal justice and the opportunity to report misconduct without fear of retaliation or bias. House Bill 122 addresses these concerns by allowing police officers to file complaints with an independent police accountability board. This external oversight is essential for fostering a culture of transparency and accountability with law enforcement. It ensures that all complaints, whether from the public or from officers, are taken seriously and investigated thoroughly. Moreover, this bill recognizes the importance of officers who witness or experience misconduct by providing them with a safe and impartial avenue to report such incidents. We uphold the principles of justice and fairness that are fundamental to our society. In conclusion, I urge the committee to support favorable of House Bill 122. This legislation is a vital step towards restoring trust in our law enforcement agencies and ensuring that all individuals, including police officers, receive the justice they deserve. Thank you for your time and commitment.
Okay. Hello, everybody, once again. First off, thank you, Madam Chair, and also Mr. Chair and Madam Chair as well. So I am in strong support of House Bill 122 because accountability in policing cannot be effective if it is not also independent. Right now, if a police officer witnesses or experiences misconduct within their ranks and wants to report it, their only option is to go to the department's Public Integrity Bureau in Baltimore City, which is Internal Affairs, with the same system they work within, the same leadership that they answer to. That is not true accountability. That is not independence. That is not oversight. That is installation. House Bill 122 is about changing that. It gives officers the ability to file misconduct complaints, and I won't bore you all with the same details we just mentioned, but we ask that officers to uphold justice, yet we give them no safe mechanism to report when justice is being violated from within. We should not be asking officers to risk retaliation or their careers just to do the right thing. This is not an anti-police bill. This is a pro-integrity bill. It protects the vast majority of the officers who serve with honor by ensuring that the bad actors in their ranks cannot hide behind a wall of silence. Accountability cannot just be an internal process. It must be independent, transparent, and free from conflicts of interest. That is what HB 122 achieves. I urge you to support this bill, not just because it is the right thing to do, but because it is necessary to build the kind of policing system that our communities, our officers, and our state deserves. Thank you.
Good afternoon to this committee. Special thanks to the chair and the vice chair for allowing me to speak today. My name is Doris Minor Terrell. I'm a member of the Police Accountability Board for Baltimore City. I will be speaking to you based on my experience in hearing the pain from officers who have suffered what I would call inhumane treatment after filing reports. Reports based on personal encounters, reports based on the abuse that they suffered before filing the report, and abuse tolerated after the report was filed, the leaking of personal information, the continuous bullying in the workplace, the failure to protect a complaining officer in the workplace, continuous harassment from supervision in the workplace. Gender specific has been females who come and ask for support. On this accountability board, we have no leverage to offer them anything but a comforting ear. The emotional trauma that these people are suffering as officers of law enforcement to protect us should not be tolerated. They are still human beings. You should not be allowed to suffer just because you spoke up. It is your right to have a voice. Thank you.
Ashley Devon, please, for 2 minutes.
Good afternoon, Chair and members of this committee. My name is Ashley Devon. I'm the Policy and Research Coordinator at Out for Justice. Out for Justice is an organization led by individuals who both directly and indirectly impacted by the criminal justice system. I'm a proud constituent of the 45th District, and I want to thank my delegate for sponsoring this bill. I'm not gonna go back over much, but I will say since the passing of the Maryland Accountability Act, Maryland is safer. However, the dangers of the blue wall of silence are still present. Some officers openly engage in unethical, immoral, and even illegal behavior because they are protected by the unofficial agreement between law enforcement not to challenge each other's misconduct. We must provide officers with every opportunity to change this culture. When misconduct occurs, we must ensure an investigation can be completed with fidelity. This particular bill will do that, so we urge a favorable report on this bill.
Delegate Kaufman.
Yes, this is a question for the sponsor. The chiefs and sheriffs say that your bill undermines the authority of a chief or a sheriff because it impedes on their ability to appropriately manage their departments. Can you tell me why you think they're wrong, and have you seen the letter?
I have the letter. They did provide it to me in advance, and I did speak with their lobbyists in advance as well, and I do appreciate their engagement with me on this and all of the bills. I do understand the concern that they have. Frankly, you know, the chiefs and sheriffs, they have to run their departments, and part of running your department is disciplinary issues and management of that. But again, as I stated previously at the beginning of the hearing, this bill is to initiate the initial conversation about where is it appropriate for us to, from a public policy standpoint, decide that certain issues need to come out from within the police department. Because we have seen in history, whether it's in Baltimore, but not just in Baltimore, but across the state, we've seen instances of discrimination and other circumstances where law enforcement, including the unions, have had to leverage the courts to seek remedy. And so certainly there are circumstances where we don't need to wait, or we don't want to have to make them have to go through all of that. And that's what I'm trying to engage in, is the conversation about where is it appropriate for us to move that out into the Police Accountability Board structure, so that way those concerns that people have in those specific instances that we talked about and we lifted up, and maybe others, so that way those officers can also have an avenue towards justice, and or to make sure that integrity, where it may not be effectuated appropriately within a department, can be done so.
Thank you, Delegate Young. Thank you, Mr. Chair.
Delegate Simmons.
Thank you, Mr. Chair, and thank you, Delegate Young, for bringing the bill. A few of us, not many, but a few of us here on this committee have served as law enforcement officers.
Yes, sir.
From the federal government down. So with that being said, there is protocol in place with just about every law enforcement agency that I'm aware of to handle complaints within a department. There's certain levels that it goes through to resolve that matter. What are you seeing? Is the problem that you're addressing, is it a Baltimore City problem? Is it a Baltimore County problem? Is it the state of Maryland problem? Is it based on what you're seeing from outside of Maryland and you want to prevent it from happening in Maryland? What is the energy behind this legislation?
Well, again, the energy behind this legislation came from what Ms. Doris just talked about, is the Police Accountability Board, in this instance, Baltimore City, having those concerns that were lifted up to them. But again, as I just mentioned about discrimination, I could talk to you about some lawsuits across the state where there has been challenges as it pertains to how officers feel they're being treated by their leadership. And then, of course, there's concerns that we can point to across the state where one officer might have experienced or seen corruption or other misconduct. And when they complain that misconduct, we have had concerns about retaliation in this state as a consequence. So again, this to be a broken record, The goal is to have the conversation about where is it appropriate and when is it appropriate to bring in this additional apparatus that we've heard today is working, right? When is it appropriate for that to also apply to officer encounters if it's appropriate? It's probably not appropriate as drafted for the whole bill for everything. I agree with that. But it is appropriate in certain circumstances, and I'd like for us to talk about and identify that.
Sure. Have you ever yourself done a ride along with police
Absolutely.
officers? All right. Thank you.
Are there further questions? I guess I have one. When this committee dealt with issues related to police accountability in 2021, this was one of the bigger issues that the committee kind of wrestled with. And I still think that the issue is out there today, obviously in the form of this bill. And inevitably, when I ask a question, they drive by. And it's an ambulance, so okay. But I guess the question that pops into my mind is, where is that line between discipline within the police department and misconduct? And how do you go to the question, again, that the chiefs and sheriffs ask? Not quite the question that they ask, but the point that they're making. Where do you draw that line, I guess, between those two? Because I think we found it to be very difficult to determine where misconduct starts and stops, and how would you address that, Delegate?
Excellent question, Mr. Chair, first and foremost, and thank you. I think the way I would address it is where we have a public policy interest in ensuring that the circumstance that is occurring or whatever the issue might be, there's a higher interest in ensuring that there is a separation, or that there's the same non-biased evaluation is where I would draw the line. So, for instance, I mean, I'm just overly basic, of course, but a uniform violation, that never needs to come out. Under this bill, it probably would be available, and I know that's not appropriate, right, as it's drafted. But like I said, sexual assault, discrimination, misconduct of money, and corruption, those things, while should be able to be handled within the police department, we know that it hasn't always been. And so there may be public policy consideration to say that we want an unbiased group, or a group of the ultimate power, which is the civilians, to help us decide what's appropriate moving forward.
To your point, from the very beginning of the bill, you said that this is incredibly broad, and it is, and you could actually foresee in this, or maybe not foresee, but you could have an officer raising an issue with the police commissioner's uniform on filing a complaint if their uniform was not, and that's not your intent, and not the intent of the bill. But I guess its breadth helps to illustrate, I think, the challenges that we find in finding that line where we have existing process with regard to those discrimination and sexual discrimination, sexual assault, and other things. The question is where I guess is that line where it has kind of gotten to the place where there should be an independent group looking at it, as opposed to the criminal sanctions that might be happening, or the existing sanctions within the agency. And now that I've had this little bit of a conversation, I'm going to stop because we're going to be here all night, and I don't see any further questions. Thank you all very much for being here.
Thank you.
And we're going to go ahead and we did the favorable with amendment. That was Mr. Kelly. David Morris, please. Chief Morris. In opposition.
Good afternoon, Mr. Chairman, Vice Chair, members of the committee. David Morris, representing the Maryland Chiefs of Police in opposition to House Bill 122. First, we do want to thank the delegate for having conversation with regards to this bill. And we recognize the sensitive nature of some of these investigations. But most importantly, what this bill neglects to, or what's neglected to understand here, is that this bill passed as it's written would require all complaints to go to the Administrative Charging Committee, regardless of whether they were initiated by a member of the public or internally. I do want to say, sexual assaults are a crime, and they should be investigated as a crime. Discrimination complaints, there's a recourse through the EEOC. But as it relates to this particular bill, I want to give just a general idea of some of the internal types of complaints that would end up resulting going to the Administrative Charging Committee. Absent without leave, giving false statements to a police supervisor during an investigation, mishandling of agency property, tardiness, uniform violations, showing up to work drunk, sleeping on duty, unethical conduct, improper grooming, failure to take appropriate care of agency equipment. All of these are internal matters that need to be addressed in order to maintain good order and discipline by the chief, the sheriff, the commissioner, and the superintendent. As this bill is written, all complaints of any nature would result in going to the Administrative Charging Committee. And as we've seen, the Administrative Charging Committees are already overworked and likely underpaid, and this would only exacerbate the problem. I'll just conclude with this. Senate Bill 178, which was also passed in 2021 at the same time House Bill 670, defined technical infractions as those rule violations that are committed that are administrative in nature, and those particular types of violations as addressed were intended to allow the chiefs and sheriffs to be able to maintain discipline and good order within their department. Thank you.
Thank you, Mr. Chair, and thank you, Chief, for your testimony. Can you give us an idea of approximately how many officers are terminated yearly based on violation of departmental rules?
I can't speak statewide. I'm sure we could get that information through the commission because they track all of those terminations. The commission, every agency that whenever there's a personnel action taken by a police agency, when an officer resigns, is terminated, changes their legal name, that notification has to be made to the commission. So the commission would have the information as to the number of officers that were separated in less than good standing. I have fired one officer in Cheverly since I've been there in 18 months. It took me almost 18 months to terminate that individual officer's employment, in part for many of the issues that we're addressing here today. The previous administration, where I was chief of police, I terminated 3 officers, all of them small agencies, all for misconduct.
When an officer is terminated by a department or the chief for good cause, can that be overturned?
It can be. It can be appealed to the, it can be appealed under the LEOBR, could be appealed to the circuit court. Under the Maryland Police Accountability Act, the officer's rights are to take any administrative action that is either result of an internal discipline, keeping in mind that after the House Bill 670 was passed in 2021, this body came back and amended the bill, amended that statute so that the uniform disciplinary matrix and the administrative hearing board process applies to both internal complaints as well as complaints made by members of the public. So the appeal process is the same regardless of whether it's an internal matter or an external matter, and that would be to an administrative hearing board and then subsequently to the circuit court.
Are you aware of any departments here in the state of Maryland that has been sued by an officer for wrongful termination?
Over the last 40 years, more than I can probably remember. Yes, sir.
Okay, thank you.
Further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 122. Going to House Bill 985, and this is the last of Delegate Young's bills. Only one person said aw. Jamal Turner?
It's the fourth quarter, everybody.
Is Mr. Turner, Jamal Turner? All right, so we'll hear from Delegate Young and Jamal Turner. There are 2 other people who are signed up favorable with amendments. Do you want them to come up as well, or no? We don't have to.
You can just,
sure?
To save
All
your
right.
time. Yeah.
Sarah Sample and Jasmine Riggins. Let's go ahead.
Thank you, Mr. Chair. Fourth quarter, last one. Thank you again to the committee for your patience with me today and for your intent listening and great questions. I always appreciate coming to the Judiciary Committee. This bill, House Bill 985, is very simple. It simply would, under state law, you can only have one charging committee in every jurisdiction. This bill would allow for your city or county council to authorize an additional charging committee. Why? Because they are working their tails off. And what we're hoping to be able to do is allow for those jurisdictions that see it appropriate to have a red team and a blue team, so that way they can just split the work. It's real simple as that. There is concerns that are being raised as it pertains to uniformity of decision-making. I remind everybody that each individual that serves on a charging committee has to be nominated and approved by either your police accountability board or your executive if you're sitting on a charging committee. Those individuals then have to go to a training with the Maryland Police Training and Standards Commission. Those individuals then must follow the uniform disciplinary matrix. And sure, there may be some variation in what they choose in the matrix, but we do have those mechanisms in place to ensure that there's a measure of uniformity, to make sure that everybody is trained, and to make sure that, you know, it's not a whole bunch of egregiousness that's occurring. So it's very simple. I do know that there are those who might want to limit it to just giving giving our counties the ability to only add one. I would be open to that as it sees fit right now. But beyond that, that's just the goal. It's really a matter of workload management and efficiency. Thank you, Mr. Chair.
Okay. So thank you once again, Mr. Chair and Madam Chair. Jamal Turner, once again, Chair, Baltimore City Police Accountability Board. And so right now, every county is limited to just one administrative charging committee to handle every police misconduct case. That might work in smaller jurisdictions, but let me tell you what it looks like in Baltimore City. Our 5-member administrative charging committee is expected to review over 1,000 cases a year on a part-time basis. Think about that. Over 1,000 cases part-time. We're asking a single committee to ensure due process, review evidence, hear testimony, and make critical disciplinary decisions, and all while drowning in an overwhelming caseload. I applaud the outstanding job of ACCs around the state, and I'm looking at the dilemma that they face. This just is inefficient, and it's unfair to everyone involved. It's unfair to officers who have to wait months or even years to wait an extended period of time for their cases to be heard. It's unfair to complainants who are left waiting for justice, and it's unfair to the public who's counting on the system to work transparently, effectively, and efficiently. Let's be clear, this is not about creating unnecessary bureaucracy. It's about making the accountability process actually work. If we're serious about oversight, we want to take this fair, transparent, and efficient. We want a system that is fair, transparent, and efficient. And this House bill does so. I urge you to support this bill for all police accountability boards in Maryland, because justice that takes too long is justice denied. Okay.
All right, thank you to the chair and members of the committee for having me. Again, I'm Sarah Sample here on behalf of the Maryland Association of Counties, and we support with amendments House Bill 985. We think this flexibility would be great. It will help us work through some of the backlogs and try to meet some of the deadlines that are currently in statute. Our amendment is actually something we might already have the authority to do, but we at least want to run it by this committee to make sure that we're all on the same page about that. And it's to do with the standards that both ACCs have. And ultimately, what we would be looking to do is just make sure that the ACC, the additional one, is subject to the same standards and requirements regardless of how often the authorization is employed or the time frame in operation, just to make sure that there's equity, there's continuity, and we have liability protection. We might already have the ability to do that. Thank you.
Thank you, Mr. Chair. Madam Chair, Vice Chair. Yes, so Jasmine Riggins, Baltimore City PAB, Baltimore City ACC. I support this with amendments. I actually think that the way that the law is currently written, it would allow for a second ACC, but I think that that's too restrictive. I actually think that local jurisdictions should have two options, which would be to either expand the current ACC from 5 to 9 members, or create an additional ACC. Also, the bill doesn't actually define the composition of the additional ACC, and as the law is structured currently, it ensures that PAB has more seats than the county executive or the mayor. So it's 5 PAB members and 2 mayoral appointees. And I wanted to propose an amendment that would ensure that the second ACC, if created, would actually follow the same composition criteria as the original ACC. And with that, I urge a favorable report with amendments.
Questions? Very briefly, it strikes me that it's not exactly the same, but in the discussions, again, going back several years ago, delegate to police accountability, there was a comparison with a grand jury and the ACC in particular. And it strikes me that in some counties in the state, they have several grand juries that meet regularly. Isn't that so?
It is so.
Okay. Well, it's an interesting idea. I think that there would be questions about how it would be constituted, and I think there'd be, and so I take your point that there could be questions with that, but I'm listening carefully to the questions when it comes to the points when it comes to at least some jurisdictions having too much work all at once. Delegate Simmons.
Thank you once again, Mr. Chair, and thank the panel once again. Can you tell me what's the difference between the Police Accountability Board and the Internal Affairs Department of the Police Department?
Well, yeah, Internal Affairs in Baltimore City is called Police Integrity Bureau. I mean, that's inside the police department, they investigate the complaints. The Police Accountability Board receives the complaints under HB 670, but they transmit those over to the law enforcement agency for investigation. Beyond that, the investigations go to the charging committee, as we discussed, and the role of the Police Accountability Board is more so oversight, looking at the stats, looking at, some of the things we talked about. When is the timelines, when are the investigations getting to them, high-level stats on adjudication. I mean, if you look at the Baltimore Police Accountability Board report, you can see some of that and some of the other reports around the state. But I hope that answered your question.
Thank you.
Thank you, Mr. Chair. And this is real briefly, but Ms. Sample, have you done an assessment of all the counties in the state, which ones are asking for something similar to this, or have at least expressed the necessity to have this?
So it's mostly going to be our larger jurisdictions, particularly ones are larger, but also have a number of municipality forces. So like Prince George's County is a good example. I think there's somewhere between 25 and 27 where your county ACC is handling the cases for all of those municipality police forces.
So it varies jurisdiction by
jurisdiction? It varies,
jurisdictions?
but mainly our larger ones.
Okay. All right. Thank you.
I would anticipate Baltimore, Montgomery City, Montgomery, and Prince George's are probably the 3 that might do something with this right away.
All right.
Counties?
Our amendments?
Or the bill? Meetings that you have with the representatives from the...
Our legislative committee?
Yes.
Yes. I come here with exactly the marching orders that I've been given by them.
Okay. Thank you.
Thank you all very much. Seeing no further questions, we'll go to the one person testifying in opposition to Chief Morris, please, again.
Thank you, everybody, once again.
2 minutes when he gets there.
Good afternoon, Mr. Chair. Madam Vice Chair Dave Morris, testifying on behalf of the Maryland Chiefs and Sheriffs. You have our written testimony, and the Chiefs and Sheriffs fully recognize the challenges that at least some of the administrative charging committees are encountering with trying to adjudicate these investigations of alleged police misconduct, particularly those involving members of the public. And we also recognize that these challenges are further exacerbated when the misconduct also potentially involves matters of a criminal nature. And we certainly applaud the delegate in this body for trying to address these issues as it relates to both fairness to the officers and to the aggrieved member of the public that's filed the complaint. But we are concerned that introducing multiple ACCs lends itself to subjectivity. The uniform disciplinary matrix that applies applies in all matters of discipline, permits a range of disciplinary action within each of those categories. And our only concern would be ensuring that there is something to avoid the critical flaw that may exist when one ACC renders more draconian decisions than a similar ACC operating out of the same county. So having some sort of an oversight or perspective or view so that those disciplinary decisions from multiple ACCs can be viewed in a light to ensure that there's consistency in those actions would be what we would request.
Daniel Franklin, I'm sorry I missed you. Come on up, sir. Also for 2 minutes. Please go ahead.
Afternoon, Chairman Clippinger, Vice Chair Bartlett, members of the committee. Dan Franklin, Chief of Police, Morningside, Prince George's County. I'm here on behalf of Maryland Chiefs and Sheriffs testifying in opposition to House Bill 985. Just a couple points. I was in on the establishment of the ACC for Caroline County as I was an elected official at the time. I know we were not alone in the struggles with establishing our initial ACC. It took us a lot of time and a lot of people, a lot of interviews. I suggest that a second ACC would probably involve much of the same that a lot of counties just don't have the time, money, and will to do. Another point is kind of keying on what Chief Morris said. Different ACCs may create some disparity in decisions. Understanding each one would be independent. However, if you have an officer in front of an ACC and an officer in front of the second ACC on the same charges, same severity, and different decisions are rendered, you certainly would create some fodder for appeals there, I would imagine. Number 3 thing that I would like to say is all of the ACCs in the state of Maryland, per the Training and Standards Commission survey, save for one, are not having trouble meeting their timelines from what we were told. That being said, blanket action for an acute issue generally does not work out well. You're kind of providing a solution for a problem that doesn't exist everywhere. And there's absolutely no questioning or no disrespect meant to the jurisdiction that is having issues, but I just don't think this is the solution to addressing one issue as opposed to however many other ones we have. With this, I ask for an unfavorable report, and I thank you all for your time.
Are there questions for the panel? Delegate Cardin.
Thank you all very much. I share some concerns about inconsistency. However, we have district courts all over the state with different judges that may have very similar fact patterns and have different responses. Should we be deciding whether to not increase efficiency based on the fact that we're worried about inconsistency when it's just human nature? That would be question number 1. That's like the negative question. Question number 2, which is more of a positive question for you, is if we tried to limit the number of types of procedures to, like, we get rid of, say, traffic accidents that didn't cause any major injuries or damages, or other types of discourteous behavior that wouldn't render to a certain threshold, wouldn't you be able to reduce the workload?
So, Delegate, thank you for both those questions. I'll answer them in order. You know, as it relates to our judiciary, I have a great deal of respect for them, and I know that our judges look at a very high bar, civil cases notwithstanding, but proof beyond a reasonable doubt. And when it comes to sentencing, they have certain sentencing guidelines, and I would be naive to suggest that different parts of the state may impose sentences differently from one standard to the other. What we're talking about is administrative charging committees within the same jurisdiction that may render disparate treatment. And to Chief Franklin's point, particularly if two officers are involved in the same incident and reviewed by different ACCs. We just want to make sure that whatever moves forward, that there's a process to ensure that consistency so that there's no disparity and subsequently minimize or mitigate the likelihood of appeals on either side. As it relates to your second question, I'm going to have to ask you to repeat it just briefly.
I was just wondering if we could figure out a way to take away some of the less serious types of charges or concerns, and maybe that would reduce the level and just focus on the ones that really interact with the general public in a way that really has negative impacts.
Again, Delegate, I think it's an excellent example and idea, and we'd certainly, the Maryland Chiefs and Sheriffs would certainly welcome that. We don't believe that it was the intent of the General Assembly to have ACCs reviewing departmental accident investigations and things of that nature, very minor in nature, that by nature of the involvement of a member of the public falls to the ACC. We do believe that the intent was to look at those more egregious types of circumstances to ensure a fair and equitable outcome for all parties involved. So we do believe that there would be a number of those.
Maybe future legislation.
I'm sorry?
Maybe some future legislation.
Well, I had that written down as a future prospect, but I'll leave that to you, sir.
Further questions for the panel? Seeing none, thank you very much. That concludes the testimony for House Bill 985. Committee, we are approaching that time in session, unfortunately, when we have lots of people who are here, but we also have bills that have come back and they're reintroduced in the same posture or an extremely similar position that they were in previous years. House Bill 255 is the first of several bills like that. I'm going to ask the sponsor of the bill to speak for 2 minutes and ask for those people here today who are witnesses on the bill to speak for a minute, and then we'll take questions after that as we've heard these bills in the past and their reintroductions. So Delegate Acevedo, please. Benita Taylor is here. She is here. Lauren Nickerson, please. Come on up. All right. Delegate Acevedo, please, for 2 minutes.
Thank you, Mr. Chair, members of the committee. For the record, Delegate Acevedo here, testifying or presenting House Bill 255 that would essentially end no-knock warrants in the state of Maryland and basically bring us in alignment with 13 other states that have ended this practice, this dangerous practice that has its roots in the war on drug period that we are still essentially implementing today, with no statistical data that really supports its effectiveness whatsoever. And we can look at multiple cases. I think there are a number of arguments to be made about no-knock warrants from the civilian standpoint, ensuring that we're protecting civilians. We've seen a number of cases across the country where folks have died as a result of the execution of a no-knock warrant or botched no-knock warrant. And we have seen instances across the country where law enforcement are essentially put in harm's way because they are the ones who are executing this no-knock warrant. But regardless of how we look at it or however you want to argue it, this is about public safety, maintaining safety for civilians as well as law enforcement, but also ending a practice, as I said earlier, that data doesn't really support as being effective. Our law enforcement agencies have at their availability technology and a number of ways to ensure that we're accomplishing a goal without putting law enforcement and civilians in a standoff and continuing a practice that we've seen, whether it's in Kentucky or more recently in Minnesota and a number of other states have put civilians at risk. And so My hope is that we would join other states in ending this practice, and I would ask for a favorable report on House Bill 255. Thank you.
1 minute. Good afternoon, Chairman Clippinger and the panel. The public defender is in favor of this bill. This gives Maryland an opportunity to be proactive instead of reaction. We don't want to wait till something happens. When I did a Google search, I found out that the last incident that we had was in 2018. We had 2 incidents in 2018 where one, the same number, different street in an apartment complex, where a woman and her 1-year-old baby were awakened and disturbed. The other one was, I think we all are aware of, in Berlin Heights, where the mayor at the time, his 2 Labradors were killed with someone serving a no-knock warrant at the wrong place. We don't want that to happen in Maryland. We don't need a Breonna Taylor in the state of Maryland. But more importantly, I think we should be proactive because we now have the issues with ICE serving warrants in Maryland. And we have households who don't know who it is at the door. Is it ICE? Is it a local police? Exactly who is it? So we need people to announce who they are and their purpose when they come to serve a warrant.
Good afternoon. My name is Lauren. I'm with Social Work Advocates for Social Change. Thank you, Chair, Vice Chair, and members of the committee for hearing us today. No-knock warrants have a very limited lack of data regarding who is subjected to their use. The data that we do have available shows that there's a disparate impact on minority communities. The primary offense of the warrant, any resistance to the warrant, and any demographic information on the people who were subjected to the warrant is not currently part of the reports that are given out by our law enforcement agencies. However, in 2023, the Office of Legislative Oversight for the Montgomery County Police Department, they issued the report in 2024. It was for 2023. And 53 people in Montgomery County were subjected to those warrants. There were 9 total. Of those, only 1 person was white. There were also 14 people under the age of 18. We urge a favorable report. Thank you.
Questions for the panel? Seeing none, thank you very much. That concludes the favorable testimony. 1 person in opposition, that's Mr. Schellenberger. He will have a minute.
A whole minute?
Yes.
Thank you, Mr. Chairman and members of the committee. Please, please, please read my written response. Back when the Breonna Taylor case happened, this legislature acted very proactively in drafting Criminal Procedure 1203. 1203 has the requirements that this legislature worked on to make sure that no knocks were being done right. Number 1, officers, direct supervisor must sign off on it. Number 2, I have to sign off on it. That means to get a no-knock warrant, there is political accountability. The elected state's attorney in each state each county must sign off on it. I have an iPad back there right now that I could sign a no-knock warrant if necessary. More importantly, we have to have a description of the evidence. We have to say why it needs to be done. We have to explain why you can't detain the suspect. This is one of the most complete bills that we had ever passed. We all worked on it very hard. I think we have enough protections here, and we need an important protection for police safety.
Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 255. We'll go now to House Bill 1435. Delegate, it's your bill. You are the sole witness, and you get 2 minutes. It's a reintroduction.
Whole 2 minutes.
Whole
Wonderful.
2 minutes.
So this bill essentially addresses an issue that we've been hearing from a number of community members, and particularly, I think, given a recent report from the U.S. Congress about white nationalism. It was an FBI assessment, rather, about white nationalism in law enforcement. That assessment essentially showed that white nationalism is not only present in law enforcement across the United States, but it has serious implications for policing, trust in law enforcement, and how law enforcement are viewed, seen, and received in various communities, not just communities of color, Jewish communities, indigenous, et cetera. And so what the bill essentially is hoping to address is to ensure that law enforcement officers, the people who are charged with not just trust from the public, the right to bear, the folks who have a license to kill and also carry weapons, that these folks aren't affiliated with or a part of organizations that are identified as white nationalist organizations by the FBI and other and other groups as well. And so I think whether it's January 6th, 2021, whether it's the instances that we hear countless times on news of law enforcement officers who are members of white nationalist organizations, it is clear whether it's police chiefs, managers, those who are administrators of agencies, this is not an issue that is being addressed, taken up, or discussed. And therefore, it's incumbent upon us as legislators to ensure that we're providing the mechanism to ensure that the people who we're charging with the responsibility of patrolling and policing our communities are not involved, are not in league with, are not members of, aren't sympathetic to white nationalism or part of white nationalist organizations. Prefer that we become proactive on this issue rather than waiting for an instance of police violence and the kind of information that could potentially come out from that about the issue of white nationalism. And so I hope that this committee would not just move the bill, but ask for a favorable report. Thank you.
Thank you very much, Delegate. Are there questions for the delegate? Seeing none, we thank you very much, and that concludes the testimony for House Bill 1435. Thank you very much. We're going to go to Delegate Davis, who is not here. She's on her way. Hornberger. All right, stop it. Stop it. She on her way? Delegate Davis's bill is a reintroduction. It'll be 2 minutes and one, and we're gonna get at least her first panel loaded in. Is Marguerite Morris virtual? Is she there? No? Natalie Novak? No? Nicole Chang? Yes. All right. Joshua Harris? Yes. Erica Hamlet? No. All right. If I could have at the table, Yannette Emanuel, Nikki Owens, Beverly John, Davon Love, and I understand if we've called out some names virtually and they appear, we're going to add them in. But at this point, I'm sorry, Natalie has come on in. All right, we're trying to give Delegate Davis the opportunity to get here. I called Beverly John, Yannette Emanuel, Nikki Owens. What's your name?
Nikki is not able to make it, but we have a couple people virtual.
Okay.
And Mr. Love should be here shortly.
Davon Love?
Yeah, he's coming from another committee. He'll be here shortly.
Okay. Jamal Turner, I know you're still here. See you in the back. All right, Delegate Davis is coming in. This bill is a reintroduction of a bill from the previous session. As such, the sponsor is going to get 2 minutes and everybody else is going to get 1. So I'll give Delegate Davis a couple more seconds to take your time. You're fine.
Thank you.
And to breathe before you, because you just had to get here. But Delegate Davis, when you're ready for 2 minutes, please.
Chair Clippinger, Vice Chair Bartlett, and committee members on Judiciary, my colleagues. I am Delegate Deborah Davis from District 28 in Charles County. I'm here to present HB 836. It reads, County Police Accountability Boards investigation of complaints of police misconduct. I know it's Police Accountability Board Day. HB 8336 would clarify that the local governing bodies have the authority to empower their own police accountability boards to hire investigators and conduct independent investigations into complaints of police misconduct. This bill represents a critical step toward increasing transparency, restoring public trust, and ensuring accountability in law enforcement across Maryland that we envisioned when we first passed the comprehensive police reform in 2021. You will hear from people on the ground who are actually doing the work, who believe that this bill needs to go forward. Lastly, you will hear that the opponents to the bill claim passage of the bill will create a situation where double jeopardy would apply. I assure you, double jeopardy does not apply in these administrative cases. For these reasons, I urge a favorable report. Thank you.
Good afternoon. For the record, my name is Yanetta Emanuel, Public Policy Director for the ACLU of Maryland, here to urge a favorable report on HB 836. I'm going to focus my remarks on addressing the opposition. First, giving PABs investigatory authority is not inconsistent with police agencies also having that authority, nor will it unequal the playing field. The Baltimore City Civilian Review Board and the Prince George's County Complaint Oversight Panel have had similar powers for decades. The independent investigations performed by the CRB staff have proven just how critical it is to have the option of conducting independent civilian-led investigations into complaints. Beyond the increased trust and cooperation complainants show with the CRB investigators, the CRB and the Public Integrity Bureau disagreed in 26% of concurrent investigations in 2017. Second, giving PABs investigatory authority would not undermine the uniform disciplinary process that HB 670 sought to create. It simply changes the identity of the people engaged in one of the tasks that are part of the disciplinary process. Taking the position that only police can investigate the police would treat the repeal of Lear Board as utterly meaningless. For the foregoing reasons, the ACLU of Maryland and MCJPA urge a favorable report on HB 836. Thank you.
Good afternoon, Chair Clippinger and Vice Chair Bartlett. My name is Beverly John, and I'm a member of the Prince George's County Coalition for Police Accountability. I'm here to discuss why this is important. In 2020, Prince George's County Police Department was sued by the Black and Hispanic Law Enforcement Associations for race discrimination and retaliation. And as part of this lawsuit, an evaluation and an expert report of the department's policies, practices, and customs was made by an expert on police practices, Michael Graham. In this report, he found that there were failures of senior commanders to address officers who engaged in repeated use of force, some officers with 10, 20, and 30 complaints in their jackets. Senior staff interceded on behalf of white officers accused of abusive, racist, or discriminatory conduct, and that senior commanders ignored complaints made by the former CCOP. This is why this legislation is important. We need independent investigatory powers. Thank you.
All right. Thanks again, Mr. Chair and Madam Vice Chair. I'm joined virtually here also with my Vice Chair of the Baltimore City Police Accountability Board, Joshua Harris, and other members as well of the Baltimore City Police Accountability Board. So just to keep it succinct, so right now, as we know, PAB serve as the oversight body for police misconduct, yet we are denied the most fundamental tools to do our job effectively. Through our ACCs, we're tasked with reviewing complaints, but we cannot independently investigate them, and we are responsible for ensuring justice, yet we do not have the subpoena power to compel evidence, documents, or testimony when critical information is needed. So without independent investigatory powers, PABs are left waiting for information from law enforcement agencies, et cetera. And so this bill is not, as I mentioned before, an anti-police bill. This is about being pro-accountability. Good officers, those who serve with integrity, should welcome independent investigations because it protects their professionalism. I urge you to support this House bill.
Good afternoon, Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. There has been progress that has been made in the Maryland General Assembly on the issue of police accountability in expanding the ability for non-law enforcement civilians to participate in the internal process of discipline of law enforcement. the clarifying the ability for local jurisdictions to give the Police Accountability Board independent investigatory power, it diffuses more power away from the leadership within law enforcement that ultimately controls the nature of the investigations and provides a community-facing body more of that information. Previous testimony has talked about why that will be important in terms of aiding the formal proceedings in terms of police misconduct. But I want to raise to the committee, there's an important advocacy role for the Police Accountability Board and having an independent investigatory power where that board that has more of an advocacy role has its own ability to investigate, provides it the tools that it needs to make the case to folks within the community, additional policies that may need to supplement the existing process that this body changed in 2021. Thank you.
Thank you all very much. We'll take questions for this panel first, and then I'll go to the people who are on virtually. Are there questions for this panel? The Vice Chair.
My question is for Mr. Love. I couldn't tell if you finished what you were going to say. Did you finish your statement? Okay. Okay, thank you.
Anyone who was making a statement based on something you had in writing, if you didn't complete it all the way through, you can still submit it to the committee and we'll add it to the record. Delegate Taylor.
Thank you, Mr. Chair. It doesn't matter who answers this question, but have any one of you seen an example where if the PAB had this authority, do you have an example where if they had that authority, that things would have been different, the outcome would have been different?
You can take a stab at that. If we look at all of the majority of the police misconduct cases that we've seen in the previous years, I'll give you one example in Prince George's County, which is the case of William Green.
Can you speak up?
Yeah, sorry. I'll give you one example. There's a case of William Green who was shot and killed in January of 2020. The officer involved in his case had a history of misconduct that was not adequately investigated or held accountable for, including a shooting in 2011, another shooting in 2013. The one in 2013 actually resulted in a death, choking a woman while she was handcuffed in the backseat of a police cruiser, falsifying complaints and charges against people and then not showing up to court afterwards. There was countless misconduct that had there been a process where there was somebody actually adequately investigating complaints made by the community, that person wouldn't have been on the, hopefully wouldn't have been on the force and been on there in January to kill Mr. Green. That's just one of thousands of examples.
Thank you.
If I can just add briefly, one of the things, particularly in the work we did in changing the Maryland Public Information Act in terms of investigatory records of law enforcement, the disciplinary records, is the issue of misclassification in terms of the nature of what a particular thing that an officer was accused of. And so the ability to have independent investigatory power circumvents the ability for a police chief or administration to be able to use or communicate with Police Integrity Bureau in the context of Baltimore City or other internal affairs. It would provide information that otherwise wouldn't be accessible because the administration, again, is able to classify. And again, that was part of an issue that we dealt with on another aspect of the legislation I think is important to your question.
Yeah, thank you.
Thank you very much. That concludes the questions for this panel. We'll go to the people who are on virtually, including Marguerite Morris. I see Marguerite Morris. So let's start with Ms. Morris, and then I'll make my way around the rest of the virtual testifiers, and then we'll go from there. Thank you. Ms. Morris, please, for 1 minute.
This is Reverend Marguerite Morris. The current police chief here in Anne Arundel County won't speak to me over citizen issues. Why? Because in our last meeting, in one video of one incident, 2 different officers giving reports of that video gave reports that neither report agreed with the video. I'm also reminded that recently in another case, our local chief said that she stood by the actions of her officers because they had followed protocol in a high-speed chase that resulted in the death of an individual. These officers falsified reports as well. The chief stood by them, stating they followed protocol. Attorney General Anthony Brown stated publicly that he did not agree with the chief of police, the police's assessment, and that there would be an investigation. That investigation resulted in those officers being charged. We cannot continue to allow the investigation of self and must continue empowering PABs to do independent investigations. Please don't insult our intelligence by stating that all police do a good job. That depends on the certain officers and if they're motivated to do so. As always, this is not anti-police. This is anti-bad police, and we urge you to support, because I'm testifying in favor of HB 836. Thank you very much.
Thank you very much. Nicole Chang, with the understanding that you are not actually operating a motor vehicle.
Not at all, sir.
Thank you very much. For 1 minute, please.
Good afternoon, Chair, Vice Chair, members of the community. My name is Nicole Chang, and I serve as the Vice President of the Baltimore City Branch NAACP and the Criminal Justice Chair for the NAACP Maryland State Conference. I am here today to express our strong support for HB 0836. The Maryland Police Accountability was a step forward, but without clear authority for the police accountability boards to conduct independent investigations and issue subpoenas, true oversight is impossible. Right now, PABs must rely on internal police investigations, something history has shown is deeply flawed. The DOJ's 2016 investigation into the Baltimore Police Department found widespread failures in handling misconduct complaints, and similar patterns persist across the state. With the Baltimore Civilian Review Board being phased out, we are at risk of losing independent oversight entirely. If we want real accountability and public trust, PABs must have the power to investigate misconduct themselves. HB 0836 is common sense, and we urge you to support it. Thank you.
Thank you very much. Natalie Novak, please.
Hi. Good afternoon. Natalie Novak, Chair of the Baltimore City Civilian Review Board, and I've been on the board for 5 years. I am in favor of this proposed legislation. The CRB used to be only one of 2 entities that conducted independent investigations of police misconduct. However, like the other entity, the Baltimore City CRB has been recently sunsetted. As of January 1st, 2025, the board can no longer accept any new complaints. After we complete our open cases, we will be closed. Thus, the last remaining non-police entity conducting independent investigations has been ended. Therefore, this bill is badly needed at this time. I will highlight one reason why independent investigations are integral to police accountability, which is that they are free from the inherent bias, which may be ever so slight, but the inherent bias that exists in BPD's internal investigations. One way this bias shows up is the numerous times that BPD and CRB have come to opposite conclusions based on the same evidence. So based on the exact same evidence, BPD found that the complaint was not sustained and CRB voted to sustain the complaint overwhelmingly. And these are some of the most serious allegations you can imagine. And those officers were not held accountable and were put back on the street. Thank you very much.
Thank you very much. Again, if you're reading a written statement and you weren't able to completely finish and want to submit that to the committee, again, going to everyone, you're more than welcome to do that. We'll go to Joshua Harris, please, for a minute.
Good afternoon, Mr. Chair, Vice Chair. I'm Joshua Harris, the inaugural chair of the Baltimore City Police Accountability Board and the current vice chair. And this bill would strengthen civilian oversight of law enforcement. Maryland has taken some very important steps to improve police accountability and rebuild public trust. However, without independent investigative authority, police accountability lacks the necessary tools to provide meaningful oversight. Across the country, jurisdictions that have implemented strong civilian oversight mechanisms, including independent investigative authority, have seen improvements in mechanisms, including improvements in transparency, public trust, as well as police community relations. Cities like New York, Chicago, and San Francisco have empowered their oversight bodies with investigative powers, and the National Association of Civilian Oversight of Law Enforcement recommends this as a best practice. And so passing this will put us in position to be a leader in the nation and align with best practices. So it will give us the ability to gather our civilian oversight bodies, to gather evidence and interview witnesses independently, conduct thorough impartial investigations, and hold law enforcement agencies accountable for misconduct. Thank you.
Thank you very much. Questions for this panel? Seeing none. Thank you all very much. Just one last time, Nikki Owens, Erica Hamlet. Nope.
Erica should be on Zoom.
We do not have her. No? I'm sorry. We have one person testifying favorable with amendments. Jesmond Riggins, please. Mr. Riggins, please, for a minute.
All right. Thank you, Mr. Chair. Excuse me, Madam Vice Chair. Yeah, so I
support this bill, but I think that there is an amendment that I think would actually be helpful when it comes to Baltimore City actually having a discussion about this, which is that currently the bill allows for concurrent investigations. I actually think that the bill should be amended to either remove concurrent or to add exclusive, which means that the city can have a conversation about whether or not PAB can either conduct a concurrent investigation or it would be the lead investigator when it comes to complaints submitted by members of the public or an incident involving a member of the public. So with that, I urge a favorable report with amendment.
Questions for this one witness? Seeing none, thank you very much. We'll go now to those people in opposition. Mike Davey, Michael Shire, Clyde Boatwright, please. Each will get 1 minute. We'll give them an opportunity to come up. Whoever would like to go first for a minute.
Go ahead. All right. Thank you, Mr. Chair, members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police. When talking about police reform, we just had this discussion over in the Senate, and I'm going to echo my same testimony that I had over there, and some of you may appreciate this. I'm going to take a line from the great songwriters, the Osley Brothers. Here we go again. We're back at it again. Police reform, let's give it some time to work. We heard from Mike Davey that it's working as far as fairness. In football, you know, you throw a red challenge flag and then the referee has to go over and look at a screen and take a look at the play all over again. That's what this bill is intended to do, to say that the investigation was not done in the way that we wanted to see it, so let's take a look at it again. So at this point, under House Bill 670, you have the ability to send it back for further investigation. So we say, let's continue to use what we have in place and let's see the fruits of this bill. Thank you.
Thank you. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police. We're requesting an unfavorable report on House Bill 836. The FOP believes that this bill is not necessary as the Police Accountability Act already grants investigative authority to the police accountability boards through their self-appointed administrative charging committees. If passed, the complaint involving a member of the public would now have multiple investigations. If it's criminal related, it would be done by the agency's criminal investigation division. If it involves death or bodily injury, the AG's office would investigate it. If it's just a regular complaint, it would be handled by the agency's internal affairs. Right now, the Administrative Charging Committee has the authority to review all the body-worn camera footage, call officers to appear before them, request additional information, require additional investigative steps, and issue subpoenas. What is going to happen when we get multiple decisions and different decisions by each jurisdiction? The only person that's going to win is the officer, and that's not what our goal is. It's to be fair.
Good afternoon again. Mike Shire on behalf of the Maryland Fraternal Order of Police in opposition. As Mr. Davies said, you have ACCs that are beholden to and subordinate to the police accountability boards. They're doing investigations as it stands now, and the MPA entrusts them to do so. Their oversight is the PAB. When you get multiple investigations going on that are parallel, you're going to have contradictory results. That's why traditionally we've had criminal investigations. When they're ongoing, you pause the administrative investigation. We have another bill to hopefully address that as well. So they don't interfere with each other and they don't ruin each other. Despite being as framed as anti-accountability, the FOP is and has always been and will continue to be in favor of efficient accountability, and this bill serves only to weaken the accountability in law enforcement, because as Mr. Davies said, when you have contradictory results, all we have to do is put those on in front of a trial board and you've got enough seeds of doubt to exonerate an officer. It makes no sense. You have the ability for the ACCs to do exactly what the advocates are asking for here. Let them do it. Thank you.
Questions for the panel? Seeing none, we thank you very much, and that concludes the testimony for House Bill 836. House Bill 885, well, in concept has been introduced in the past and is significantly different than other bills. 3 minutes for the sponsor, Delegate Hornberger. We'll hear from Mike Davey, Michael Shire, John Bartlett, Clyde Boatwright, and Veronica Bruns, and we'll take up all 6 seats.
For the sake of time, should I bring up the panel now?
I'm sorry?
For the sake of time, should I bring up the panel
Yeah, no,
now?
I'm asking them to come on up now. If I called your name, you need to come on up.
Great, okay, go ahead
Michael
and get
Davey,
started
Mike
as
Shire, John Bartlett, Veronica Bruns, and Clyde Boatwright.
Excellent. Thank you, Mr. Chair. For the record, Delegate Hornberger here on House Bill 885, Public Safety, Police Accountability, Investigation Records Relating to Unfounded and Exonerated Complaints. So we've now had a few years of implementation of the Police Accountability Board. This bill seeks to make a very minor change to improve this process. I want to be very clear. This bill only deals with expungement for exonerated and unfounded complaints, okay? This does not include unsustained complaints where, for example, there may be insufficient evidence. However, it's decided that some infraction has occurred. So want to have a line in the sand there about what this covers and what it doesn't. How did we arrive at 3 years, okay? Well, first off, if we look at citizenry, they're in a similar timetable when it comes to expungement, 3 years without incident. Okay, there's been many concerns, and I know this was debated when the bill was originally passed, about patterns. And our argument is that at the 3-year mark, and in many instances we're talking about a 20-year career, at the 3-year mark, a pattern is going to establish itself. And if that is the case, then a 3-year look back is far enough to say that, yes, this should be removed from the person's record. Next point I want to make, and this goes to Giglio material. One of the unfortunate outcomes of this is that we now have state's attorneys who are pursuing cases where, because of the Giglio material requirements, they have to disclose, this is discoverable, exonerated and unfounded complaints, and it's negatively impacting their ability to prosecute the perpetrators. Next up, we have personnel records. So if you're looking at 2 different officers for a promotion, one has exonerated or unfounded complaints, one has a clean record, it's not a leap here to say that one is going to get chosen more often than not over the other, even though there is no compelling evidence that that person did an infraction. Lastly, I want to close with what I feel is ultimately a due process violation. Whereas no other citizen in our state would be held to this level, whereas they have these unfounded and exonerated complaints following them around, impacting their ability to matriculate through the police force or transfer, and then also impacting negatively their ability to prosecute cases and do their jobs. So with that, again, we have a number of folks here to testify on the bill. We're asking for a favorable report and would love to take any questions. Thank you.
Good afternoon. My name is John Bartlett, and I'm a citizen of Caroline County. I'm a lifetime resident of the state of Maryland. I had the honor to be selected by my commissioners to be the chairman of both the ACC and the PAB in Caroline County. Part of this job, I would tell you, each and every member on these boards take their job very seriously. They look at all the body cameras, they review all the evidences, and they take their job very serious for doing that. But what we have learned, not all people tell the truth. And there's been accusations against law enforcement officers that our board has seen that are flat out untrue, such as the officer headbutted me. Every body camera for every officer was reviewed, and that incident never happened. We have made tough decisions. We have taken leave. We have sent reprimands, and we have someone going to trial boards. So we're not a pushover to anybody. But what realized is the ACC, as my job as the PAB rep on the ACC, chairman of the PAB, we took this to our board. The documentation was put into our end of the year report that the PAB for Caroline County adamantly supports the expungement of law enforcement officers' files based on unfounded and non-sustained or exonerated complaints.
Michael Davey, General Counsel to the Maryland State Fraternal Order of Police. We're requesting a favorable report on House Bill 885. The ability to expunge personnel records as a police officer went away back in 2021. A lot of things have changed since then. The passage of this bill would allow a law enforcement officer to have internal complaints and investigations expunged when the complaint results in a finding of unfounded or exonerated. The most important part is by an administrative charging committee or a trial board. Those are two independent reviews basically by civilians. They will look at the facts, make a determination whether the case has any merit, and if they determine through the administrative charging committee that there's nothing there, the officer didn't do anything wrong, there's no violation of a policy, the officer should have the ability to have it expunged. Same as if going to an administrative trial board where you have an administrative law judge or a retired judge, a citizen, and a police officer. If the trial board determines that they're found not guilty, that should also be expunged. The important part is the transparency and the independence of that review by either the administrative charging committee or a trial board. There's continued transparency throughout this process. There's civilian oversight. A false and unproven allegation of police misconduct, unfortunately, they happen every day. Many of these allegations are very serious and detrimental to the careers of these officers. Many of these issues are completely disproven, either by other witnesses, body-worn camera. However, they'll stay in their personnel files forever. If a citizen is charged with a crime and found not guilty or even receives a probation before judgment, they have the opportunity to have those records expunged. Police officers should not be treated any differently. Thank you.
Good afternoon, Chair and Vice Chair. I am Veronica Bruns, the Treasurer of the State Law Enforcement Officers Labor Alliance, which is the exclusive representative for approximately 1,700 officers and troopers within the state of Maryland. I'm also a corporal in one of those represented agencies and a member of FOP 130, the Department of Natural Resource Central Lodge. SLEO believes that it is imperative that we maintain a procedure that holds an accountability and fairness in how law enforcement officers who serve and protect our communities are treated. Law enforcement officers throughout their careers shall be held to the highest standards, but should not be unjustly hindered or by complaints that have been thoroughly investigated and deemed to have merit. HB 885 will ensure that law enforcement officers who have been exonerated or cleared of misconduct allegations maintain a protection on their reputation as well as their professional careers. It will hold that our record of allegation where the officer is found not to be at fault will never continue to impact their career indefinitely. The proposed 3-year time frame provides a reasonable balance between ensuring a thorough investigation, allowing for the restoration of an officer's good standing after a complaint is deemed unfounded or exonerated. It will also help to restore public trust in police accountability, the discipline process. It should ensure an officer's record reflects only relevant and substantiated complaints. This will allow for the public to have more confidence in the officer being held accountable for legitimate and substantiated complaints and findings. While doing this, it upholds that officers are still afforded their right to fair treatment and due process. This will help to foster morale as well as assist with recruitment and retention, which we all know is so needed in law enforcement currently. For this reason, the State Law Enforcement Officers Labor Alliance would like to ask a favorable vote on this amendment, and would like to thank the sponsor for this.
Good afternoon again. Mike Shire, representing the Maryland Fraternal Order of Police, here today speaking on behalf of House Bill 885. I've served as a police officer in Maryland for 21 years. I've done so proudly, and I've worked hard my entire career. That means that I have gotten false complaints against me, as any other hardworking police officer does during our time as law enforcement officers in this agency. Surprisingly, not everybody we meet wants to be our friend, and some people are pretty upset with having to get arrested, and they will make false complaints against us. We serve under intense scrutiny and pressure. We're tasked with upholding the law, often in challenging and unpredictable situations. And every time a complaint is lodged against us, it hurts us, especially when they're false accusations, particularly when they're false accusations that are later determined to be false. They can unfairly tarnish our records and our reputation, even if we have been cleared of all wrongdoing. My chief always tells all of our new recruits and our officers to never take away anybody's dignity, yet we have these things hanging around our neck, these false complaints for our entire career that can be many, many years. By leaving these unfounded and exonerated complaints on officers' record, you're discouraging them from doing work because you're saying that, well, even if you have a false complaint, that's going to stick with you for the rest of their career. Do not discount for a second the additional stress placed on officers when they're notified by such a complaint. It's not a small issue, even if the officer knows that they did nothing wrong. This is just an issue of fairness. Just as we protect the rights of individuals who may be falsely accused of crimes, we have to extend these same considerations to officers who are legitimately exonerated after false complaints have been filed. Holding on to these records, despite a clear dismissal exoneration of the complaint, can impact their future in a way that's not aligned with our core values of justice and due process. The integrity of the law enforcement system relies on transparency, fairness, and trust. And if an officer is cleared of these accusations, they should be expunged to help with morale, foster trust, and make sure that police officers are treated with dignity and respect. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Bovray for the record, President of the Maryland State Fraternal Order of Police, representing approximately 21,000 police officers statewide. And in the interest of time, I'm just going to say me too.
Everyone could listen to. Delegate Schmidt, please.
Thank you, Chair. Thank you all. Thank you, Delegate, for bringing the bill. 2 quick questions. How does this compare to other states, and how many of the findings are unfounded, I guess, or how many of the complaints, basically?
I'm not sure how it compares to other states, but from my experience, and I do a vast amount of the defense work for police officers in the state of Maryland, I would probably say that 70 to 80% of the complaints are non-sustained, unfounded.
And do you know, do other states have a 3-year threshold, 1-year threshold?
I don't know the difference. I think I know a lot of states do have an expungement process, as we used to, but whether it's 1 year or 3, I think we agreed that 3-year was fair based on the opportunity for lawsuits, things of that nature to come.
Gotcha. Okay. Thank you.
Thank you, Chair. Is the exoneration automatic after 3 years, or is there a process and procedure written into this somewhere?
I think the way this bill is written, it would be automatic. It used to be different agencies would handle it differently under the old system. The expungement was available and the officer would have to apply for it on a regular basis, but some agencies would just automatically do it to alleviate the paperwork burden. It actually ends up being easier if they automatically expunge because the agencies can put timers on the cases and know that they have to be expunged. They don't have to worry about the paperwork coming through and doing it in that fashion.
Thank you for the clarification.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill, and thank you for the panel. My question will be directed towards Mr. Davey because I think you're probably, although the entire panel could probably answer this question. We were throwing the terms around quite a bit in this hearing. Unfounded, exonerated, sustained, not sustained. Could you give me a breakdown in each of exactly what that entails? Because that is different than the criminal side where you're guilty, not guilty, probation, et cetera.
Sustained basically means there is enough evidence to, by the preponderance of evidence that the officer violated the policy. That's sustained. Non-sustained is there's not enough evidence to indicate that the officer violated the policy. Exonerated, these are always very confusing. Again, I think that's why they were taken out of the law because now it's basically just charged or not charged. One of them simply means the officer's actions were consistent with policy. And the other one means it simply did not happen at all.
So in a not sustained, and which this bill does not tackle a not sustained, we wouldn't know, we're not sure one way or the other. Is that correct?
That's correct. The most important part, I think, of this bill, and I think the delegate did a very good job of crafting it, is the fact that it has to be reviewed by the Administrative Charging Committee. So that's a civilian panel having to make that determination that the officer should not be charged, or going forward with an administrative trial board and that officer being found not guilty. So you basically have 2 different reviews. This does not address an officer who missed court or a case that didn't go to the ACC or a serious nature where the chief can just write it off. That's not the case. These are serious cases that would have to be reviewed.
With the public?
Yes.
With the public.
And if I could analogize this, you mentioned the relationship to the criminal justice system. So in the criminal justice system, you have guilty, which is we find beyond a reasonable doubt somebody did it, and we have not guilty, which just means we can't prove that they did it. It doesn't say they're innocent, right? So the sustained is more like a guilty, the not sustained is like a not guilty. The exonerated and unfoundeds are like an innocent finding, where we have somebody reviewed it and determined that the actions were correct.
Thank you. Thank you, Mr. Chair.
Delegate Tomlinson.
Question. I think that answered my question.
Further questions for this panel? Seeing none, we thank you all very much. That concludes the testimony in favor. We're now going to those people who are unfavorable on the bill. Dara Johnson, Marguerite Morris should be virtual. Debbie Levy should be virtual. Melody Mitchell should be virtual. No. Yannette Emanuel, Jamal Turner, Nigel Jackson? Yes, okay. We'll see how many people we get virtually, and whoever would like to begin for 2 minutes, please go right ahead.
Good afternoon, Chairman Clippinger, and thank you. Okay, there we go. Okay, thank you, Chairman Clippinger. Good afternoon, Vice Chair Bartlett and members of the committee. My name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland, here to voice our opposition to this bill. In addition to failing to account for the overriding interest in maintaining public insight into investigative processes, not just outcomes, this bill would impose an almost insurmountable limitation on efforts to address the many known cases of police misconduct that are dismissed despite clear harm suffered by a complainant. This bill is seemingly premised on the misguided assumption that an exonerated or unfounded finding sufficiently confirms the misconduct investigation was properly executed, that the public conduct at issue was harmless, and that the related records could pose no future relevance to any public need. This premise is a fallacy, however, as there have been numerous examples of failures to adequately address serious officer misconduct, which Yannette can speak to more substantively. In addition to these examples, there are continuing concerns with inadequate findings by administrative charging committees resulting from current limitations on their opportunities to review citizens-involved investigations. As records of technical violations are already exempt from public disclosure, the expungement of more serious complaints under this bill would deprive both the public and the government of the benefit of investigative information that remains relevant beyond the few years following a decision, such as for law enforcement hiring decisions, witness credibility determinations, and factual research into any longstanding pattern or practice of misconduct. As public officials given immense power over individual freedom and liberties, the conduct of police officers must remain transparent, as affirmed by this body through recent measures like Anton's Law. This 2021 law provided access to records of both sustained and unsustained misconduct complaint, which was galvanized in part by the production of public records that show 90% of misconduct complaint were not sustained. So with that, we do urge an unfavorable report on HB 885.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and the members of the committee. For the record, my name is Yannette Emanuel, Public Policy Director with the ACLU of Maryland, here in opposition to HB 885. To add on to what my colleague Dara just shared, I'll just focus my testimony on highlighting some key examples. In the Anton Black case, a police chief falsified records to hire an officer with known history of misconduct. In the William Green case, an officer implicated in multiple violent instances, including shooting in 2008 and a fatal shooting in 2011, and multiple assaults, including allegedly choking a handcuffed woman in the back of a police cruiser and triggering the police department's early warning system by using force twice in a short period, managed to hide his long record of abuse behind dismissed departmental charges. A DOJ investigation into the Baltimore Police Department revealed deeply troubling examples as well. In 2014, a middle-aged black man alleged that a sergeant in Southeast Baltimore stopped him near Patterson Park and strip searched him in public. When the man protested and said he would contact a lawyer, the sergeant allegedly told him, "Get your N-word ass out of here." The BPD found the complainant not sustained without interviewing any of the involved parties. In another case, a man was hospitalized after 2 officers slammed him to the ground and unlawfully arrested him. The complaint was investigated for 13 months until rediscovered by an auditor, then lingered for another 4 months before being assigned to a detective. The BPD ultimately found the complaint not sustained for lack of cooperation, even though the witnesses failed to appear 17 months after the complaint was filed and 2 officers were never interviewed. The culture of secrecy not only undermines public trust, it endangers lives. In Maryland, 80% of exonerees are Black, and police misconduct is a leading factor in wrongful convictions that cost taxpayers millions of dollars. Public access to misconduct records is essential to prevent further tragedies, and ensure that our communities are protected. So for the foregoing reasons, we urge an unfavorable report on HB 885. Thank you.
Okay. Thanks again, Chair, for this. So first I want to say, and just to ensure that I'm not overlapping or mentioning a lot of the same points, I just want to echo 2 things. One is that first, I'm against this bill for the fact that it eliminates crucial context for officer performance. Every complaint, whether sustained or not, tells a story. Patterns of repeated complaints, even if each one is individually dismissed, may reveal issues that need attention. Maybe an officer is receiving multiple complaints about excessive force, but each case is cleared due to the lack of evidence. Should we ignore the pattern? Should we erase that history, preventing leadership from recognizing a potential problem before it escalates? Keeping these records helps identify areas where officers might need additional training or support. Next, it hurts future investigations. Past records are often essential in evaluating new complaints. Investigators need a full picture to assess credibility and identify misconduct trends. But if records disappear after just 3 years, we are forcing every new complaint to be viewed in isolation rather than in context. That weakens our ability to conduct fair, informed investigations. And finally, it goes against best practices in law enforcement. The best police departments in the country prioritize record retention as a part of their commitment to accountability. HB 885 would do the opposite, setting a dangerous precedent that could make it even harder to ensure that officers are held to the higher standards of conduct. Thank you.
All right, we'll go to the people who are on virtually, starting with Marguerite Morris, please, for 2 minutes.
Yes, good afternoon again. I hear that I am a thorn that will not go away. My name is Reverend Marguerite Morris. I'm here to testify in opposition of HB 885. I'm with Community Actively Seeking Transparency, and for Kathy's sake, first, I'm asking, are they asking us to once again make an exception for their own internal protocols? Are they asking us to consider patterns of behavior for other individuals that allegedly did something wrong, but were not charged, but not for them? Someone on the Senate side compared this to where citizens ask for records to be expunged, but this is like saying that to hit someone with a truck deserves the same relief as running over a toe with a kid's bicycle. Things are not equal, and the likelihood of an officer not being charged or say charges being dismissed is as probable as the sun rising in the morning. So moving quickly, it's all about patterns of behavior, and this bill seeks to remove or block long-term evidence of those patterns, the very patterns that they themselves use and call it behavioral analysis, originally referred to as criminal profiling. And this is one of the tenets of it, is that a person's thinking dictates his or her behavior. Key points about the importance of behavioral patterns: profiling. Studying patterns and actions helps investigators create a profile that outlines potential characteristics, demographics, and behavioral tendencies of an individual. The modus operandi, analyzing the specific details of how a crime or alleged crime was committed across multiple incidents can reveal a consistent pattern. Studying the characteristics of victims targeted can reveal patterns related to the offender's motivations and preferences. From a blog from American Military University, Signs of an Organized Criminal. He has an above or above average intelligence, is gainfully employed, is in a committed relationship, has no history of mental illness, is socially competent. So why are we once again seeking to place police and other law enforcement professionals above what is the reasonable expectation of others? In closing, I just want to say that I have firsthand knowledge that most likely there are things that were done that no one will ever be charged for. So in closing, please do not allow this bill to go through, for they're trying to chip away at the progress we've made towards some level of increased accountability. Thank you very much.
Just to be sure, Ms. Johnson? Okay, just making sure I've got everybody. All right, Ms. Levy, please.
Thank you, sir, Mr. Chairman. I will say this is the most concerning bill on the docket today for me from the Office of the Public Defender. As the proponent of the bill acknowledged, the materials that the police departments are asking for the legislature to condone destroying are discoverable material. And they're complaining that it's too hard to prosecute cases, so they're looking to the legislature to help thwart their constitutional obligation and under the rules of discovery to destroy discoverable material. Police officers are different than the average citizen. They testify for a living, and their statements help put people in prison. They are subject to scrutiny, and Brady and the rules of discovery require anything and everything in any form that would lead to the discovery of usable evidence at trial to be discoverable. There are officers of the court in this body sitting in this room today who cannot sanction the destruction of discoverable material. I encourage you to look at our written testimony. You can see that the affidavit that we supplied from former Major Lanzi, Stephanie Lanzi from the Police Integrity Bureau of Baltimore City says there are still problems with integrity. We've heard from scores of people today talking about the fact that ACCs are backlogged and overburdened. And Mr. Davey didn't even give a clear definition of what unfounded is. Let me give you an example of an unfounded complaint. Recently in 2022, an ATF agent, Kaisha Coleman, said that a police officer from Baltimore City gave a sworn statement of probable cause that conflicted with his body-worn camera, and that case should be dismissed federally, and they acted on it, but for whatever reason, that complaint was unfounded. I have another police sergeant who called in false reports about his colleagues in Baltimore City saying they were all dealing drugs out of their district action team unit. It was unfounded, but the police officer who fabricated it was lying. You cannot destroy those records. Cases come back on appeal, cases come back on remand. These documents are not always investigated properly, but that doesn't mean it's not discoverable material that must be required to be disclosed by law.
Mr. Jackson, please.
Good afternoon, Chair and members of this committee. My name is Nigel Jobs on Deck Jackson, Community and Development Lead for Out for Justice. Today marks my 742nd day out of federal prison. I would like to start by acknowledging that police officers are people too, serving our communities with dedication and often facing challenging situations. However, it is crucial to uphold accountability and transparency in law enforcement. This bill opposes the practice of expunging police records after just 3 years of infraction. While we understand the need for our officers to have the opportunity for rehabilitation and growth, the gravity of their responsibilities demands a higher standard of accountability. In contrast, individuals who commit crimes and serve significant prison sentences, often more than 5 to 10 years, return to society under strict probationary conditions and criminal records that follow them for the rest of their lives. For those falsely accused of a criminal offense, it often takes years to have their records expunged. This disparity raises important questions about justice and accountability. Our communities deserve to know the full history of those entrusted with their safety. By maintaining accessible records of police conduct, we foster trust, ensure accountability, and ultimately enhance the integrity of our law enforcement agencies. Thank you for considering this important issue. I urge an unfavorable report for House Bill 885. Thank you.
Ashley Devon for Out for Justice.
Good afternoon, Chair, members of this committee. My name is Ashley Devon, and I'm the Policy and Research Coordinator for Out for Justice. I would like to kind of reiterate what Mr. Nigel has said, is that our laws give police officers extraordinary authority. They have the power to stop members of the public from going about their normal lives, search them, arrest them, and charge them with the crime, and even kill them in certain circumstances. With these extraordinary powers, there should come an extraordinary responsibility to make sure that they use these powers effectively. While I'm here in my capacity as a policy coordinator, By trade, I am an educator. I'm a former teacher, a former school administrator, and now a school system administrator. I cannot alter, change, or remove anything from my professional record. There is a massive responsibility that individuals take on when they choose to work in public service positions. These responsibilities demand a higher standard of accountability. I'm asking that we have the same professional standards for all public servants. For these reasons, I urge an unfavorable report on House Bill 885.
Delegate Grammer.
Thank you, Mr. Chair. I have a question for Ms. Emanuel. So a lot of the arguments we've heard in opposition to this bill today are some of the reasons we hear arguments for expungements. For example, showing certain biases, showing certain behaviors, showing certain patterns of fact. And when people argue for that, if they argue against an expungement bill, so that maybe an employer could see, a private actor could see certain behaviors, certain patterns of fact, knowing that we move most expungement reforms, why would we not offer the same thing to police officers who've been exonerated? Because it's, these are not charges that have stuck. These are charges which have proven to be false. So make the comparison for me.
So I think you heard from my colleague earlier that the majority of these cases are exonerated or unsustained. And the issue is that a lot of times we find there hasn't been an adequate investigation actually conducted to come to that conclusion. So it would be one thing if maybe we had independent investigations and we could trust the outcomes of these investigations and the decisions, but that's just currently not the case right now. We have examples of people on the Eastern Shore, for example, who file complaints and get retaliated against, and that's happened in at least 2 cases so far. Now, that's just for them trying to even seek to file a complaint. So just because, and it looks different in different jurisdictions as well. There's some folks here from the Baltimore City Administrative Charging Committee and PAB who are in support of these reforms and I think are like-minded, but that's not the same for all jurisdictions, and we need to look at every case on a case-by-case basis. Additionally, what's different is that police officers, like it was mentioned earlier, are the judge, jury, and sometimes executioner, and that they need to be held to a different standard than everybody else. They have different powers, and with that comes greater responsibility and accountability.
You could say the same thing for expungements in criminal law, that, well, that got, the investigation didn't get sufficient resources put toward it. This person's had 3 thefts, they just didn't have enough police to work that specific case. Shouldn't we be looking at the principle and applying it equally, that if these people are, for better or worse, if we find, the system finds that they're innocent, I mean, is it legitimate to lament that, looking back, maybe we didn't have the resources, or shouldn't we just say they were found innocent and we're going to be accepting of that?
So in your example, you're talking about an individual who committed theft, right? Property crime. We're talking about people who can be on the streets, patrol people, detain them, and sometimes even take their lives. The standards are different. They have different responsibilities. And also, when we look at these cases, if there's a thorough investigation and if the officer is found not guilty or unsustained, if the complaint is unsustained, that can also be determined or evaluated through that complaint being public as well. It goes both ways.
Thank you.
Thank you, members of the panel, for coming in to testify. On the choking, triggering the early warning system, what is that system?
The early trigger warning system?
Yes.
It's a system that they have in Prince George's County that's supposed to detect officers who use use of force and maybe that it's more frequent. And maybe Ms. Levy can talk more about this, but I don't think it just lives in Prince George's County. I think it's a statewide program, but in this particular situation, in the William Green case, the officer triggered it twice. There's supposed to be some kind of investigation afterwards, and there just simply wasn't.
And that was in the vehicle?
No, the 2 incidences that was part of the early trigger warning system are completely 2 different situations, not related to him killing Mr. Green.
When you said that, when you made reference to that system, did that occur in a vehicle or not in a vehicle in each one of the cases?
I'm not sure what happened in those particular cases, but that was before the killing of Mr. Green. So that happened that summer. Mr. Green was killed in January of 2020.
Thank you very much.
Seeing no further questions, we thank everyone very much for testifying. And that concludes the testimony on House Bill 885. We're now going to move on. Delegate Bhandari, please come up. Delegate Bhandari is testifying. He's the only person to testify for House Bill HB 1361. Delegate Bhandari, if you'd like to begin for 3 minutes, please.
Thank you, Mr. Chair and esteemed members of Judiciary Committee. Good afternoon. For the record, Delegate Bhandari. While my work often focuses on healthcare and education, today I'm bringing forward this House Bill 1361 because I believe standardization of law enforcement reporting is a very practical and necessary step forward, one that can leverage artificial intelligence that our committee hears often to enhance accuracy, efficiency, and data sharing across jurisdiction. The bill originated from a conversation with the constituents, and we share a very difficult to track police report that led me to dig deeper into these issues, and I discovered that different law enforcement agencies in our state use different reporting systems, making data sharing very, very inefficient, slowing investigations, and creating inconsistencies statewide. After attending a Baltimore County Police Department presentation, I spoke with the police chiefs about how data is shared or often not shared across jurisdiction. That conversation confirmed that a standardized system would improve efficiency, accuracy, communication, and public trust. I understand Mr. Chair must be looking the fiscal notes as 100 million. I was not expecting that. And I know fiscal note is a very serious challenge to this bill. However, we should not let financial hurdles stop us from addressing critical issues. Instead of a full rollout, we can pilot the system in select jurisdiction before expanding statewide, leverage existing infrastructure like MAARS, NIBRS, and LINX, rather than creating an entirely new system, and seek federal grants and partnership to reduce state cost. We already have a system that this auto accident, they share the statewide report. We could mirror that as well. And if full implementation is not feasible now, I urge the committee to at least pass this measure as a study or report. This would allow our state to explore cost-effective solution without burdening the state with an undue financial burden in this difficult time. I appreciate your time and consideration and look forward to working with you on a practical and responsible path forward, Mr. Chair.
Questions? All right. Seeing none, thank you very much, Delegate Bhandari. That concludes the testimony for House Bill 1361. Now,
very simple bill. Thanks.
Thank you. Committee, this is going to be a first time for everything. Oh, I got popcorn. But that's not the first time for that. This is House Bill 1293. It's a bill that was introduced by Delegate Stephanie Smith from Baltimore City. I'm going to ask to come to the table Nicholas Blendy and Michelle Wurzberger. Why this is interesting is because it was a bill. Are you from Delegate Smith's office or Delegate Smith's office? Okay. So we're going to let her off the hook because, interestingly enough, this was a bill that was passed by the Alcoholic Beverages Subcommittee of the Baltimore City Delegation. And I chair that committee too. So, with the alcohol bills that come out of the subcommittee, I normally present the Baltimore City bills. I am not going to present this bill, but I'm yielding to the staff from Delegate Smith's office who's going to tell us what the bill does. And then we have two people here from the Baltimore City Liquor Board in what will be worlds colliding for me. So please go ahead.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. My name is Morgan Phillips, and I'm here today to present on behalf of Delegate Stephanie Smith to present House Bill 1293. House Bill 1293 seeks to establish the Neighborhood Services Unit within the Baltimore City Sheriff's Office to expand upon the existing relationship between the Sheriff's Office and the Board of Liquor Licensing Commissioners. 1293 fosters a collaborative approach to addressing alcohol-related violations by requiring the Neighborhood Services Unit to formally partner with the Board of License Commissioners for Baltimore City. The NSU will serve as the centralized unit within the Sheriff's Office to conduct underage task force operations, the BD7 tavern compliance checks, and public consumption referrals. The designation of the Neighborhood Services Unit ensures that enforcement and public safety initiatives have a dedicated structure and the necessary resources to continue the work. Most importantly, House Bill 1293 expands the authorized uses of certain revenue sources to support the Neighborhood Services Unit's work, and this provision ensures that the unit will have the financial resources needed to fulfill the mission without imposing additional burdens on Baltimore City taxpayers. The unit within the Sheriff's Office is a forward-thinking approach that will enhance public safety and improve the overall quality of life for Baltimore City residents. Most importantly, the bill has been heard by the delegation and voted out unanimously. And for these reasons, we respectfully urge the committee to issue a favorable report.
I'll correct myself. Mr. Blendy is here from the Sheriff's Office. Ms. Wurzberger here from the Liquor Board. Whoever would like to go next, please.
All right. Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, Nicholas Blendy, Assistant Sheriff from Baltimore City Sheriff's Office, formerly attorney for the Liquor Board, and have been succeeded by a much more able-bodied and minded lawyer over here in Ms. Wurzberger. But I appreciate Morgan from the Delegate Smith's office putting it in context, and I'll just, without belaboring thing, get into slightly a little more detail on like the core most important thing, which is the Sheriff's Office has ongoing partnership and collaborative effort already with the Liquor Board, and we do with the Maryland Alcohol, Tobacco, and Cannabis Commission as well. And when we signed an MOU with the ATCC to do some collaborative work, I was informed by yet another previous attorney for the Liquor Board, who is Mr. Akris over in the ATCC, that they have a provision in the Alcoholic Beverages and Cannabis article that allows the ATCC Field Enforcement Division to enter into cooperative agreements. And then we realized, oh, that doesn't exist in the Liquor Board. And then we started having questions about who is the custodian of records when we work on these collaborative things. So by creating this authorized process and allowing us to then engage in this MOU process, things that get referred properly to law enforcement for a criminal investigation would be able to be deemed as custodian of records, now the Sheriff's Office, and then we would handle any requests for it, and the Liquor Board would not be forced to turn over what could potentially be the actual like genesis of an investigation into criminal activity. So we thought that this would be a wise structure, and I appreciate Morgan talking about the funding effort. There's already a surcharge on all filings in CJP for landlord-tenant actions, effectively, and those uses are for to fund enhanced sheriff's benefits and other things, and we would like to expand that to include neighborhood services, the goal being between cobbling that together and other resources we think we can establish it, and we ask for a favorable report. Thank you.
Mr. Chair, members of the committee, for the record, my name is Michelle Wurzberger. I did succeed Nick. I am the Deputy Executive Secretary for the Baltimore City Liquor Board. You have our written testimony in your packets. We are absolutely in favor of this bill. The Sheriff's Office is one of the Liquor Board's strongest partner in this effort. We get calls and emails and complaints about all sorts of activity that is happening both in and around liquor license establishments. And some of those complaints, we just simply don't have the capacity and we don't have the authority to deal with those issues. And Mr. Blendy outlined some of those. This bill would allow us to formalize that partnership and be crystal clear about what each agency's roles are so that we can work together to ensure public safety, again, in and around liquor licensed establishments. And for that reason, I do urge a favorable report for this bill. Thank you.
Questions? Would the Baltimore City delegation approve this legislation?
Yes.
Yes, okay. Yes. Yes, it did. Yes, we actually, yes, we should have a letter. Yeah, that's true. It wouldn't be heard if we didn't have a letter. Seeing no questions, thank you all very much.
Thanks.
And that concludes the testimony on House Bill 1293. Now, committee. Oh, my. House Bill 748. Oh, no. I don't know. Delegate Schindler.
Permission to bring my panel, Chair, Mr. Chair?
Yes, you really should.
Thank you.
Yes. His panel is exactly one person. Tyler Bennett.
This might actually be my debut in this.
Is it your debut as well? This is Delegate Schindler's first bill in front of the committee, everybody. Be the requisite amount of nice. Delegate Schindler, please, for 3 minutes.
Thank you, Mr. Chair. Madam Vice Chair, honorable members of the committee. For the record, I'm Delegate Matthew Schindler, and I'm here to testify in support of House Bill 748. I thought this committee could use a break, so I'm bringing you what I hope will be the most brief and straightforward bill of the day for you. House Bill 748 is an enabling legislation, simply allowing municipalities to authorize code enforcement officers to wear body cameras if they so choose. This legislation would allow municipalities to enhance transparency and ensure that enforcement officers and constituents are able to access a record of their encounters. In my previous experience on the Hagerstown City Council, I witnessed many complaints or issues regarding code enforcement that could have been readily resolved if there was a digital record of the enforcement encounter. I believe this legislation will create a tool that can boost government trust, efficiency, and transparency. This bill carries no fiscal note, merely gives our local jurisdictions another tool in their toolkit. With that, I thank you for your time and respectfully urge the committee for a favorable report on House Bill 748.
Thank you, Mr. Chair. Members of the committee, for the record, my name is Tyler Bennett with Compass Advocacy on behalf of the city of Hagerstown. We are in full support of House Bill 748 and are grateful to Delegate Schindler for sponsoring the legislation. Delegate Schindler covered many of the key points on the benefits of allowing this policy, and you have our written testimony as well that covers a number of other key points. Again, this is just authorizing legislation. It's not a mandate. We've seen other jurisdictions throughout the country begin to deploy cameras in a variety of ways for parking enforcement, fire marshals, et cetera. It's just whenever you have a scenario where an interaction may turn confrontational, body-worn cameras can ensure that both the municipal employee and citizen can be held accountable in a way that's transparent. The bill also requires that the municipality, should they choose to move forward with this policy, develop and publish policies that address a number of administrative and procedural factors that are spelled out in the bill. And we would certainly welcome any input from the committee regarding the nuts and bolts over those types of things. And thank you and for your consideration, and respectfully request a favorable report.
There are 3 questions so far. Delegate Schmidt.
Thank you, Chair. Quick question. Who is the godfather of the body-worn camera legislation? This is a very important question, Delegate.
I believe that would be Mr. Conway.
That's correct. Thank you, sir.
I really just wanted to torture him a little bit, but I actually started to read the bill. And it's pretty complex. There's a lot going on here. So I just wanted to know, did you actually copy this from our other body-worn camera statute, or did you just make this up on the fly?
If I'm being completely transparent.
I told you I wanted to be hard on him.
I found that we have this very helpful group called DLS.
Yeah.
So you give them an idea and they run with it for you. They really help you to craft it. So.
Okay, so this may not actually match the other stuff that we had, because there's just a lot here. Like if the person is recording and it stops working, and then there's all of this you know, when recording is mandatory, prohibited, discretionary, blah, blah, blah. So I don't know if we have all that in ours, but maybe it seems reasonable, but maybe the committee can massage it so it matches the other stuff. So we're not setting different policies for different.
Sure, and there's no sense to recreate the wheel. So if there's something that works better that's already, you know, crafted, we're, you know, amenable to that.
Yeah, the dangerous thing about coming to Judiciary is that when we take your baby from you, it becomes our baby. And it can come out looking real different. So anyways, welcome to the Judiciary Committee.
Thank you.
Thank you. And forgive me, I just don't remember the answer to this. Is it that current law prohibits any other employees from wearing body cameras, or just that because they're not named, you believe you need this enabling legislation?
And Tyler, I don't know if you'd like to speak to this, but it was my understanding that right now the only thing that's explicitly given permission for body cameras would be law enforcement. So
this is to sort of be careful versus no. Okay.
That's my understanding as well.
I think the issue was that when the committee in the past sought to mandate it, suddenly that came with a very large fiscal note attached. And so this is different in that it's authorizing and they can figure out how to pay for it on their own. Delegate Moon, then the Godfather, then Delegate Simmons.
Thank you, Mr. Chair. I'll just start it with, isn't that so? Isn't that so that to answer some of these questions and sort of get at what you were asking about whether there's some tweaks here, I'll have to go back and refresh my memory, but I do believe that when we set forth the police body cameras, the main way we did it was simply by saying you're not in violation of the state's two-party consent wiretapping statute in recording audio with police body camera. And so the way we put them into law was simply by exempting police body cameras from the wiretapping statute. You could probably just add this as a one-word exclusion to the wiretapping statute and get a very simple bill through. Isn't that so?
Thank you.
Delegate Conway.
Yes. Thank you, Delegate. Thank you, panelists, for coming in to testify. So are these people you're talking about, are they sworn officers?
No, these would be.
I couldn't hear you.
Oh, I'm sorry. The microphone's on now. No, I don't believe these are code enforcement, for example. So someone that will come out and they would be inspecting a building for code violations, things of that nature.
Well, seeing how they're not sworn officers, I don't see how you're going to bypass the privacy acts that we made the exception for law enforcement. So you might want to think about that. Thank you.
Any other questions? Seeing none, we thank you very much. Welcome to Judiciary. And that concludes the testimony on House Bill 748. And committee, that's the first page of bills. And it's only 4 o'clock. All right. The Washington County delegation is heading up to the table with one of the Washington County delegates who we've seen before. We'll hear also from Eric Byers, who's there, I believe, and right, Delegate Valentine, please, for 3 minutes.
Thank you, Chair. Good afternoon. Good afternoon, Vice Chair Bartlett and members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing Washington and Frederick counties. I'm before the committee today to present House Bill 478, which involves the Hagerstown Community College Police Force and its jurisdiction on behalf of the Washington County delegation. Last fall, the delegation was contacted by Dr. Klauber, our college president, and Chief Byers, seated to my right, and requested to pursue this legislation. The bill clarifies and adds language to existing statute and will be explained in further detail by Chief Byers. By way of background, the current statute was written when the Hagerstown Community College was located in a single location on a rural farmland outside the city of Hagerstown. Today, the college has 2 local schools, a hospital, a school of osteopathic medicine as its neighbors. The college has another training location under construction in the city of Hagerstown, set to open later this year. The college is a partner with the Washington County Police Academy and conducts training at its Public Safety Training Center. These locations are throughout our county, and Hagerstown Community College police officers routinely travel to and from these locations. The college has entered into reciprocity agreements with Washington County Public Schools, Meritus Healthcare, and the Washington County Sheriff's Office in the event of an emergency at either the school or hospital location, and HCC police can respond more quickly than other county resources. The city of Hagerstown is also considering such an agreement when the college moves to its new training site on Northern Avenue within the city later this spring. This legislation will allow the Washington County Sheriff's Office, the Hagerstown Police Department, and the Hagerstown Community College Police Department to work more seamlessly together, which will bring better safety to its students, our residents, and visitors to Washington County. The sheriff, as well as the Hagerstown Police Chief, both support this legislation, and any changes would require a review and support of both the college president and its board of trustees. The legislation was unanimously supported by the Washington County delegation and is currently cross-filed with Senate Bill 504. I would respectfully request a favorable report and hereby switch to Chief Byers.
Good afternoon, distinguished members of the committee. Thank you. My name is Eric Byers. I'm the Director of Public Safety and the Chief of Police for Hagerstown Community College. To follow up on what was said previously, back in 2009 when the House Bill 361 was originally written, I believe there was appropriate guardrails put in place at that time. This was something new. There's only one of, at the time, currently right now, there's only 3 community colleges with sworn police departments. So I think those appropriate guardrails were put in place designed to allow the police department to grow. You fast forward now to 2025, our college has grown and our needs to help ensure safety in our community have also grown. We are less than a mile away from the Meritus Medical Center, 2 primary schools. We travel throughout the community. The way the bill is currently written resembles much of what you would see in special police language, restricting us and denying our police officers of what is referred to as statewide police jurisdiction under 5802. This new subtle change to the law does not grant us extra jurisdiction. It just allows the other agencies, our partner agencies, the Washington County Sheriff's Department, Hagerstown City Police, the ability to call out and ask for us for help, and allows us to go off campus and assist with emergency situations. Just to be clear, we're not looking to handle a domestic across the street in our neighborhood. We're not looking to run traffic outside our jurisdiction. We are just merely wanting to be that force multiplier within the community and be able to enact our law enforcement authority if called upon to do so by the other law enforcement agencies within our community. We're currently serving as the reunification site for Washington County Public Schools in the event of an emergency. If there be an active assailant situation, those schools are reunifying on our college campus. We're also part of a very big part of the emergency management and emergency planning within our community. So today I would just respectfully ask for a favorable opinion on this bill. Thank you for your time.
Questions? Okay. Go. I'm not sure. Go ahead. Are you here to testify on the bill? I didn't have another person listed to testify.
I'm sorry, Mr. Chair. I did have one in my system, did have Dr. Klauber signed up.
Okay, go ahead.
I've already testified to the majority of what he would say.
That's fine. Me too is also helpful, but go ahead. You're already here.
That was it, Mr. Chairman. I apologize. I've been here, but I had to slip out to Judiciary Committee for another bill that we had up today. So, and it just happened they both came at the same time. My name's Dr. Jim Klauber. I'm president of Hagerstown Community College, and both of what these gentlemen said I thoroughly support, and we really need your help in passing this piece of legislation because it will help us work better together with Washington County Sheriff's Office, Hagerstown Police Department, especially with the proximity of elementary schools close to the college and the hospital and the new medical school just down the street. So those are some things we'd like to have your help with.
All right. Delegate Schmidt has a question.
Thank you, Chair. Delegate, do other jurisdictions, other community colleges have these powers across the state?
I'll let the chief speak, but in discussion with him earlier, he said that this bill mirrors the Anne Arundel County Community College bill.
Yes, the language in AA Community College is very similar, and they have a sworn police department as well. Their agency has an MOU with the county police department in Anne Arundel. What started this for us when we went to engage in an MOU with Washington County Sheriff's Department years ago, they said just because of how our bill was drafted originally, we could not engage in that MOU and be deputized or have statewide authority based on the constrictive nature of the language in the bill.
Okay, thank you.
Any other questions for this panel? All right, thank you very much. That concludes the testimony on House Bill 478. Moving right along, we're going to go to a couple bills from Delegate Grammer, and then we're going to make our way back to a string of bills related to parole, both medical and geriatric. House Bill 954. We'll hear from just Delegate Grammer on House Bill 954 for 3 minutes. And then there are 3 people testifying in opposition. One of them is virtual. Delegate Grammer.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 954. House Bill 954 adopts a framework for the legal use of drones in law enforcement. Look here, look there, you'll see drones everywhere. Montgomery County was the first to launch the use of drones as first responders in Maryland. At a hearing in the beginning of this legislative session, Baltimore County announced it had a plan to launch its own program. The Baltimore County launch was announced similar to that of other technologies, suddenly and without input. And knowing that surveillance technologies are always used beyond their stated goal or limit, we should put a framework in place to provide boundaries for the legal use before every jurisdiction has the program. And that is what House Bill 954 attempts to do. The bill allows for the use of drones with a valid search warrant, with a valid arrest warrant, in fresh pursuit of a subject, to assist in an active search and rescue operation, to locate escaped prisoners, to prevent imminent serious bodily harm, or to when under the duress of a terrorist attack. It's a reasonable starting point for protecting the Fourth Amendment as we step into a world of drones. Thanks for the opportunity to present House Bill 954. I'd be happy to take questions, and I'd ask for a favorable.
Questions? Seeing none, that's the testimony in favor of the bill. We'll hear now from Mark Kaler, Scott Schellenberger, and Nick Macerno virtually. Yes, please. All right. Whoever would like to go first at the table, go right ahead.
Sure. Scott Schellenberger, State's Attorney for Baltimore County. The delegate just said that there are no boundaries in place. Well, there are boundaries in place. It's called the Fourth Amendment, and it's been around for a couple of 100 years. And what has happened is, over the years, the Fourth Amendment has guaranteed our right of people to be secure in their persons, places, and effects. But ever since the 60s, in the Katz case, Katz versus U.S., please read my written testimony, the Supreme Court ruled that the Fourth Amendment protects people in places where there's a reasonable expectation of privacy. There is no reasonable expectation of privacy when you're walking down the street. And the Supreme Court has ruled in 2 different cases that it's okay if an airplane flying overhead records you or sees you. That doesn't violate the Fourth Amendment. And then they went in 1989 down a little bit lower, that when a helicopter is overhead, that doesn't violate the Fourth Amendment. So why would Maryland law want to put into effect something that is more difficult than the Fourth Amendment that has been governing our lives for all this time? I can follow you down the street, or a sheriff can follow you down the street. He can stand on the top of a building and watch you and look at you. He can look out the window and follow you. You're allowed to do all those things. We are not using drones to peer into people's windows. We're merely using them as an effective law enforcement tool to try and make sure that we catch criminals and we look for innocent victims. And, you know, we might as well make this easy. I got 25 seconds left. House Bill 682, persistent aerial surveillance, is exactly the same testimony. The cases are the same. The Fourth Amendment is the same, and therefore the concepts are the same. We can't keep taking away police officers and law enforcement's good use of technology to solve crime and make sure victims are protected.
Thank you. I'm Lieutenant Kaler, the Charles County Sheriff's Office. Thank you for affording me the opportunity to share some of my UAS knowledge today. Unmanned aerial systems, or drones, have been increasingly used by law enforcement across the country since 2016. This technology significantly enhances the ability for police to save lives, increases public safety, is used as an invaluable de-escalation tool during critical situations, and affords the opportunity to engage with the community and our youth. House Bill 954, along with House Bill 682, will significantly hamper these accomplishments of these tasks. Police departments draft drone policies with civil liberties as well as public safety at the forefront. Under this bill, if an individual broke into a home and fled prior to police arrival, their escape will be made easier by police not being able to use drones, as that does not fall under the fresh pursuit exemption. This previous year, on 2 separate occasions in Charles County, the drones were used to locate and arrest multiple individuals breaking into vehicles. Without the use of the drone, these individuals would have been able to continue to victimize their community. During the tragedy at the Key Bridge last year, numerous agencies flew drones after the initial search for survivors. This footage helped keep crews safe, monitor shifting debris, and keep tabs on the progress. If this bill was enacted, none of this would have been possible, and any evidence gathered in this manner would not be allowed in the state's federal lawsuit against the shipping company. I'm aware that the framers of this bill are concerned with privacy issues. So is law enforcement. I would hope that this bill, along with 682, can be put aside and that the sponsors of the legislation can meet with agencies that run UAS programs to carve out any future legislation that would protect privacy rights, but would also allow the police to continue to use this excellent technology. Thank you for allowing me to speak today.
Nicholas Pacerno, please, for 2 minutes.
Good afternoon, members of the committee. My name is Nicholas Pacerno. I'm a captain with the Montgomery County Police Department. I am Director of Special Operations, and under my division is our UAS program. I'm going to speak briefly about our DFR program, or Drone as First Responder program. It's a program that has received quite a bit of attention and accolades recently as an amazing force multiplier for law enforcement, also as a way to mitigate some of our staffing shortfalls in Montgomery County. We operate a very transparent system. We've worked with community members, with community organizations, and our local politicians to put some frameworks in place of our UAS program, so we only fly emergency calls for service and calls for service where an officer is requesting our assistance. Every single flight that we do is published online. Information is published as to what the flight was about, what for. We are arriving on scene in Montgomery County using our DFR program within a minute to calls for service, and more than 70% of the time we are arriving on scene before a police officer arrives on scene. By doing so, we're able to provide the latest and most pertinent intelligence and information to officers in the field. And by doing so, officers are able to use that information for de-escalatory purposes. They're able to make decisions faster, with more information, resulting in safer outcomes. We are proud of Montgomery County. We actually had the first conviction in the state of Maryland based solely on video obtained from our DFR program. DFR programs originated in California in the Ninth Circuit, a very progressive, left-leaning, very progressive part of the country, and they've had amazing successes out there. So I would encourage an unfavorable report. If any members of the committee want to see our program in person, I would love to have you all out. Please reach out to me, but I would urge an unfavorable report.
We'll take questions now. Delegate Cardin, then Delegate Erica.
Thank you, Mr. Chair. Thank you very much. I guess I don't know if this is for Mr. Schellenberger or for the law enforcement folks, but if there is a non-law enforcement drone out there that is following somebody, let's say harassing them, staying on them, is that permitted? Is that allowed because it's in a place that's you're not expecting privacy?
Go ahead, please, go ahead.
So right now, drone laws for the public are under the FAA's guidelines. So as long as they are flying under 400 feet in non-restrictive airways, that's a legal flight. However, there are already laws on the books for harassment, stalking, stuff like that. So if that falls under those guidelines, whether you're using an iPhone or whether you're using a drone, those laws would still apply.
And a bill that we had last week, which was the visual surveillance, where the person kept raising their cameras to peer into the person's, the victim's bedroom. Under that concept, that law may apply if the drone were to be staring inside a young person or a person's bedroom window.
And clearly a law enforcement drone would not attempt to do that without a warrant, right?
Oh, no.
Appear into somebody's bedroom.
Oh, of course, no, we would not.
And if a law enforcement drone was following somebody close behind who they may have thought was, you know, involved in some kind of criminal activity and kept following and following and following, in the end, they found out that it was the wrong person. So what kind of response does that individual have to be able to pursue any kind of claim against them for harassment?
I believe that they would have the same recourse that any individual would have, that maybe an officer is following them, running their license plates, stuff like that. They're trailing them on the roadways. So they have recourse through what we've heard earlier today, through the Police Accountability Board and complaints systems.
Okay.
The same recourse for...
I'm not going to go into this, but if it's a contractor, like in Montgomery County, it's oftentimes the contractor's actually doing the actual technical work while the police is overseeing that work. Would the Police Accountability Board still have jurisdiction over that?
I'll let the captain discuss that, but I believe their contractors are not flying their drones.
So in Montgomery County, for our rooftop contractors, their sole purpose is to take the drone off, to observe it. We have a requirement. Montgomery County is a little bit weird. The rest of the state, half of our county is what's called a flight restricted zone, which is the 15-mile circle around DCA airport. So we have to have a person actually watching the drone at all times. So on the rooftop where the drone takes off, we have contractors whose job it is to maintain the visual line of sight with the drone, but they're not looking at the camera as what the drone is seeing. That's happening at the flight deck here in Gaithersburg.
Got it.
What I will say is one of the reasons why the DFR is so effective is because we're able to get on scene so fast. We are improving outcomes because we're actually, by being on scene first and sooner, we're able to give officers information in the field so they know they're dealing with the right person and not extrapolating imperfect facts 5-10 minutes after the call comes in. But if someone were to be, the drone isn't making the interaction with somebody, it's police officers on the street. But information being provided to them is being done by law enforcement officers here in Gaithersburg. So your recourse would be the same. The contractor has no direct impact with the community.
And Delegate, it would be the same as where we started, and that is you have no right to privacy in the public place, so they would be able to be followed, even if it was the wrong person. But the moment they go into their house, then it ends.
Okay. Thank you. Thank you, guys.
Because of the reasonable expectation of privacy.
Delegate Erican.
Thank you, Madam Chair. Thank you guys for coming in. Okay, a couple things. First, I want to applaud Montgomery County for doing what seems like a lot of due diligence when they got their program up and running. It seems to me, I've heard about it now a couple of times, that you guys really try to think through a lot of the potential pitfalls of a program like this and how it could trigger both the left and the right. But if you look at the bill, it actually has a ton of carve-outs. I mean, what you guys were complaining about, you almost acted like it was a full-on ban, but it's not. It allows carve-outs for valid warrants that were issued, if you're executing a warrant, if you're in fresh pursuit of a suspect, which was one of the cases that you mentioned, if you're actively search and rescue operation, which is another case that you mentioned, trying to locate an escaped prisoner, it goes on, there's several other ones, threats of imminent bodily harm. There's a ton of things in here that would actually allow you to use that. And it covers every case you've said so far.
Well, the problem is with regard to the first one, in accordance with a valid search warrant issued by a judge, remember, search warrants have to be very particular as to the place that you're going to be searching. And so, for instance, if an individual like David Linthicum has shot 2 police officers and has been wandering the woods for 48 hours, then a search warrant wouldn't be able to narrowly limit where they were searching for that individual. And so that was the thing. I agree with you. There are some exceptions there that certainly do help. But the fact that a search warrant has to be very particular as to the place and the location of where you're searching, it is so particular that we had a Court of Appeals, a Supreme Court decision a couple of years ago where the officers had a valid search warrant to search the house, but then when they took the phone out, they had to get another search warrant to search the phone because it has to be so particular. So that's the reason I worry, particularly when you're using a drone or, again, aerial surveillance, when you're looking over a large area of space. You know, I don't know that we would pass constitutional muster to say that you can search all of Montgomery County except for those miles.
I hear you. Why would it not be in fresh pursuit of a suspect then? Why would that not count? If somebody just shot 2 police officers and ran into the woods, that's a suspect and we're in fresh pursuit, right?
Well, like he said, that's 48 hours later. We are now, although fresh pursuit doesn't have to be instantaneous, it has to be with unreasonable delay.
Right.
So, you know, in the case of my individuals breaking into cars, no officer had sight of them on the ground. So there was no pursuit, and the drone can initiate a pursuit. So that would not have fallen under that guidelines with the gentleman's example of someone shooting 48 hours. I believe your words were we might be in a constitutional murky water there.
So maybe we could create a better language, but I think, can you guys at least acknowledge why some of us find this to be extremely creepy? I mean, it's creepy. It's creepy to think about. I didn't like the spy planes. I can't be the only conservative that thought that was crazy. I mean, I don't want you watching me all day long. It's uncomfortable. We don't want to be the office of pre-crime one day with little things buzzing around telling us that we walked outside of a crosswalk. That is next level nutty stuff. So I think if we could just find some common ground where we can say, you know, Montgomery County seems like they're doing a pretty good job. Maybe we adopt some of their policies, but something I think has to be done because we're going to have a patchwork of wacky policies, and some of us are going to be, especially since we've already said we don't really like it now, in 2-3 years, we're going to be really cranky.
And I believe that the language has to be modified. I believe legislation is inevitable and needed. It's getting everyone at the same table.
Okay. There's a path potentially to a kumbaya moment.
But let's remember reality nowadays. Everywhere you walk, someone is able to see you through a camera. You go into the Safeway, you go into the Target, people are watching you, you are being recorded. It is the way of life that we have come to accept unless you're living in a cabin in Canada somewhere. And I suspect when you cross the border, you're going to be on somebody's video somewhere.
Oh no, there's a lot of border crossings up there that are unmanned, as we've learned.
So, but
no.
But what I'm saying is, you know, we've adapted to accepting all these pieces of technology, and why should we limit the police's ability to use the best technology that's out there?
I hear you. I do think there's a difference between my neighbor recording me and I can, you know, drag him into a civil litigation situation and the government watching me, with all due respect. You know I love you guys.
Thank you.
Okay, thank you very much. That concludes the testimony for House Bill 954. We're going to move on to House Bill 682.
I'll save you time. I'll just say ditto and sit down.
Great, thank you. Delegate Grammer, come on up, and
ditto.
So you'll be testifying favorably, and then we'll have our unfavorable panel.
I'm sorry, 682?
682, I only have you as favorable,
Got it.
so whenever you're ready.
Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 682. House Bill 682 adopts a framework for the legal use of persistent aerial surveillance, including the constitutional check on the warrant requirement. When persistent surveillance systems started surveilling the city of Baltimore, it did so in discreet agreement without any public awareness. The wide area live feed surveillance system was developed for wartime use. After being shut down in Los Angeles and Dayton over privacy concerns, the program was brought to Baltimore and authorized by Baltimore City Police. The Fourth Amendment is not a guarantee against all searches. What it does do is limit searches only to those found reasonable by law. The Supreme Court has long held that aerial surveillance does not constitute a search in considering the Fourth Amendment. However, the persistent monitoring makes aerial surveillance more equivalent to GPS monitoring, which the Supreme Court has already considered a search. It was on this premise that the Fourth Circuit Court of Appeals based on its opinion when it ruled the Baltimore City program unconstitutional. As aerial and drone-based surveillance expands into all realms of law enforcement, we should make the checks and balances around surveillance clear. We are lawmakers. We shouldn't rely on judges and case law to protect the Fourth Amendment. We should do our jobs and place statutory boundaries around this technology. And briefly, to comment on why this legislation is important, if we look back in American politics over the past several decades, every new surveillance technology has been significantly abused. The federal government with telecommunications, there was a huge whistleblower that really released information that the public found to be shocking. The state's attorney mentioned your cell phones. You need to get a warrant to search the cell phone. Does anybody remember the use of stingrays here in Maryland and the fact that they drove that van around and collected the cell phone communications of everybody in proximity? Yeah, absolutely we need a warrant to get access to your cell phone. And how about this bill itself, the persistent aerial surveillance in Baltimore? Can you imagine that a jurisdiction in this state deployed a technology in the middle of civil unrest without any knowledge of the public, which recorded the actions of every person in the region? So I think the government is probably the most horrible violator of personal rights. If I go into a giant, I'm fully expected to be recorded as I walk up and down the aisle. I'm not expected to be continually surveilled by the government, and that is why we need, this committee is the arbiter of the Fourth Amendment, and I think after years of seeing surveillance expand in our state without any checks, it's time to step up for personal privacy. With that, thanks for the opportunity to present House Bill 682, and I'd ask for a favorable.
Thank you. Are there any questions for the delegate? All right, seeing none, we're going to move to the unfavorable panel. I have Travis Hayes and Mr. Schellenberger, if you're sticking by ditto, he's out, okay, and Captain Picarno, we've got you here. So whenever you're ready, Officer Hayes, thank you.
Good afternoon, and thank you for allowing me the opportunity to speak on behalf of Bill 682, as well as Bill 954. My name is Travis Hayes, and I'm a deputy with the Harford County Sheriff's Office. I've been a member of our drone unit for the past 3 years. I just want to briefly go over what we utilize our drones for. We have many different applications to include search and rescue, situational awareness, visual inspections, scene and evidence documentation, accident reconstruction, aerial photography for threat assessments, and to assist with our canine tracks. We also utilize our drones for tactical deployments to aid our special response team with providing overwatch in a barricade incident, perimeter security, or a hostage situation. Our drones give us the benefit to continuously provide overwatch and send real-time video feed to any of our SRT members, criminal investigators, and other deputies who may need to utilize this crucial tool for their investigations. Our drones provide real-time insight into security and emergency situations for better control, accurate intelligence gathering, comprehensive situational awareness, and a more informed decision-making. Thank you.
Thank you. Captain, whenever you're ready.
Good afternoon. I'll just refer back to my previous testimony on the drone bill. The concern I raised about this piece of legislation, 682, is the definition of aircraft would also include drones. So for the same reasons I spoke about the drone bill, I'll also incorporate those in my testimony on this piece.
Thank you very much. Questions, Delegate Arakan?
Thank you, Madam Chair. Thank you for being here. You said you were from Hartford?
Yes, ma'am.
Oh, good. So that's where I'm from too. You probably heard the conversations specifically on drones. This, I think, bill is more towards the aerial surveillance plan in Baltimore. We, just for the record, do not have that happening over Hartford County, correct?
Correct.
Okay, that would be super disturbing. I think maybe there's an opportunity here for Hartford County to weigh in as well as Montgomery County on how you guys are currently using things so that we as a body can make a decision about what guardrails to put on folks so that, we make sure that everybody feels comfortable with how they're being used, that they're being utilized both to protect you guys, but also to protect citizens as well, and also our basic rights to privacy. So hopefully the Sheriff's Office would participate in those ongoing discussions.
Absolutely.
Okay, great. I would love to see us come to some kind of conclusion, rather quickly before everybody opens up a separate shop and we've got, the patchwork. That's horrible, and then it will drag us all down here repeatedly to try and, fix things that we could have just started out. Since you guys are the beta test, let's see if we can come together quickly.
Sure. Yes, ma'am.
All right, thank you.
Seeing no further questions, that concludes the testimony for 682. We're going to move on to the third bill by Delegate Grammer, House Bill 687.
Whenever you're ready.
Okay, go ahead.
Thank you, Madam Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 687. House Bill 687 prohibits the use of law enforcement quotas. When former Baltimore City Police Officer Michael Wood was asked what his suggestions were for improving police culture, he recommended that we think about what our goals are, and he told a story about how the metric that he was given by leadership was arrests. He told about how he would drive through his assigned detail looking to satisfy his arrest quota. He couldn't fill his quota in the rich part of his assigned precinct that was predominantly white, so he drove to a black community to arrest people for jaywalking or littering. Proper policing is community-driven. Officers form partnerships with community members, build trust, and follow the evidence. In many places in our state, we implement the opposite. Politically driven policing implemented through quotas. Behind closed doors, officers are squeezed to produce a product that elected officials can sell to the public. Under a regime of quotas, some officers feel empowered to bend or break the law as long as their superiors continue to reward them for numbers that look good in the paper. The series We Own the City demonstrates the realities of what can happen when elected leaders are allowed to press their officers to hunt. This bill was requested by a member of Maryland's law enforcement community in response to this issue. A separate member of Maryland's state police community reached out to my office to share his concerns about the issue. This person shares concerns about troopers' mental health and said most troopers disagree with this policy but have no voice or help to combat this practice. The person specified that state troopers are threatened with disciplinary action if they do not meet these required goals. I have submitted to the committee actual enforcement communications by state police leadership. This is illegal under Maryland's public safety article, section 3504. In addition to that, I've shared an email from law enforcement leadership comparing quota enforcement actions to help determine who is getting a new car. Please note that the #1 producing officer is delivering 4 times the numbers delivered by the lowest. Leadership is pushing officers who don't generate numbers and rewarding those that do with trinkets. House Bill 687, the Community-Oriented Policing Act, discontinues the use of law enforcement quotas in the state of Maryland, hopes that all aspects of Maryland law enforcement are derived from community concerns, not political aspirations. Paraphrasing the words of former Officer Michael Wood, we cannot set this terrible stage and gasp in horror, screaming, "Look at this terrible stage." Thanks to those who submitted written or oral support in favor of this bill. I'll be happy to take questions, and I'd ask for a favorable.
Thank you. We have favorable testimony who are here virtual, so we're going to go to them, and then we'll go ahead and ask questions. We have Deborah Levy.
Thank you very much.
Good afternoon, Chair and members of the committee, Vice Chair. My name is Debbie Levy. I serve as the Chief of Strategic Litigation at the Maryland Office of the Public Defender. I'm here today to urge your support for House Bill 687, which seeks to address harmful effects of police quotas in Maryland. Whether formal or informal, police quotas introduce perverse incentives into an already strained relationship between law enforcement and our communities. These quotas distort legitimate public safety priorities and often result in unnecessary, harmful interactions between police officers and community members. In his law review article, Police Quotas, Professor Sean Ose-Owusu from the University of Pennsylvania's Carey Law School explained that quota-based policing is one area where there's widespread consensus for change. Remarkably, this is an issue that unites groups across the political spectrum. Liberals, libertarians, conservatives, police officers, unions, and people of color all have combined to agree that quotas are unjust and counterproductive. Professor Ose-Owusu highlights how quotas negatively impact three key groups. Marginalized communities who are often the targets of officers' attempts to fulfill their quotas. These groups are disproportionately affected by aggressive policing driven by these arbitrary targets. Police officers, because they are forced to comply with quotas, leaving them with less discretion and authority to make independent, reasonable decisions during their shifts. And the public as a whole, which suffers from a misallocation of law enforcement resources because quotas prioritize numbers over genuine public safety needs, leading to inefficiencies and potentially harmful policing practices. While Maryland already prohibits some form of quotas, this bill goes a step further and increases the amount of quotas that are outlawed in Maryland. Because of that, we urge this body to take a step toward changing our culture, and we strongly urge you to issue a favorable report for this bill. Thank you for your time and consideration.
Thank you, Ms. Snyder.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to speak today. My name is Jillian Snyder. I'm the Policy Director of Criminal Justice and Civil Liberties at the R Street Institute. I'm also a professor at John Jay College of Criminal Justice and a retired police officer from the New York City Police Department. As someone who has dedicated her life to public safety, I recognize how we enforce laws matter just as much as the laws themselves. This is why we have a strong interest in House Bill 687, the Community-Oriented Policing Act. We support this bipartisan legislation that seeks to prohibit the use of quotas within law enforcement because it addresses concerns around constitutional rights, the integrity of police practices, and the goal of fostering community engagement to improve public safety. Law enforcement must be empowered to address threats to the public. However, I know from experience that quota-driven policing is not the right way to do it. Imposing quotas can lead to arbitrary stops, searches, and citations that infringe upon citizens' rights. When officers are mandated to meet numerical targets, there is an inherent risk of prioritizing quantity over quality. Mandating quotas strips officers of their discretion, compelling them to engage in stops and issue citations that might otherwise deem unnecessary. This can divert attention from more serious public safety concerns and can erode trust between police and the public, which compromises investigations, case clearances, and willing participation from the community in the fight against crime. Research indicates that restricting quotas can improve the quality of pedestrian and vehicular stops, suggesting that eliminating quotas allows officers to focus on more substantive activities. Police benevolent associations and fraternal orders of police across the country have expressed support to ban quotas. The bipartisan nature of this bill reflects a growing consensus on the issue. House Bill 687 takes a decisive step towards preserving constitutional rights, enhancing public safety, and fostering trust. I urge the committee to grant a favorable report on this bill, and thank you for your time and consideration.
Thank you. Reverend Marguerite Morris.
Good afternoon. I'm with the Community Actively Seeking Transparency, and for Kathy's sake, for which the Captain Morris Death Reclassification Act was just passed into law last year, so thank you for that. I'm here to testify in favor of HB 687. I recently did a report on the state of policing in Anne Arundel County. It references the police's Officer of the Year. The officer named Conforti, who, according to this article, was on the force for just 2 years before earning this distinction. He received the nomination from his supervisor, who noted that he averaged and combined 159 citations, safety equipment, repair orders, warnings, and or parking tickets each month. He was further quoted as saying a disproportionate number of his stops led to either registration improprieties, stolen tags, and etc. This supervisor stated that in the collective memories of platoon supervision, he cannot recall any one of his with as many handgun, arrests, or whatever through the calendar year. The quality of his work product had been nothing short of phenomenal. During this period, Cass received numerous videotaped traffic stops from across the county. Citizens reported traffic stops without probable cause, and several videos showed individuals informing officers of their rights. So how might this relate to the chosen officer of the year? Well, according to the then census, the racial demographics of Anne Arundel County were 72.3% white and 19.1% black. This officer, Conforti, gave out over 1,700 citations. More than 78%, approximately 1,342 of the citations were issued to black and brown persons in a county where the black persons only made up 19.1% of the total population. This 1,700 found in the Maryland Judiciary case search did not include the warnings and parking tickets that he may have also issued. Some of the more prevalent citations issued was for the failure of individuals on the highway to display licenses to uniformed officers on demand. Let me repeat that. Some of the most prevalent citations issued were for the failure of individuals driving on the highway to display license to a uniformed officer on demand and driving with insufficient illumination of a license plates. In addition, these records appeared to show that black and brown motorists had substantially more citations issued to them per stop than whites. This is an example of why there's a clear need for HB 0687 so that officers are not incentivized to abuse the public and then be rewarded for potentially questionable behavior. Again, this is not anti-police, this is anti-bad policing. Thank you.
Thank you. So we do not have anyone testifying unfavorable, so let's just go right into the questions. I see one with Delegate Kaufman.
Yes, thank you, Madam Chair. While they're not here in person, the Maryland Chiefs and Sheriffs Association is opposed to your legislation, of which, to be candid, I'm a proud co-sponsor. They say that that your bill is unnecessary because quotas are already prohibited under Maryland law, and that your quota thing is arbitrary. So what's the disconnect, Delegate Grammer? They say, oh, police officers aren't doing quotas, it's prohibited. And then you had two people who came to you understandably requesting anonymity, saying that, oh, we're required to do quotas and different things like that, and talking about the trinkets they get and different things like that. So where's the disconnect? Are supervisors just doing a wink and a nod, or what's happening? Because they say it's prohibited already.
What a great question. Delegate Kaufman, back in 2006, there was a delegate from Cecil County named Delegate Mike Smeagol. And there's a lot of political history about this very issue, and he fought this issue, and he brought a very similar bill. And they passed that bill. But there was a chair of this committee named Joe Valerio, and he would do this tricky thing where he would amend a bill so that it did nothing. And when they changed the statute, they inserted the language that reads like this: use the number of arrests made or citations issued by a law enforcement officer as the sole or primary criterion for promotion, demotion, dismissal, or transfer of the officer. And it's that language, the sole or primary, which provides 10 miles of wiggle room for a law enforcement officer to avoid this statute altogether. So had we passed the bill as drafted in 2006, we wouldn't have this issue. The problem is the way the current statute is defined. Like, I want to be clear, it is the intent of the General Assembly to not use quotas for the exact reasons demonstrated and articulated by my pseudo panel here. We talk extensively about minority communities and how the numbers of arrests and citations received by minority communities are so disproportionate. I think we ought to stop and ask ourselves as a committee, are we really concerned about that? Because what we've come to find after I brought this bill the first year is that we have you're not supposed to have a system of quotas. And after that first year, law enforcement officers came out of the woodwork, and what they gave us is on paper a formalized system of quotas. And I thought it was just the local jurisdictions that did it, but it's not. The worst offenders appear to be the state police. But I also got calls from every type of law enforcement down to sheriff's offices. And the sheriffs would say, we have quotas on investigations and warrants. And I would say, well, how does that work? How does an investigation or warrant a number of quotas for like warrants? And they would say, well, we have to prematurely execute a warrant. The investigation could continue, but I'm getting pressure from management to put guns and drugs and money on the table. So it is the intent of the General Assembly to not use quotas. The language is not sufficient to do that. And it is deleterious to law enforcement broadly. But I think when you continue to hear, I mean, I've been here for 11, 12 years. We hear the same arguments from minority communities, and you got to wonder, like, how is this still happening? Well, we know why it's still happening, because you're whipping law enforcement officers to up the numbers. And just to be clear, I have in my hand an email from law enforcement where the numbers produced by the highest, most effective officer are like 5 times that of the lowest. How does that happen? So I have a lot of information I'd like to share with you personally. I have text and emails from law enforcement officers all over the state that would show you some really shocking things. I know you're a sponsor on the bill, so I don't have to twist your arm too much, but I think I have a lot of information that would really help convince you or anybody else on this committee to support this bill.
And thank you. I look forward to receiving the information, and may Delegate Smeagol rest in peace.
Thank you.
Thank you. Delegate Taylor and then Delegate Erickson.
Yeah. Thank you, Madam Chair.
And then can you just pull down your mic?
Sure.
Thanks.
Delegate Grammer, you mentioned that under our former chair's reign, there was some language input into the statute that allows this to happen, okay? Did you consider just going back and maybe trying to strike that language?
I did. It's in this bill.
It is, because I was looking for it, I didn't see it.
On
so.
page 2, line 19.
Oh, solar primary.
Those brackets.
Page 19, line 19, I see it now.
Got it.
Okay, and then you added more. Thank you.
You got it.
Delegate Erickson.
Thank you, Madam Chair. So I was just looking at the state police. I don't know if you've seen it yet, but the state police wrote in just a letter of information. So, I mean, that's, I guess, a positive, but it reads a little bit more like a opposition letter, if you ask me. And they say, like you had mentioned, that they may not establish formal or informal. Obviously, the evidence you have shows that they actually have formal, not informal, and that they're rewarding people with not trinkets, but new cars.
Yep.
Okay. So, and I'm thinking in my head, I live out in like the middle of like the boondocks. There's no way that my boys out in Jarrettsville are getting new cars because there's no one to police out in that precinct. So I feel bad for my guys out there because hopefully my sheriff's office is not doing that. But if you're looking at, comparing people in, one office, but there's people that are put out in the rural areas, my gosh, who do they have to arrest for crying out loud? Anyways, their letter says on the first hand that, no, we can't do that. And then literally 2 lines down it says, but we have to do it because how else can we rate job performance? How else can they rate job performance? What else can we do to sort of say, if they do want to give people merit-based rewards, what are the other tools they have in their toolbox? To do that.
Yeah, if you look at how local jurisdictions have the frontline guys produce a work product, most of it is community-based. If you've gone out to a community association, I pray for you, it's very painful and there's a lot of talk about what's happening in the community. And in my experience, in all my community associations, Baltimore County does not use quotas for the record. Okay. The local law enforcement will say, what are you seeing and where should we focus? Because Baltimore County is short law enforcement officers. Where should we focus our resources? And for the most part, my jurisdiction uses that kind of metric. That is how this process should be driven.
Okay.
But if you read that letter, I think the question, Madam Chair, is we have to ask first and foremost, is there any one person that would say that law permits us to use quotas? And the answer to that is no. But we see even, letters of information where they say, but we still do it. It's because we let them. It's because we let them.
Have you gotten any complaints from my county? Just curious. No. Oh, good. I didn't think so, but I just wanted to have it on the record.
Okay, keep in mind, this is a reintroduction of 2024's bill. Delegate Conaway, and I'm not saying that for you, Delegate Conaway. I'm just saying to the body that this is a reintroduction.
Thank you, Chair. Thank you, Delegate, for bringing this bill. So basically, it's a reintroduction of the bill, but you took the part out that Chairman Valerio amended in?
I always try and mention that. I'm always a little short on time, but that is the problem. Everything that talks about this issue in 2006 articulates the need to do away with this process, whether it was committee testimony or bill-sponsor testimony or the way the media talked about it. They said, with this bill, we're going to do away with quotas. Well, clearly, they have not done that.
Can you be clear on what the amendment did?
So, Delegate Smiegel's original language way back in the day, and I can dig it up for you.
I was here.
You were there? You were here? Yeah, so you probably know, I probably do. As the discussion went, the policy discussion is we want to do away with this. And other states have done away with this. And they use language that's tighter. If you look at my bill, it's just a tightening of current statute. Whether it's perfect or not, we could take that up as a work product, but it's largely closing a lot of holes in language that frankly allow agencies to continue to use this process.
Just for transparency, am I a co-sponsor on your bill?
I think you are.
Oh, thank you very much.
Thank you very much.
Okay, that concludes the testimony for House Bill 687.
Thank you.
We're going to move on now to House Bill 537. Anyone who is here for any of the parole bills or any of my bills, I apologize, but we're just going to keep going down, and we're moving those parole bills along towards the end. So if you need to stretch or step out for a second, please do so, because I know you've been patiently waiting, and I thank you. Okay, Delegate Cardin, we're going to hear, this is a reintroduction of House Bill 537. Yes. We have
anybody else coming up?
Michael Davey, Mike Shire, Angelo Casolo, Clyde Boatwright, and Delegate Cardin, whenever you're ready. Thank you.
Madam Chair, members of the committee. John Cardin on behalf of House Bill 537, asking for a favorable report. This bill authorizes the police officer who's been denied a right granted by laws relating to police accountability and discipline to apply at any time before the hearing is held by a hearing board to the circuit court for a show cause order. The essence of the bill is that if a police officer believes that his rights are being violated, he needs somewhere to be able to go to ask for some relief. And this is the bill, this is the what I believe is the best possible way to do this. And that's the essence of the bill. We want to make sure that regardless of whether you're a police officer or not, if your rights are violated, you have somewhere to go to ask for relief. And I would ask for a favorable report, and I have a very esteemed panel here that can make sure that you understand the bill if there are any questions.
Thank you. And so everyone is going to have 1 minute and go.
Thank you. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on House Bill 537. This bill basically would allow a law enforcement officer to go to the circuit court prior to the hearing if he believes or she believes one of her rights under the MPAA have been violated. There's really two purposes. The one, if it's a violation of the disciplinary process, it gives them the opportunity to go to the circuit court to avoid having to relitigate the same case at another time. Basically, if a right's violated, we bring it up in the trial board. If the trial board agrees, we just don't want to have to do it twice. It just doesn't make any sense. The second issue is there's certain rights under the MPAA that simply there is no jurisdiction or venue that can be addressed. I've done a number of these cases with administrative law judges, and what we're finding is certain things in the disciplinary process or the other parts of the MPAA simply don't have the ability to be addressed. I have examples if I had more time. Thank you.
Thank you. Whoever would like to go next. Mr. Boatwright, you want to go next?
Good afternoon, Madam Chair, members of the committee. For the record, my name is Clyde Boatwright, President of Maryland State Fraternal Order of Police. My esteemed lobbyist Southside, Frank Boston, is going to be happy when I use this. For the lawyers on the panel, think interlocutory appeal. I got it right, Frank. So yes, this is simply a fix that we will welcome, and we'll stand for any questions. We stand in support for this piece of legislation. Thank you.
Thank you.
My name is Angelo Consoli. I'm the second vice president for the state of Maryland and president of Prince George's County. I'm here asking for a favorable report as well on this. As they've mentioned, this bill goes a long way towards helping officers get problems that have no jurisdiction and or that are related to an investigation adjudicated. In Prince George's County, we have a couple cases, not just our agency, with other agencies within, where certain chiefs have taken actions that are actually either improper at the time they're taking it, or they've taken discipline before a trial board is even over, and or officers have been suspended without pay at a time that we believe that they shouldn't have, and the only recourse that you would have been to do a show cause. The case in Prince George's County, the officers were suspended without pay for 9 months, and the state's attorney dropped the charges. They were put back to work before we got in front of a courtroom because we had to do a different way where show cause was not an option. So because of that, and for due process for officers, we asked that this be returned. It was inadvertently taken out of the process when we switched from the LOBR. Thank you.
Thank you. Lieutenant Mike Shire.
Mike Shire, the Maryland State Fraternal Order of Police. So I want to analogize this when you're having a disciplinary process. We talked about last year, it's like building a house. If you have a cracked foundation in your house and you keep building the house on top of it, the inspector comes along, says cracked foundation, tear it down, do it all over again. If there's a problem with the disciplinary process, the show cause allows a circuit court judge to quickly and efficiently deal with that issue so that you don't have to go through the whole process with the ALJ and come back and start over. A lot of the advocates are going to say this is a delay mechanism. It is not. Officers do not want to delay their trial boards, and history has demonstrated when the show causes were available, they're often not used because usually things do go smoothly. If there was a speedy trial demand, officers would probably use it in these circumstances, in these trial board situations. Using a show causes delay mechanism is just not something that ever happened in 25 plus years before and is not likely to happen again. So we'll stand for any questions. Thank you.
Thank you. I have one question for Mr. Boatwright. Could you repeat what you said earlier about interlocutory appeals?
Hey, I think I got it right. I think I'm playing a lawyer today.
No, you're fine.
He just walked in.
You're fine. He just walked in.
Oh, right.
Okay. Delegate Tolles.
Thank you, Madam Chair. This question is for Angelo. You know, I tell everybody here, I think you're so fabulous, and they always will come back and tell you. So now you get to hear me say it in person.
I appreciate it. I appreciate it.
But can you talk about how this bill would go a long way in terms of retaining and your hiring process? Because I don't know, well, I know we probably are short officers in Prince George's. What that means in terms of, you know,
I mean, it goes a long way because it shows the officers that there is a, due process and a fair process that we face. We got everything when they did police reform. We created the boards that we did, but there were some facts that were in the LAOBR that were not brought over. It wasn't intentional. It was just that they were in sections that nobody was concentrating on at the time. This happened to be one of the things that was left off. And all the discussions we had from when we did police reform, I don't ever recall anybody discussing wanting to get rid of this or do away with it. It's a process that's used, and it's usually fairly quick that it can get done. We've had them in the past, and when you go in front, what it does is it allows you to go in front of a judge, get a judge to sit there and say, yes, you're right, no, you're wrong, here's the remedy, here's what needs to be done, before you actually get to a trial board and do them. What made our process great at the time was it allows you to then get through the trial board, through everything, and then the officer, if he's terminated, he's done, he's gone. He gets his appeal to the circuit court, but only on whether or not there was any violation of rights. It had nothing to do with the process. But if you look across the country, all these other places that have the ability to fire quicker or do like this without the show cause, when I sit there and say you did something wrong, I can now appeal to the court. When I appeal to the court and the judge agrees with me, guess what? 2 years later, I'm getting my job back, and or they got to put me back in place and retry me, this time the right way, because they can't use the evidence that was against me, and you have an officer that you thought was fired now getting his job back. So that was the one added benefit also, that it might, even if it did delay the process slightly, at the end of the day, when the officer was gone, he was gone for cause, and he wasn't coming back. And that's the process that I think we should put in place. You don't want to have someone be reemployed that you thought you fired for cause because a mistake was made that could have been remedied, and we didn't use the proper remedy.
Okay, just a follow-up question for anybody in the panel. Could you talk about the fiscal impact it has on local jurisdictions when you have to, have somebody?
There really is no fiscal impact. Most of the agencies have either a assistant attorney general, or they have their own in-house counsel, or they.
I'm sorry, I meant for the officer.
Oh, for the officer?
Yeah.
Most of the officers, a great deal of them are on retainer with a law firm, and that law firm would take care of it. I've been doing this.
Are you talking about the lost pay issues?
Yes.
Oh, I'm
Okay.
sorry. Okay.
So you have officers like Mr. Consoli just said, that they're out of pay for 9 months outside of the law. What are they supposed to do to support their families? And then 9 months later, so now all of a sudden they're being reinstated, but every other officer, and this goes to what you're saying about retention and hiring, every other officer sees how those officers were treated and how unfairly they were treated, and they're like, I can't risk 9 months, and I've got this other job offer over here. I can't risk 9 months getting suspended without pay. I'm just going to leave the profession. Or you've got somebody coming into the profession that says, look how you treat your officers. You suspend them without pay for 9 months. Outside of the law, you weren't supposed to do that, and there's no way to fix that. Never mind, I'm going to try a different profession.
Can I add just one thing to that? It also impacts the officers' health care, and that now impacts the families. If an officer's out of pay status, then they're no longer able to be covered. So that there is a significant impact that officers face when they're suspended without pay.
Thank you. And Madam Chair, just a quick follow-up, because I've been gone at my own hearing, so I'm catching up on some questions. Thank you. I have some in the bank saved up. Just a follow-up. If you have, we've had instances in Prince George's County where the county has, like you indicated, that the case has been dropped, and then, the county has settled and paid out officers even after they've, been dismissed in court. How does that play into this particular bill? Maybe no, it does not play into it at all. That Delegate Carton is saying it's not have anything to do with that.
No, I'm not think that's the same
It
thing.
won't impact that.
No.
And I think case I'm referring to where the county paid out, and then the officer ended up being, I think he got in trouble for something else, but in this, whatever, the situation where he was suspended for.
I think that's
I don't think that would
Yeah, I
apply
think that
in
was
this case.
separate, yeah.
They're separate, okay.
And then when it comes to like the suspensions that we're talking about where you would do a show cause, the only thing it would is it could have ended the suspension right then and there, and that's a different issue.
Okay, all right, thank you. Thank you, Madam Chair.
You're welcome. Delegate Valentine.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill again this year, and as well as to the entire panel. My question is specific to Mr. Davey as well as Mr. Shire, and both because you both touched on it in your testimony. I want to give you the opportunity because I know you were limited in time with regards to examples of when this would be used, and also maybe for Mr. Davey, in the past when it had been, or examples of when it was used before the elimination of LEOBR, of how it was utilized then with all of your experience in this field.
Sure. So we'll start with currently under the Police Accountability Act, there's no mechanism for us to go to circuit court. I had a case last year in Cecil County where an officer was investigated for misconduct. The case went to the Administrative Charging Committee, and they recommended a demotion and a 10-day suspension.
Okay.
The officer on that day signed a document indicating he was requesting an administrative trial board, consistent with the law. The chief at that time said, we're not waiting. They demoted the officer and suspended him without 10 days before any due process. So if we had the ability for a show cause, I would have filed one in the circuit court and explained to the judge that they're violating his rights to not having a trial board before the disposition of the charges, the administrative charges. Unfortunately, I don't have that ability now. And making a motion to the administrative law judge or the retired judge, they have no jurisdiction over that issue. The only jurisdiction they have is the trial board itself. So they're not going to get involved in whether a chief violated the policy or violated the law prior to that trial board. Unfortunately, I've had it happen once or twice now. We also have issues where if a case should go to an administrative charging committee, but the chief elects not to, I have no remedy for that. There's nothing I can do about it, because what we could have is if the case by law should go to the administrative charging committee and it doesn't, I don't know what recommendation of punishment or whether they would charge or not when the chief did it. So, but there's nowhere to go. We're basically stuck with nothing. There are other examples in the Police Accountability Act as it pertains to regulating secondary employment. If a chief unfairly or unreasonably regulates secondary employment, there's nowhere for me to go. Unless they have a collective bargaining agreement where they have a grievance procedure, I might be able to do something. But if they don't have a collective bargaining agreement, and most agencies don't, the final say in that grievance is by the chief who unfairly regulated. So we need an opportunity or a venue in order to resolve some of these issues.
To be heard.
Yes.
And the big one for this committee, we heard testimony earlier today about police officers being able to file complaints against other police officers, against problems that they see in the agency. Well, there's whistleblower protections within the Maryland Police Accountability Act. But if a chief can illegally punish, either discipline, suspend, or otherwise an officer who whistleblows, and there's no remedy to fix that, do you think it's likely that other officers are going to continue to whistleblow against the bad actions of their agency? So in a large sense, we're asking you, please provide some protection for our officers who are trying to do good work out there for the communities and those that they serve.
If I could just add also, the opposition to this bill will say it's just used as a delay tactic because it would generally pause the trial board while we're waiting for the circuit court to hear the case. I've been doing this for 26 years. I've probably done over 400 trial boards. I filed 10 show causes in those 26 years.
And can I ask you one last question for this panel? Has it been your experience that officers want these type of matters delayed for extended periods of time?
They absolutely want them resolved as quickly as possible.
Thank you, Madam Chair.
Thank you. Delegate Boucher, excuse me.
Thank you, Madam Chair. Since we're talking about jurisdiction, the judiciary takes exception to Anne Arundel County Circuit Court being the show cause jurisdiction for statewide and bi-county law enforcement. What is the rationale behind that, and are you amicable to amending that to comply with what they want?
So under the Police Accountability Act today, if an officer goes to a trial board and he's found guilty, he has the absolute right to an appeal to the circuit court in his jurisdiction, his or her jurisdiction. In the law, it says that if you are a statewide agency, Maryland State Police, Transportation Authority, MTA, the legislature through the bill said that all of those cases for statewide agencies would be appealed to Annapolis. They wanted one jurisdiction to handle that. If the incident happened in Baltimore County, we'd go to Baltimore County Circuit Court. This bill basically is in line with the current law, because this basically be, if it's a statewide agency, state police, MTA, MDTA, it would go to Annapolis, but if it was in Baltimore County or Howard County, it would go to their local jurisdiction. This bill simply is trying to keep the locations or the jurisdictions in line with the current law.
I appreciate that, but I'm wondering why the judiciary would contradict that and say it conflicts or causes conflict.
I don't think it causes any conflict. It just, there's a lot of statewide agencies, and I think they may be concerned that they might be overwhelmed having to deal with that many agencies. It's statewide agencies and by-county agencies. And I think it's Maryland National Park Police is one. That would go to Annapolis. It's the way
So there's already precedence for
this.
All right, thank you.
Yes.
Okay, thank you very much. Seeing no further testimony, or no further questions, excuse me, we have unfavorable, a panel, which we're going to call up. We have one person testifying virtual, Deborah Levy, okay, and Andrew Bright. And Mr. Bright, we're going to start with you, and then we'll hear from Deborah Levy.
Very well, thank you.
You'll have a minute. Thank you.
For the record, Andrew Bright, legal advisor for the Washington County Sheriff's Office and here for the Maryland Sheriffs and Chiefs Associations. Start with a couple of points of agreement. We're all in agreement that we want every officer who is accused of misconduct to receive due process. We agree with that. We also want all cases to be handled quickly and expeditiously, efficiently. However, I think that may be where we part ways a little bit. Giving an unlimited right to an interlocutory appeal in the middle of a case will have the effect of creating massive delays in certain cases. If you look back to the cases under LEOBR, several of them are reported. A quick search on Westlaw will point to many cases that went on for more than 2 years of delays before they came back. For these and other reasons, we would oppose this bill.
Thank you. Deborah Levy.
Thank you very much. Good afternoon, Chair, Vice Chair, members of the committee. My name is Debbie Levy. I'm here to speak in opposition to House Bill 537. This bill is really seeking to resurrect the Law Enforcement Officers' Bill of Rights. It's problematic for several other reasons. First of all, it's just not necessary. The bill already allows for an appeal within 30 days. And as Mr. Davey said, if you're in a multi-state or a multi-county jurisdiction or all state, you can go to Anne Arundel County and everybody else goes to their particular circuit court. Opposition from law enforcement today talked about saying we don't need another administrative charging committee. We can't have multiple proceedings. And this is exactly what this bill would do, create multiple proceedings and cause unnecessary delay. It's way too broad. It says that if an officer claims a right is being infringed upon, but 3-106 doesn't actually confer any right to anybody except for the complainant. The right the bill talks about, or the law already talks about, is the complainant's right to attend. This is way too broad, and it's just an end run around the year and a day timing provisions so law enforcement officers don't have to face discipline.
Thank you. Do we have any questions? Okay, seeing none, thank you very much. That concludes the testimony for House Bill 537. We're going to move now to House Bill 309. Delegate Cardin. We're going to call up, do we have any? Let's see who we have. Yep, we have witnesses. We're going to call up Dave Rose, John Hadaway, Catherine Greenbeck, Jessica Murphy.
Ms. Murphy got tied up at work, so she won't be here.
Okay, and Delegate Cardin, do you want me to call up favorable with amendment?
Yes,
Sarah
please do.
Semple?
You want to come up?
All right, whenever you're ready, Delegate Cardin.
Thank you, Madam Chairman.
This is not a reintro, so you'll have 3 minutes and everyone else will have 2.
Thank you, Madam Chair, members of the committee. John Cardin on behalf of House Bill 309 asking for a favorable report. I also have with me my legislative director, Matt Horn, who has personal experience here. While he remembered to sign me up, he did not remember to sign himself up, but I usually don't take my 3 minutes, so maybe he can chime in. This passed in the Senate overwhelmingly, I think unanimously. It has absolutely no opposition. And basically what it does is it provides the necessary confidentiality protections for peer support teams across Maryland, enabling officers, police officers, to come forward in times of crisis without fear of exposure. And I thought this is actually directly out of Mako's testimony, I believe. Not only can HB 309 fortify these employees in a way that supports better outcomes for our community, but can also create a team environment that relies on prioritizing mental health, trust, and support. And there's a great deal of crossover between corrections and law enforcement workforces, which is why considering their needs together will make them both stronger and independent agencies. Again, no opposition, already passed out of the Senate unanimously. I'm going to ask if Mr. Horn
Why don't we go to him with questions, and then that way he can give his testimony then, because he's not signed up, and I'd like to stay as much into protocol as possible.
Sure.
So whoever would like to go next.
Hi, my name is David Rose. I am the president of Baltimore County Fraternal Order Police Lodge 4, and I'm seeking a favorable report on House Bill 309. In May 2018, following the tragic death of Officer Amy Caprio, our department began informal peer support meetings on the second floor of our office. These gatherings provided a vital space for officers to come together, grieve, and offer mutual support at an incredibly difficult time. Over the years, we recognized the need for a more formalized structure to ensure the well-being of our officers, and we established regular peer-to-peer meetings that we have monthly at our office that is attended by officers in a department, peer support counselors in our agency, as well as guest speakers from around the country and state. And while these meetings have proven invaluable, one concern we've had consistently raised by our officers is the fear that their confidential communications with the peer support officers would not be protected, and many officers are reluctant to speak freely about their personal and professional challenges that they face, fearing that their words may be disclosed to management, who does not need to know what they're talking about. So the establishment of legal protections for confidential peer support communications, as outlined in House Bill 309, is essential in addressing this concern and ensuring our officers can engage in these critical conversations without fear of reprisal or breach of trust. Currently, this protection exists for EMS and fire in the state of Maryland. That bill and this law and this protection exists within those agencies in their peer support groups. We're simply asking to be added to have the same confidentiality that already exists with the fire and EMS employees that we work sometimes side by side with on the same scene, seeing the same things, the same critical incidents. They can then talk to a peer support counselor and their conversations would be protected, but the officer cannot, because those conversations can't be protected. So I urge you to respectfully vote in favor of 309 as written. Thank you.
Thank you. Whoever would like to go next.
Good afternoon. I'm Lieutenant Catherine Greenbeck. I'm speaking on behalf of Baltimore County FOP Lodge 4. I'm a 23-year veteran of the Baltimore County Police Department, and I currently serve as the commander of our behavioral assessment unit, which includes the peer support and wellness team. I'm speaking today in strong support of House Bill 309, which will provide legal confidentiality for communications between police officers and their specially trained law enforcement peers. Situations and demands that are specific to the field of law enforcement result in unique stressors and often trauma, which can cause both acute and cumulative stress reactions. Law enforcement peer support programs strive to support police officers who are in crisis, utilizing shared experiences and trusted human connections to mitigate the effects of all forms of stress to which police officers are routinely exposed. Dave Rose told you about the informal peer-to-peer support group that FOP Lodge 4 started after our devastating loss of Officer Amy Caprio. The police department itself also recognized this vital need to bolster the mental wellness of our first responders and created a formal peer support and wellness team, which offers moral support, emotional support, peer counseling, and access to programs that focus on officer safety, wellness, and resiliency over multiple platforms. Research, including that conducted by Dr. George Everly, who provided written testimony in support of this bill, shows that interpersonal support is the best predictor of resilience in the face of what police officers are exposed to on a daily basis. Confidentiality is crucial to the success of any peer support program. And in our department, peer support members are not therapists or licensed mental health professionals. Currently, Maryland law does not provide privilege for communications between our police officers and their law enforcement peers, as is currently enjoyed by Maryland's firefighters. I respectfully urge you to issue a favorable report for this bill, and I thank you for your time and consideration.
Well, you're with amendment, right?
Okay. Good afternoon, Madam Chair and honorable members of the committee. My name is Sergeant John Hadaway, and I am here on behalf of Baltimore County FOP Lodge 4. Thank you for hearing our testimony on this important bill today. I fully support House Bill 309. I am a 24-year veteran of the Baltimore County Police Department, an Army veteran, and currently serve as the Peer Support and Wellness Manager for the Baltimore County Police Department, helping our over 2,000 sworn and professional staff members with their mental, physical, emotional, and spiritual health. Research in the Journal of Traumatic Stress shows that law enforcement officers face an average of 178 critical incidents in their careers, far more than the typical 2 to 4 incidents a person typically encounters in their lifetime, creating a serious mental health strain for officers during their careers if the proper support is not in place. Over the last several years, police reform has been a priority for the legislature, as we've heard many times today. But in many cases, officers' unprofessional or illegal behaviors could have been prevented if the stigma surrounding mental health had proactively been addressed and proper support was available. Unfortunately, too many officers are still afraid to seek help due to concerns about confidentiality. They fear their struggles will be leaked to leadership, lead to court testimony, or even be discovered by their family and colleagues. Confidentiality is key to helping those who are struggling, allowing trained peer support team members to provide a safe and trusted space for disclosure. In addition, confidentiality does not hinder the mandatory reporting of immediate safety concerns, criminal activity, and abuse. Thus, confidentiality does not serve to conceal any improprieties that would negatively impact the community and profession. House Bill 309 will provide the necessary confidentiality protections for peer support teams across Maryland, enabling officers to come forward in times of crisis without fear of exposure. This is crucial in encouraging officers to seek help, foster a healthier and more supportive environment, and make the bond stronger with the community. I urge you to vote favorably for House Bill 309. Thank you.
Thank you to the chair, members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendment House Bill 309. So I think this is a really great bill. We were really happy to see this. Our only amendment, and so I can be really short, is that we want to add corrections officers to this. They experience comparable levels of trauma as law enforcement agents, and also we have seen that the stress that they experience, there's research that shows us that they live on average 20 years less than an average individual. That has to do with the complications of the job that they're doing. And we also know that sometimes going to a supervisor or a doctor is sometimes more intimidating than going to a peer. So we think this could be sort of a gateway to them getting more intensive help if they need it. So that's why we would support with amendments on House Bill 309.
Thank you. I'm going to start to my right, and we're going to start with questions. And Delegate Cardin, I'm sorry, I forgot your aide's name. Can you say it one more time for me?
Matthew Horn.
Okay, Mr. Horn, I'm going to ask you to submit your testimony, please, via email. Just send it out to us by email, and that way we'll get a chance to look at it, okay? Okay, thank you. Delegate Simpson.
Simmons. Simpson is over there, I think.
You know, I do that once a year. I have to do that once a year. Okay, Delegate Simmons.
I look better. Thank you, gentlemen, and thank you, ladies, for coming out. We really appreciate all the hard work and advocacy to our law enforcement agencies. Two questions around this. Does this allow for, or can you tell me how this is related to short-term disability being one, and also workman's comp? Do you see that is it a possibility for officers to utilize those for relief?
I don't think it's related. I'm not sure. This is really about, so the idea behind this bill is to make sure that that the officers feel comfortable speaking to their counselors or to their peers.
Right. So as a result of them talking to their counselors and their peers, and if it escalates to a point where they need to exercise workman's comp, does it allow for it?
So you want to go ahead?
Or short-term disability.
So further, this is looking to be preventative on the front end, being able to speak with your peer support counselors.
Sure.
But if there is a more serious underlying problem that the officer might need to have, step out and seek, greater, more intense, more professional counseling, they would be able to do that. And that's either taken through, sick time or, personal leave time. And really short-term disability, at least in our jurisdiction, that would never come into play. You would have to file a workers' comp and have some sort of injury or illness that's permanent or some kind of injury at a workers' comp, but this is not for that at all. This is basically, I was involved in an incident where another officer and I had to handle homicide, and it was very traumatic. And
Is that
I'm
like
having,
PTSD?
I wouldn't even go that far.
It's not?
Let Sergeant Hadaway speak on it a little bit, but it's basically, I'm having some issues with this incident, and I'm kind of short at home. You know, do you have anything that we could
So
talk
is it
about?
coping? I don't understand.
Yes.
So it's a way to address people who are struggling or in crisis proactively. So if you're having trouble at home, if you've been involved in a critical incident, it's a way for us to be able to speak with them, and then we can help them either triage to a higher level of care, which would be that licensed clinician or mental health professional, or we help them get through whatever their issue is with resources.
There is nothing in this that precludes or prohibits anybody from using their employee assistance program or utilizing whatever other assistance that is available through licensed mental health professionals. But law enforcement, historically, law enforcement personnel historically see a stigma associated with reporting mental health needs, because historically, in the past, if we reported to our supervisors that we were struggling with a mental health issue, the first thing that would happen is that they would take our gun and badge from us and
That's
take us
correct.
off the road.
Yeah. Mhm.
So this is, peer support programs everywhere are really designed to provide a level of support, again, with people who have shared experiences to each one of us, people who understand what we've just seen and how we might be feeling about that. And connections with people that they can trust and they know that they can trust. Whether that's a legitimate thing that they can't trust another person is really not even the point. It's that the perception of a lot of police officers is that I can't trust another person not to report it to my employer. I can't trust another person to not mess with my career.
Sure, is that not built into the FOP, as they rep? Like, is that system is not already built in advocacy and counseling?
Go ahead.
We have it, and we have these meetings at our office, and they're, group meetings. I don't want to use the term AA, but you understand.
Yeah, I understand
everybody.
the concept, yeah.
So, but if I, at the end of that meeting, say, John, I like the conversation here. I'd like to talk to you about something a little more in depth, and I need some direction. Under this bill, I can have that conversation with John, and it's...
Now, in what capacity is John? Is John
He's a peer support.
superior officer?
Yes.
Superior officer.
Yeah.
Okay.
And that conversation would be confidential, and he could direct me or help me get to other resources or get in contact with similar people who have gone through the same similar type issue to get with them to try and get through mine without a supervisor coming up and going, what was your conversation with Dave Rose about?
Okay.
Because right now, they're not going to have that conversation because they're afraid that's going to happen. So we want to make sure that those conversations are happening. That's the idea.
And understand these specially trained peer support officers, they are assigned all throughout the department in different places, at least in our department, and they do receive training for this. This is not just me talking to my buddy. This is going to someone who has received special training in, it's critical incident stress management type of training.
Sure, but my concern is this, is that as a superior officer, if you're approaching whatever capacity, if you make the decision that that person that you're talking to is going to escalate, there's no way, I don't see any circumstances where you can not escalate that complaint or further that conversation that's being had for the greater good of the public, right?
There are provisions in the bill.
I'm sorry, hold on a second, I wasn't finished.
Okay.
So the idea behind a superior officer taking any form of verbal from someone that's going through something, and all officers do, I've been through it. You know what I'm saying? So, and at no time did I feel that if what I'm saying is totally off the record. Because if I'm talking about something that's going to escalate or going to turn into a domestic or is going to turn into a murder-suicide or any of those type of things, as a superior officer, you have to report it. Right. And you have to take immediate action because that gun is that officer. So I don't understand. I just wanted you to make it make sense to me what you're trying to get to.
And so that's excluded as part of the bill. So anything where there's an immediate safety threat to either themselves or others, or there is a crime that's been committed, such as abuse or something of that sort, that's all mandatory reporting. So essentially, if I'm walking through a police station because we're proactively out in the field and somebody says, hey, you know, I had a baby death last week and I've really been struggling with it and it's affecting my home life and it's affecting my sleep, then now we can talk to that person and try to help them process that experience, try to help them work through it, and we can give them resources, or we have our EAP clinician is actually here today, Ms. Hubbard-Pinot back there, and I can then triage that person to our EAP clinician who is a licensed mental health professional.
And as a supervisor, if one of my employees comes to me and expresses something that makes me feel like they are not safe in their job, I will 100% still be able to send them for a fitness for duty or suspend them at that time so that they're safe, so that they remain safe and the community remains safe.
Page 2, lines 12 through 20 or 21 talks about all the exceptions. Potential suicide, explicit threat, imminent serious bodily harm, information relating to abuse or neglect of a child, a vulnerable adult, admission of criminal contact. All that is excluded from the confidentiality.
Thank you. Delegate Phillips.
Thank you, Madam Chair, and thank you, panel. Thank you, Delegate, for bringing this. Since, Madam Chair, is it okay, since Mr. Horn is at the table, if I can ask him his experience?
The problem is that we had an incident last week where someone wasn't signed up and they weren't allowed to testify. Okay. So I'm trying to maintain protocol. Thank you.
All right. My question is this. Couldn't this be done with policy within the department? If we have a process almost like creating a policy that would make those correspondence communications more like a HIPAA communication, where the peer counselors are then communicating potentially with EAP?
So I'm going to leave this to Mr. Rose, but
is there a reason we can't do it that way?
So I think that the stigma of it is very, very serious. And everything that we can do to show the officers that they should feel free to relate information and feel comfortable about it, we should do. So I worry that, if it's a policy, then, everybody, oh yeah, it's a policy, but, that the people talk. Well, if it's in the code, then I think that there's a degree of confidence that far exceeds, police policy. That would be my comment. So.
Policy gets violated all the time. It gets violated by officers. It gets violated by management. So in the same situation where I spoke to Sergeant Hadaway about an incident and a colonel or major or chief said, I want to know what he said, which would be in violation of policy, there's no remedy after that. There's no remedy. This would codify into law, and as I said earlier, would only give us the same peer confidentiality that already exists for the other half that we work with hand in hand on a critical incident scene. And once that bell is rung and Sergeant Hadaway is ordered to disclose what the conversation was, there's no way to put that toothpaste back in a tube.
Fair enough. And I'm a Baltimore County delegate, and so I appreciate the fact that you all came together after Sergeant Caprio's death. So, and I understand.
Thank you.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. I was wondering, when looking for stress, as you were describing it, does the officer come forward and say, I feel like I'm under stress, or is it a normal routine to ask them questions like once a month, or by what method would you use?
So officers can come forward themselves and request help from peer support. I want to make sure I'm clear on your question. They can come forward as a supervisor if my people, and it's already happened many times, that my people experience something that's quite traumatic for most anyone. I will talk to them and ask them how they are. I will also contact Sergeant Hadaway and say, hey, my people have experienced this situation. Can you just touch base and see if they're interested in talking? And they're able to do that as well.
And then if they talk, how can you tell if they're experiencing too much stress?
Well, that comes through the training.
We have special training through the International Critical Incident Stress Foundation, Instinctual Trauma Response, Acute Stress Adaptive Protocol, Crisis Intervention Training, and Power and Peers training through the FOP.
Okay, I was wondering, do you use life change index scale? Do you use that system?
No, that would be something if we felt that they're experiencing too much stress, we would then triage and refer them to our clinician, our licensed clinician.
Do you know what I'm talking about?
I've heard of it, but I'm not overly familiar with it. Yes.
Okay, thank you.
Delegate Erican.
Thank you, Madam Chair. Thank you guys for being here. So my question is about the confidentiality piece and how that would impact AG or IA investigations.
In short, it would not.
Okay.
So if me and fellow officers are involved in a critical incident, homicide, shooting, we've had several mass shootings in the last couple of years. Let's say I was an officer that discharged my weapon. I would have conversations with Sergeant Hadaway about, I don't know what I'm going to do, how am I going to talk to my kids, how am I going to explain this to my wife, they're going to see it on TV. Can you help me get through that? Can you help facilitate that meeting? I'm not going to have any conversations with the peer support person about the actual details of why I shot my weapon or something along those lines. That's for the AG investigation and internal affairs, if it's another type of scene. This is basically help me cope with getting through this and help my family get through it, because when an officer goes through an incident like that, it's not just the officer going through it. You're going home, and you're taking this home, and your whole family's dealing with it, if you want to elaborate.
When you experience something, it's typically not going to process for you for the first probably up to 72 hours. So you're still going to work through it for the first 72 hours you experience it. And once it comes to that point where it hits you and you're at home, now you have to explain what's going on stress-wise to your family, to your children, and everybody else. So we try to mitigate that by giving them, right after the incident happens, we work with the FOP and the attorneys and the AG and everyone, and we have the piece where we kind of give them what they may experience and some stress mitigation techniques. And then about 72 hours later, we follow up with them once they've had time to process and work through everything. And then we start to triage and decide what course of action needs to be taken. Are they processing it appropriately, or do they need a higher level of care?
Okay, all right, that makes sense to me. So there's not going to be any impact on external investigations. And Matt, I'm sorry I didn't get to testify. I know you have some lived experience, so I'm looking forward to your email.
Thank you.
Thank you. That concludes the testimony for House Bill 309. We're going to move now to House Bill 238. Delegate Cardin.
Okay.
This is a reintroduction, so you'll have 2 minutes. Your witnesses will have 1. We're going to call up Abigail Teese, Michael Davey, Michael Shire, Sarah David. See how many people we can fit in. We probably have room for 1 more person. Andrew Bright, unless there's anybody else. Okay. All right, this will be our first panel, then we'll move on to our next panel of favorable. And Delegate Cardin, whenever you're ready.
Thank you, Madam Chair, members of the committee. My last bill of the day, House Bill 238, asking for a favorable report. This bill provides clarification as to when a law enforcement agency is required to file administrative charges arising out of an investigation of alleged police misconduct. And it essentially says that you have to file the report within a year and a day In the years past, this has passed out of the Senate consistently, has been held up here. There has been support for it here. It has been a priority, not only for the FOP, but for the chiefs and sheriffs as well. I don't know if it's their #1 priority this year, but it has been in the past. It's already passed JPR again this year. And the opposition suggests that, well, if you read the opposition, they misunderstand that this is not, well, it helps, I can't read my own writing. If you read the opposition, it doesn't, their opposition doesn't necessarily make sense as to why this is absolutely needed, and I will have my panel continue because, and then I'll read my gibberish and figure out what I was trying to say when you answer your question.
Very good. Okay, thank you, Mr. Davey.
Thank you. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on House Bill 238. This bill is simply cleanup language from the Maryland Police Accountability Act. A major concern back in 2021 was that these internal investigations were taking too long. They were dragging on. The Maryland Police Accountability Act right now has a time limit of 1 year and 1 day from an incident that comes to the attention of the police department. But that only applies to those cases that involve the public. There is nothing in there about those internal cases that need to be addressed. This bill would just make all complaints once they come to the attention of the appropriate law enforcement official. They have 1 year and 1 day to charge or not charge the officer. Disciplining an officer 2, 3, 4 years after the incident really doesn't do anything. It doesn't correct improper behavior. There is another portion of this bill that talks about an exemption for criminal allegations, and I would leave that up to my colleagues from the State Prosecutor's Office to discuss.
Very good. Thank you. Next.
Good evening, Madam Chair, members of the Judiciary Committee. My name's Abby Tixay, and I'm a Senior Assistant State Prosecutor responsible for prosecuting police misconduct throughout the state. I'm here on behalf of the Office of the State Prosecutor to ask this committee for a favorable vote on House Bill 238. We would like to thank Delegate Cardin for his leadership on this important legislation. In the criminal world, deconfliction is common and important to protecting criminal prosecutions. We deconflict with the federal government, state partners, and administrative agencies so as to not duplicate efforts, which creates problems with witness statements, criminal discovery, and a host of other issues. Deconfliction is super important in police cases. If there's an administrative investigation, the department may compel a police officer's statement, which means that statement does not have the Fifth Amendment protections, and that statement and anything derived from it cannot be used in criminal investigations or prosecution, meaning that any person who's exposed to that statement, including victims, witnesses, or even jurors, cannot be interviewed by criminal prosecutors or investigators, which can prohibit prosecutors from proceeding with criminal charges. The fair thing to do is to treat this administrative investigations like others and stay pending criminal investigations.
Thank you. Next, Ms. David.
Hi, good evening. My name is Sarah David. I'm Deputy State Prosecutor at the Maryland Office of the State Prosecutor. Just echoing Ms. Tixay's statement as it relates to what deconfliction means. That means generally in the criminal world, we stay investigations when our office is investigating something, so you're not having multiple people asking multiple questions. And as Ms. Tixay alluded to, there are no Fifth Amendment protections for police officers in their administrative proceedings, but there definitely are in our cases, meaning that if the administrative investigation is going on at the same time, it can result in us not being able to prosecute that officer. And having to explain that to victims and other people who are exposed to that statement, especially since our office has expanded to have a special sexual assault unit, is re-traumatizing for the victims, having to go through simultaneously an administrative investigation, sometimes at the same time as a criminal prosecution, and then sometimes having to be told, we can't prosecute this case at all. So thank you for considering this important legislation.
Mike Shire with the Fraternal Order of Police. In favor of this legislation. We are in favor of the tolling provisions because, as I said, the FOP has been and continues to be and will be in favor of proper accountability. I want to highlight the fact that without this provision, you can have a violation, might even be a minor violation, that does not involve a member of the public hanging over an officer for years and years and years. That creates the possibility of that allegation being improperly used later on. We have statutes of limitations across various laws for a reason. It prevents charges from going stale. It allows evidence to be presented and not be lost, and testimony to be available. It's just a basic due process right. So we do ask for a favorable report on this, and we'll stand for any questions.
Good afternoon. Once again, Andrew Bright on behalf of the Maryland Chiefs and Sheriffs. We do support HB 238. We believe it fills in 3 important blanks. One, what to do if a citizen takes a very long time to initiate a complaint. It sets a statute of limitations and prevents it from stretching out, in theory, ad infinitum. Secondly, it sets a period of time for fully internal cases, ones that do not involve a member of the public at all. It sets the year and a day rule. It makes sense. And third, it clears up a problem under the PAA for us, the ambiguity of how do we keep the administrative case on hold while the criminal prosecution, if there is one, grinds on. It takes away that ambiguity and makes the course of action very clear. So we would support House Bill 238.
All right, questions for the panel? Delegate Williams.
I just wanted to, Ms. Tice, I know you got cut off a little bit there in your statement. I didn't know if there was anything else that you wanted to add to what you were stating earlier.
Thank you, Delegate. The only other thing I would add is that sometimes these investigations take years and years. Sometimes the course of conduct committed by the officers takes years, and then we have to review their phone, victims' phones, and other electronics, which can take months to download and review. So again, we would just ask for a favorable vote. Thank you.
Okay, thank you.
Any other questions? Seeing none, thank you all very much. We're done with this panel. We're going to go to the next panel. Sean Malone, Daniel Franklin, Clyde Boatwright, Dara Johnson is favorable with the, well, actually, Ms. Johnson will keep separate because you're favorable with amendments. So we can take this next panel, of which there are 3 people, and go from there. Whoever would like to go first?
Prez. Thank you. Good afternoon, Mr. Chair, members of the committee. For the record, my name is Clyde Boatwright, President of Maryland State Fraternal Order Police, and I want to say ditto to the first panel.
Daniel Franklin, Chief of Police Morningside. I'm also here for Maryland Chiefs and Sheriffs. We're testifying in support, favor of House Bill 238. Very quickly, one of the most important things this bill does is defines that when a allegation of police misconduct is reported to the agency, that is when the timeline begins, 1 year and 1 day. This is for cases that don't involve an ACC or PAB right off the bat. It establishes a very strict standard, which is in line with the rest of the Police Accountability Act, and it also makes absolutely certain that there is a light at the end of the tunnel for investigations on both sides. So for all these reasons, I ask for a favorable report.
Good evening. Good evening. On behalf of the Maryland State Attorneys Association, testifying in support of this bill. Lines 16 to 27 try to protect criminal cases against Garrity versus New Jersey, where the Supreme Court ruled if a statement is compelled against an officer, it jeopardizes that criminal case. Under the current law, agencies are put in a difficult position as they're conducting an internal investigation. If they order the statement of a police officer, that sets up an argument for defense counsel in the criminal case that there's fruit of poisonous tree and it can spoil that case. It's a common sense provision. I thank the sponsor for putting it in. Urge favorable report. Thanks.
Questions? Seeing none, thank you all very much. We go now to favorable with amendments. Dara Johnson from the ACLU and Sarah Sample from the Maryland Association of Counties.
Thank you to the chair, members of the committee for having me. My name is Sarah Sample, here on behalf of the Maryland Association of Counties, and we're here to support with amendment House Bill 238. We think this is a good bill. It clarifies the tolling provision. I just want to point out to everyone that the independent report that GOCAP did said that, the way I read it, that every single PAB, ACC, and law enforcement agency brought up the tolling as a concern. And then we've also seen in a number of the PAB reports that are required annually that they are also reiterating that this is a concern. But the only amendment we have is that we talked about this earlier on House Bill 139. We want to make sure that there is sort of a delineation between the investigation timeline that the law enforcement agency has to do and then the timeline that the ACC has to basically go ahead and review and ask for or issue subpoenas and ask for additional documents and so on. So as a vehicle, we were hoping to add that amendment to this bill, but we support it. Thank you.
Hey, hello again. My name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland. So while we maintain that just eliminating this arbitrary deadline would be best, we support this bill if our additional amendments are accepted. Our main concern is that ACCs currently lack the time to sufficiently consider each case, as they often do not receive a case until right before the deadline, which can result in it being dismissed or closed solely for procedural reasons. So this could be addressed by amending the deadline to run through the case's presentment to an ACC so that they have at least the provided 30-day period to review, regardless of how long an investigation takes. This language should also be amended to avoid creating a shorter deadline unintentionally in certain cases by setting the start of the limitations period as either the date a citizen-involved complaint is filed or the date the official becomes aware of the incident, whichever comes later. Finally, use of force cases should be exempted, as was the case under the LEOBR, and the deadline should be told pending the judgment of any related civil suit to offer sufficient time for consideration. So with that, we are favorable with amendments.
Are those in your written remarks? Do you have written
Yes,
remarks that you'll, okay, good. Questions? Seeing none, thank you very much. We'll now go to those people who are here unfavorable. Two of them are virtual. Melody Mitchell from Out for Justice, Debbie Levy, and Jesmond Riggins. Mr. Riggins? I'm sorry, Miss Levy, go ahead. We'll start with you.
Oh, okay, thank you. This is Debbie Levy from the Office of the Public Defender. We're here to urge an unfavorable report for House Bill 238. This bill is too ambiguous. So there's, first of all, no definition of who the appropriate official employed by a law enforcement agency who becomes aware is. So already we find that police departments, if you look at my written testimony, we give examples of the ACC in Baltimore City saying Baltimore City's delaying giving us information. So already we're having trouble with timelines, and there's more ambiguity created by this statute. And the second thing is that we're seeing, at least in Baltimore County, where they entered into an MOU to already do this, skirting the Police Accountability Act of 2024, an officer will shoot somebody, that triggers a criminal investigation, and the police department will purposely delay an investigation into an officer shooting somebody until the defendant's criminal case has concluded. That is completely unfair and unjust and lacks transparency, and it is highly problematic in practice as we see this implemented, and we urge an unfavorable report.
All right, I don't see anybody for Out for Justice.
Yes, Out for Justice is here. Ashley
Okay,
Devon.
that's fine.
Good afternoon, Chair and members of this committee. Ashley Devon with Out for Justice. What has been continuously conflated with this bill are the minor administrative disciplinary infractions of an officer and investigations of police misconduct. We believe minor administrative disciplinary infractions should receive a time limit to ensure workers' rights protections. However, the issue here is that has not been codified in policy to differentiate in between police misconduct. The problem with the statute of limitations is that it takes time to complete an investigation, especially when when the administrative investigation has a parallel criminal investigation. Further, when there is civil litigation, police misconduct is often discovered. However, if there's a statute of limitations, none of the identified misconduct can be considered in the administrative investigation. Last, it is not correct to assume that all police misconduct cases will automatically go to the ACC because not all investigations begin with the civilian complaint. So again, this bill is too ambiguous. I understand the need to want to move this forward to protect the police officers that are receiving bullying and intimidation from higher ups, but this does not protect the greater good or public. Thank you, and we urge an unfavorable report.
Thank you very much. Are there questions for this panel? All right, seeing none, that concludes the testimony on House Bill 238. Now, House Bill 660, oh, you want to go ahead? Yes, no, let's go ahead. We can do that. We're going to start with House Bill 1123. House Bill 1123, the Vice Chair, Dorothy Lennick, Ernest Ellery, Karen Clark. I'm sorry, Ernest Ely.
Do we have any-
3 minutes and 2 for everybody else. The Vice Chair, please.
Thank you, Mr. Chair, members of the Judiciary Committee. Sandy Bartlett for the record, representing Anne Arundel County, District 32. I am here today to present House Bill 1123 for medical and elder parole. The bill works to remove the governor from the medical parole process, acting as a technical fix to the 2021 legislation. Second, the bill creates new eligibility criteria for what we refer to sometimes as geriatric parole or elder parole consideration, including that there's a 60-year, you have to be at least 60 years old, you have to have served at least 20 years of your sentence and not had any major disciplinary infractions within the past 3 years. And those who meet this requirement would be required to undergo a risk assessment and a parole hearing by the commission. Lastly, a portion of the savings made will be directed to the commission by the Justice Reinvestment Oversight Board. And we have testimony here today who will explain a little bit more of that. But that would be for the hiring of more psychologists to conduct risk assessments as referred to in the bill. Reforming medical and elder parole in Maryland is crucial. Not only is it obviously cost saving, but it also protects our aging and vulnerable incarcerated populations. We have a serious problem involving wait time for medical parole review, and we must address it. Removing the governor from the process obviously will help individuals who to be considered without any political involvement. Further, outlining the standards for the elder parole would enable the system to be more predictable and fair for older individuals who pose no significant threat to public safety. The bill recognizes that older adults are not the same as younger offenders. We also have heard testimony where individuals who are incarcerated, their health risks are greater, and they tend not to have the same life expectancy as someone who is not incarcerated. Therefore, they should be evaluated through a lens that accounts for their unique circumstances. It's critical that we prioritize public safety while also ensuring a balance with the broader interests of our criminal justice system. We not only strike the balance with this bill, but we also alleviate some of the financial costs that medical and elder populations place on our system. Therefore, I thank you for your consideration, and I request a favorable report.
I'll go next. Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lennick. I'm the Executive Director of the Governor's Office of Crime Prevention and Policy. I want to thank the Vice Chair Bartlett for bringing this bill. We're urging a favorable report on House Bill 1123. As you know, over the past... Sorry. As you know, over the past several years, there have been a lot of parole bills brought to this committee. Last fall, the governor's office asked me to convene a work group on parole, and this bill came out of that work. And what it says is that if a person's at least 60 years old, an incarcerated individual, they've served 20 years, at least 20 years, they've had no major disciplinary infractions in the last 3 years, and they're not in for life without parole, then the Department of Public Safety will submit those names to the Parole Commission. Within 60 days, the Parole Commission must conduct a risk assessment, and then after the risk assessment, they must conduct a parole hearing. Something we discovered during these work group meetings were that the Parole Commission only has one psychologist conducting risk assessments. House Bill 1123 would authorize GOCAP to use the Justice Reinvestment money to hire more psychologists to conduct the risk assessments. This would allow the Parole Commission not only to clear up the current backlog of about 150 people who need risk assessments, but also screen the potential 650 incarcerated individuals who may be eligible under this bill. Another issue we discovered is that during the work group is that since geriatric parole was enacted in 2017, only one person has been released under it. And we think the problem was because the statute doesn't require a hearing. This bill would require the Parole Commission to have a hearing. Please note that HB 1123 does not require the Parole Commission to recommend release. It simply gives them objective information to make a decision. Urge a favorable report. It also gets the governor out of medical parole.
Good evening, Chairman Clippenter, Vice Chairman Bartlett, and members of the committee. For the record, my name is Ernie Silly Jr. I'm Chairman of the Maryland Parole Commission. The department is in support of House Bill 1123. We have worked closely with Vice Chair Bartlett as she crafted this legislation. The commission is charged with determining on a case-by-case basis whether incarcerated individuals are suitable for release into the community under supervision of the Maryland Division of Parole and Probation. House Bill 1123 does not lessen our obligation or reduce the criteria we use when someone is reviewed for medical parole, but makes us more vigilant as we consider incarcerated individuals who present as chronically debilitated or incapacitated by a medical or mental health condition, disease, or syndrome as to be physically incapable of presenting a danger to the community. The current construction of the geriatric parole statute has allowed us to consider very few candidates over the last 10 years. There has been one, as Ms. Lennox noted, one person released under the geriatric parole statute as it currently is. The proposed legislation allows for review of those aged 60 and over who have served 20 years. The commission is prepared to carry out this responsibility, and though the legislation does not call for it, as with the medical parole provisions, nothing in the legislation will compromise our ability to put public safety at the forefront of our decisions. House Bill 1123 does not create any new avenues for parole consideration, but it does significantly strengthen and clarify existing law. I urge the committee to give House Bill 1123 favorable consideration.
Yes, to my, Madam Vice Chair, to my shock, frankly, the Office of the Public, I think they would be hugging you, but they're actually opposed to your legislation. In particular, Ms. Meadows is rather blunt in her testimony. She says that the bill requires a risk assessment within 60 days, but she says the MPC does not currently have the bandwidth to do that, not even close. And she also highlights earlier in her testimony the long delays and says that your bill will exacerbate it. So I wondered, is there any merit to what they had to say, or are they wrong, or what's your response?
Thank you, Delegate Kaufman. And the Office of the Public Defender is hugging me, but not for this bill. So I will say that there have been delays. I will let Dorothy Lennox address the reason, how we're going to address the delays with this bill.
Well, thank you so much for that question, because that's really the biggest point of this bill. We don't have enough psychologists conducting the risk assessments. What we would commit $1 million from the Justice Reinvestment to hire more psychologists so that we could conduct the risk assessments in a timely manner and move people through the system so that they'll get a timely review by the Parole Commission. So I think it's going to really unclog the system. That's really the basic point of the bill.
And just a brief follow-up, Mr. Chair. I appreciate that, Ms. Lennox, but there are a lot of needs and different things like that. So by transferring $1 million from the Justice Reinvestment Act, are we robbing Peter to pay Paul? Will other programs be hurting because of this decision?
Well, the purpose of Justice Reinvestment really is about reentry. And what better way to increase reentry than to get people who can be out of prison, out of prison.
Thank you, Mr. Chair. Thank you, Delegate Bartlett and Ms. Lennox.
Delegate Phillips. Thank you, Mr. Chair. And I would be remiss if I didn't acknowledge my constituent, Mr. Ely, Thank you for being here
Thank you,
today
sir.
and taking on this role. It's a major role that you're in. My question is, how many people will this potentially impact? Last year, we went through a lot of discussions about different types of parole and who would be affected. How quickly might this all happen? Can you give me some background on that?
Yes, the number of folks who we took account last week who would meet the criteria for this legislation, 60, and serve 20 years is 646. Of that number, 67 will qualify to capture the other parts of the bill who have not had a major infraction in the prior 3 years.
So we're only talking about 67 people?
Currently, yes.
Okay.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate and panel, for bringing this bill. Sir, you said 67? Because, is that what you said?
With this legislation.
Yes, because on the
right
prompter it said 6 or 7.
I'm sorry, 640. I said 646 that meet the criteria for 60 and have served 20 years.
Okay, that's fine. I was just trying to make it clear because the prompter said something different.
If I can just add to that, though, the idea would then allow people who are incarcerated to know that, and hopefully less people will commit infractions. And so
I
more
didn't have a
people-
problem with that. I didn't have a problem with that. It wasn't clear on the prompter. The prompter said 6 or 7. And he said 67. I thought I heard him correctly. But my question was, what type of sentences are these people, are the people potentially serving this time for that might get off?
Well,
go ahead.
Oh, go ahead. Well, it would be anybody who's been in for at least 20 years, who's 60, but not life without parole.
Right. But
So
not
whatever the
life without
crimes are that are life without parole, they would be excluded. Could be any other crime.
Okay, thank you so very much.
Thank you, Mr. Chair, and thank you for just answering that question, because that was one of the ones I wanted to know. And then the second piece was, I know we have a fiscal note here showing what the expenditures will increase over time, but based on the number of people that you're saying that's going to benefit from it, has there ever been a report to show or quantify what the savings would be if these persons were released?
So after JRA passed in, I think, 2017, DPSCS counts the number of people who are incarcerated and gives to GOCAP the difference in per person from the number of people who were incarcerated when they passed JRA and now. And so each year we get, so I think last year we got $13 million of the savings of incarcerating fewer people. This year I think we get 11 million. So it goes up and down. What we're hoping is that by having fewer people incarcerated, the number will go up. But we can commit JRA money to keep this going until it's basically self-sufficient. What we're hoping is that we're going to start to get more and more people out. But that's the money that we use as our JRA money that we distribute now.
Okay.
I forget what the formula is, but we get a per dollar amount per person.
Oh, okay, so it is being tracked.
Yes.
And then the last part I just wanted to understand, in this, you're wanting to take the governor out of the medical parole process, correct? So do you find that that's a hindrance now that the governor is a part of it? Does it delay this process? If so, how long?
So yes and no. It's not necessarily this governor. It's not even necessarily any other governor per se. The problem is that we did, or not the problem, but the correction that needs to be made is we took the governor out of the parole system except for medical parole. It was an oversight. It was not intended. And so what we're doing and what you're going to see in all of the parole bills I'm going to introduce today, we are asking for the governor to be removed from the parole process. Not necessarily, like I said, this particular governor, although I do have the governor's blessing that, you know, that he wants to be out of the parole system, because we have a parole, commission that does the work, and it's not politically connected.
Okay. All right. Thank you very much. Thank you, Mr. Chair.
The head of the Parole Commission, can you go through the steps that people go through when they are seeking medical parole. My understanding is they go through the regular parole process and then they go through some additional steps. Can you go through the parole process just for the education?
Yeah, as you know, Mr. Chairman, in addition to those 11 criteria we utilize that's in COMAR laid out in law, in addition to the medical parole, it has to be a medical professional who makes the request. It has to be a really detailed report as to the prognosis and then consideration. And then that comes to the parole commission, a panel of commissioners to make a decision to bring that en banc to the whole commission, and we vote on that. And then, depending on the vote, it's favorable, it goes to the governor's office for consideration. And the governor has 6 months, 180 days to sign off or respond to that request.
Okay, so they go through the entire parole process,
Yes.
then they go through the additional medical parole process.
Yes, sir.
And then at least right now, it goes to the governor's desk.
For consideration.
So when we passed legislation in the last term that did that first part, there's a universe of people that actually, this is a universe of people that's one step beyond what we already passed.
It is.
Okay. And then let me go to the question of the people who meet the criteria. Do you happen to know the number of people, well, let me go to this question. So who normally gets a risk assessment when they're incarcerated? My understanding is that that is something that's done for people with a life sentence. Is that correct?
That's correct.
Okay. Is it done for somebody, for people with a sentence of years? So in other words, they have an active sentence of 40 or 50 years? Is that done for them?
Let me say, also for juvenile lifers, for people with life sentences, life without parole, because those folks are not parolable. They don't have a parole eligibility date. And it could be some other very serious crimes, but that's basically the group.
So it's just so you said there were 67 people. Are they only people that are life with the possibility of parole?
Yes.
Okay.
For this legislation.
Okay. So it does not then go beyond that to look at people who are there for a term of years?
No.
Okay.
In terms of the geriatric, the elder parole portion of the bill.
I understand. Okay. Other questions? Delegate Arakan.
Thank you, Mr. Chair. So I thought you said this, Delegate Bartley. You said the governor is in support of your bill?
Well, after I said that, I thought.
I was giving you a softball.
Yeah. After I said that, I thought, wait a minute. But I've heard that
you heard it through the grapevine.
I heard it through the grapevine that he's in support of being out of the decision-making process for medical parole.
Okay, and the gentleman said it was a 6 month is how much time he would have. Given how long it takes him to respond to letters I've sent him, I think he may be in the right location, moving himself out of that spot.
Is there a question?
Isn't that so?
Any further questions for this panel? All right, seeing none, thank you very much.
Thank you.
We'll go to Ms. Meadows, who's here in opposition.
Okay.
So Karen Clark.
Okay. Okay.
I'm sorry.
So, Ms. Clark, are you testifying in favor or in opposition to this bill?
So just testifying on this bill. Unfavorable, right? Unfavorable? Yeah. What's your position? No, favorable. Oh, favorable? No, we're not on 190. I'm sorry, we're on 1123 still.
Let's do this. We're going to hear from Ms. Meadows, and then we'll figure out, and then we'll go from there. So please.
Good evening. My name is Lila Meadows. I'm an assistant public defender with the Office of the Public Defender, who Delegate Kaufman referenced as quite blunt in my testimony, asking for an unfavorable report. That's me, and it is unusual for me to find myself in opposition to a parole reform bill. I should state that the Office of the Public Defender is asking for an unfavorable unfavorable report because of the content of the bill, not the spirit of it. The bill actually does several things that we are in favor of. It removes the governor from the medical parole process. That has to happen. 4 people died awaiting Governor Moore to make a decision. It should have happened years ago. We support the technical fix to geriatric parole, which right now is in the criminal law article. It needs to be brought into the correctional service article. That bill does it. Where we have problems really is with the fact that it doesn't do any of the other medical parole forms that we're asking for in House Bill 190, and they're really important reforms. Things like clarifying what the legal standards are when medical parole is appropriate, so that I don't have clients with dementia who aren't even aware that they're currently incarcerated, who can't be medically paroled because they're not terminal. It doesn't remove the Karnofsky score from consideration. And so there are just some really important things that are in House Bill 190 that did not make their way into House Bill 1123. With respect to the geriatric parole provision, elder parole under this bill, it's a problem for us to subject additional people to the risk assessment tool, both because of the backlog that you heard about, but also because I'm not sure that risk assessments are necessary for this group that will go through the regular parole process. If the person is serving life, they're already subject to the risk assessment. If they're serving a term of years, they're not. These are people who are age 60 and older, and under the bill would have had to have gone at least 3 years without a major infraction.
So, Ms. Meadows, he just said that the only people who would be eligible under the bill were people with life sentences and not people who were terms of years.
That's not the way we read the bill.
Okay, well, I'd be happy to see what technical changes need to be done to address that concern. So then outside of that, in the medical parole portion of the bill, you have issues that are better addressed in 190, is what you're saying?
That's right, and I should state outright, we're happy to work with the committee if this is the vehicle to make those changes.
All right, thank you. Delegate Moon.
I was just gonna, thank you, Mr. Chair. I was just gonna ask if 190 didn't exist, are you suggesting you would still be opposed to the content in 1123?
I think we'd likely be favorable with significant amendment, which might more accurately reflect our position, frankly.
I guess what I'm trying to understand too is whether you prefer the other bill or whether you think there's content in 1123 that does harm.
So I think that if the chairman is correct, if Chairman Ely is correct, and the bill doesn't subject additional people to that risk assessment to further, harm the backlog, that changes our assessment of the bill.
Okay, thank you.
Thank you, Mr. Chair. And I don't know if you have this answer or not, but I'm just curious, just on process-wise, similar to what the chairman was saying. Now, if someone is released and get this medical parole, does the Department of Public Safety provide supports for them outside of those 4 walls, or they're out there and they're just there trying to seek medical care on the outside when they had it on the inside? And I'm just curious.
So I've been representing people for medical parole for a decade now. I've never had someone medically paroled who didn't go immediately from the Department of Corrections into either a nursing home or hospice, and that's where they tend to stay until they die. They do have a parole agent, just the way anybody else released on parole would be, who, I think is available should any issues arise with that placement, but they're not social workers. I will say that when I represent someone, when the Office of the Public Defender represents someone who qualifies for medical parole, we provide that continuing support through our community reentry and engagement project.
Now, I hope I'm not sounding cold on this, but you mentioned that 4 people died waiting the governor's support or signature.
Yeah.
I mean, you said they're terminally ill, correct?
Right now, the standard for medical parole more or less requires you to be terminal.
Okay, I'll leave the rest off. Thank you.
Thank you, Mr. Chair. Thank you very much for testifying. I actually read the bill the way that you read the bill. And maybe there's just some magic words that only applies to people with for life with the possibility of parole, but that's not the way I read it. But why, if there's somebody who's 60 years old and you want them to qualify for parole, for a parole hearing or a decision on whether they should be recommended for parole, why shouldn't they get a risk assessment done on them? Like, I would be concerned, I mean, I'm getting close to 60, and I'm still a little spry. Like, if I was, I'm just thinking, just because you're 60 doesn't mean you're not potentially dangerous or a risk to the community.
Absolutely. And, the Maryland Parole Commission is going to have to make that determination the way they would in any other parole case. The criteria are there. You heard Chairman Ely testify that they go through sort of the normal factors that are under the statute. The issue with the risk assessment, you're going to hear from some folks following me on House Bill 190 who were incarcerated for a number of years, who hit that 60 mark and were released per a court decision, and they'll tell you they received risk assessments and were rated as high risk because I don't have confidence in these tools, and that just hasn't borne out based on what we know about recidivism for people who were released in that group.
So it's not that there's a backlog, it's that you don't like the risk assessment tool.
It's a yes and for me. It's both.
Okay.
Questions? Seeing none, thank you very much. That'll conclude the testimony for House Bill 1123. Now we're going to go to House Bill 190. And since this is a bill that we have heard before, it's going to be 2 minutes for the sponsor, 1 minute for everybody else. We have the Vice Chair again, and we're going to hear, okay, so is it just, who would you like on your first panel? And I'll start scratching people.
Definitely these two individuals.
Got it?
Okay. And I'm not sure who else is here. I'm not sure who's left. If you want to keep calling.
There are quite a few, but being that there are quite a few, I think why don't we start here, and then I'll start calling them up in groups of 5. That'll be
Okay,
fine.
great.
All right? Unless court's indulgence.
Okay, great.
You good?
Court's indulgence. Thank you.
All right, the Vice Chair.
Thank you, Mr. Chair. I'm here to present House Bill 190. For the record, I'm Sandy Bartlett. And so here's what happens with House Bill 190. You've heard a little bit about it. The Parole Commission will consider the age of the individual. The difference between this bill and the previous bill, the age is still 60. The governor is still out of medical parole. But the time for the sentence served is 15 years. The person is not registered on or eligible for registration on the sex offender registry, and is sentenced to a term of incarceration for which all sentences have been served, including any life sentence, are with the possibility of parole. So the hearing is every 2 years, and what else? I want to make sure I get everything in here. It's also important to note that the medical paroles provisions in this bill should not be confused with the next bill we're going to talk about, because House Bill 190 goes into more detailed information as to what is needed for medical parole. And so House Bill 190 brings about compassionate release. You might have heard of that before. So it brings it to Maryland, and it addresses ambiguities in medical parole. And therefore, thank you for your consideration. And Delegate Kaufman, I hope you notice that I am sitting with Lila Meadows. A favorable report is requested. What do you think?
It's hard.
It's hard things. Okay. Thank you very much.
Okay. Again, Ernest Hilly Jr., Chairman of the Maryland Parole Commission. You have my written testimony already, so I'll be very brief. The department is in support of House Bill 190 and requests the committee to amend the bill to align with House Bill 1123, as noted by Vice Chair Bartlett.
Okay.
Again, Lila Meadows on behalf of the Office of the Public Defender, here in support of House Bill 190, which is a legislative priority this session of the Maryland Office of the Public Defender. I talked about some of the reasons why we're in support of this bill already. It makes really important substantive changes to our medical parole scheme that include clarifying the legal standard for when release on medical parole is appropriate, directing the department to provide better information to the Maryland Parole Commission in order to make these decisions, and cleaning up the geriatric parole statute by moving it from the criminal law article to the correctional services article. I'll just note that we've worked with the Maryland Parole Commission over a number of years to get this language right. This isn't the form that the bill started in when it was introduced in the 2022 legislative session for the first time. We've worked with the Maryland States Attorneys Association, who are now favorable with amendment on this bill. And so this is a well-crafted work product, and we urge your support.
Questions for the panel? Delegate Kaufman?
Yes, MSAA Delegate Bartlett proposes some amendments. They're favorable with amendment. Do you consider them friendly amendments, or do you urge the committee to resist the amendments?
Hold on, I have to look at those. Give me 1 second.
They're very technical. For example, they say by changing the or on line 23 of page 3 and the, okay. So they give very technical amendments. So you can get back to us, but I am curious.
I consider that to be a friendly amendment, if they're technical. May I make one quick clarification, Mr. Chair? So I wanted to clarify that, and this is directed towards Delegate Sample Hughes. 4 of the individuals of the 14 who were granted parole, those 4 passed away shortly after being released. So I just wanted to make sure that that part was clear. So they were in hospital. Yeah.
Other questions? Delegate Cardin.
Thank you. Thank you. This is, I guess, for Delegate Bartlett. If a person is released on geriatric parole or medical parole, I guess it could be either in this bill, right? And they commit a crime, what happens?
They go back into incarceration.
Is there a hearing that precedes it, and then?
Yes. The hearing, it would be a normal procedure. They have to be found guilty. There has to be due process, just as there would with any other situation, but they could very well go back in. I was trying to find that section, but the short answer is yes. The long answer is,
I was looking
I'll let Ms. Meadows she can give you the particulars.
So if someone has been released on parole and commits a new crime, there's going to be a violation of parole hearing before the commission, in which they're going to be entitled to representation from the Office of the Public Defender. And so they're going to have to deal with that VOP, but they're also going to have to deal with whatever new charges stem from that. And so they could be in a situation where the balance of their sentence that they were released on parole is hanging over their head, and then running consecutive is a brand new sentence.
But there's no difference between a violation of parole in the ordinary course versus a geriatric violation of parole?
No, there's not.
Okay, that was the question. Thank you.
Seeing no other questions, we thank you very much. I'm just going to start rolling through the lists here, and we've got 1, 2, 3, 4, 5, 6 chairs there, and we will go through again. It's 2 minutes for the sponsor, 1 minute for everyone else. Belinda Moy, Gerald Dent, Sarah Aziz, Percy Smith, Braveheart, Richard Preston. Let's see who is here and who is not. Any of those virtually? No? I see 4, 5.
Clark, Mr. Chair.
Yes, and Ms. Clark, if there's a seat, I was going to keep it, now there's going to be 7 with Ms. Clark, so that's fine. If we don't get you in this panel, we'll get you on the next one, and there'll be plenty of room. Okay. All right, that's fine. We're going to start from my right and go to the left. And if you wouldn't mind moving the microphone in front of you and then starting, you'll get 1 minute, please. Go ahead.
Hello, my name is Sarah Aziz. I am a student attorney with AU Law Decarceration Reentry Clinic. I'm testifying today in support of HB 190. Maryland is facing its worst budget deficit in 20 years, yet we still continue to spend millions incarcerating individuals who no longer pose a threat to public safety. The cost to imprison one person is $114,000 per year, but for elders with chronic health issues, this cost is nearly 3 times more. This is far exceeding what we would spend on them if they were in our community. Research has confirmed that prisons accelerate aging, making incarcerated individuals vulnerable to chronic illnesses and deterioration at much younger ages than peers in free society. Despite this, Maryland spends millions annually on medical care for elders with a recidivism rate of under 3%, as evidenced in the Ungar cases, making them the least likely group to reoffend. Given this budget crisis, passing this bill is smart, low risk, and financially responsible, saving Maryland millions while ensuring elders who have served at least 15 years can age with dignity.
Please.
Good evening. I am Olinda Moyd, Director of the Decarceration and Reentry Clinic. I come to you again this year testifying in favor of this bill to make one point. People do age out of criminality. This is supported by documented and empirical data. The U.S. Sentencing Commission conducted an 8-year report where they followed individuals who were over 65 when they were released and found that their recidivism rate was at 13% as compared to those who were much younger with a recidivism rate of 67%. For years, I practiced before the U.S. Parole Commission. You automatically get a point added to your salient factor score if you go up before the Parole Commission if you're over 41. They get it. We also have in the state of Maryland a demonstrated evidence of releasing people who can do good in the community through the Ungar population, many of whom are here today. Thank you.
Good evening, I'm Gerald Dent. I'm saying let's take the politics out of it and your personal qualms. And I'm saying this is an opportunity to get in touch with your human self. Get the guys, the ladies that's locked up all them years, give them an opportunity to come home, geriatric parole, and pass away with a little dignity. Let them be somewhere where they can wake up and see something other than a prison wall or a ball. I served 40 years myself. And for the last 15 years, I worked suicide and death watch. And them guys were so remorseful for the most part and wanted to contact their victims, but that's kind of like a no thing to do while you're in prison. I'm saying, take with your human self, put your politic hat on the side for a minute, your personal qualm, and get a man the opportunity to die with a little dignity.
Sir, what was your name, please?
Gerald Dent.
Thank you again.
Junior, I might add.
Thank you very much. Go ahead.
Good evening, I'm Shekina Braveheart with the Justice Policy Institute. HB 190 is common sense comprehensive bill aimed at fixing Maryland's broken medical and geriatric parole systems. On January 24th, we received data from DPSCS saying that 439 people would currently qualify for release under HB 190, including expenses for chronic medical needs. The annual cost to incarcerate an eligible person is $68,316. Multiply that by 439, and we're looking at a yearly cost of approximately $30 million. If we use the numbers that Chairman Ely just gave us, which was 47, if I'm correct, that's $44.2 million. Geriatrics' ability to pose threat to public safety diminishes due to deterioration and low propensity for recidivism, making continued incarceration a poor investment of public resources. It's time for us to choose and seize this opportunity for reform, and I encourage you to issue a favorable report on this evidence-based, comprehensive approach to parole reform. Thank you.
Percy Smith,
protocol has already been established, and I want to say this has become personal. I am one of those ones who was turned down for geriatric parole. And I'm looking at the lives that you can save as well as the money. We are in a budget crunch, if I'm not mistaken. We just talked about 44 million we can save. Let's talk about the lives that we can save. You can look at this panel, these brothers and sisters back here are all over 60, and they're doing positive things. We can look at the evidence-based part of this process, and we're going to talk about the UNGA crew. We got, what, 200 and something people? Only one went back to jail. I want you to consider this as a wake-up call.
Good evening. My name is Richard Preston. I'm a returning citizen at the age of 64 years old. I say now that this bill gives finality and solvency to the parole commission. For years, we have fought for the parole commissioner to have that solvency over our lives, to take the politics out, to stop men and women from dying in prison, just languishing there in the medical department, watching them die, watching their families come to see them, and they suffer. This is too long. Without the parole commission having solvency, waiting for the governor, the process is entirely too long. We want to expedite this. We want to think about human lives, those that we could save, just by a push of the pen. That's all we ask. We just ask for the committee to be humane and think about those lives that they can save with a push of the pen and taking the politics out of this. We thank you very much. I do.
All right, questions for the panel, and I know there are people on virtually, but we're going to take the questions in the room first. All right, Delegate Arakan, and we'll make our way around.
Thank you, Mr. Chair. Thank you all for being here and sharing your stories. To the gentleman in the white sweatshirt, you mentioned that you had been denied geriatric parole.
Yes,
can you explain what the process looked like?
I'm recovering from skin cancer.
Okay. And so how did it work? You applied, and then can you just talk us through a little bit about what that process looked like? Why did you get denied?
Well, I had no idea. I had a lawyer. I paid him to go through the whole process, and they said that the geriatric parole piece, that the parole piece was available to me. Mm-hmm. And I was a young guy, and so I looked up and said, "You're not old enough." So I go back. Okay. So I'm approaching 50. Mm-hmm. You're not old enough. So I go back, and I say, "I'm not going through this no more. Let's go to getting me out." And I got out, and I was able to save the state some money.
How did you eventually get out if you were denied the medical parole?
I went through the regular court, what do they call it? Written habeas corpus, right? Okay. And they sent me home straight out the door. Okay. I was able to get support that I needed. I couldn't get that support in prison because the infirmary wasn't that adequate to help me with my skin disease.
Okay, and how are you feeling now? Are you better? Yeah.
I'm emotional.
Yeah, this is a very emotional committee. You came to the right place. Thank you. Sorry for what you went through.
Delegate Taylor.
Thank you, Mr. Chair. For the new folks on the committee, and maybe some of those that are watching, can you remind us what UNGER is? And then two, do the same risk assessments apply under this bill?
So the UNGER is there was a time in the state of Maryland where they recognized that instructions that had been given to the jury in several cases was in error. And so they went back and looked at those cases, and somewhere around 200 individuals were released as a result of that correction. And again, many of them, some of them are here today, some had to leave, but they are in the community, they are doing great things in the community, and the recidivism rate is about 3% for that population.
Okay. Thank you, Ms. Boyd, my constituent. And
I didn't have enough time to say that.
no, I didn't expect you to. Do the same risk assessments apply under this bill? Does anybody?
Yes, there's only one risk assessment that I'm sorry, are you asking, does this bill incorporate the risk assessment?
Yes, we heard a lot about risk assessments in the prior bill. I'm wondering if those same risk assessments.
It does not, and that's one of the reasons why I support this bill, because every day I work with clients who are waiting for a risk assessment, and the waiting list right now is about 18 to 24 months before an individual actually gets a risk assessment, because there is one clinician who is doing them for the entire Department of Corrections.
Could I address that also? Ma'am, the risk assessments are only valid for 365 days. So, my concern is mandating them would potentially lock parole candidates into this perpetual loop of reevaluation. I was at an open parole hearing for a 77-year-old who, this was her 4th parole hearing. She'd been incarcerated for 28 years. She's had 3 risk assessments, the most recent one in 2021, a favorable risk assessment, of course, and she went up for her recent parole hearing, and the recommendation was another risk assessment because the one she took is now expired. So, I'm concerned that mandating it, risk assessments are fine. I don't have a professional opinion of them one way or another. I'm not a clinician. I'm not an attorney. But what I do know is the backlog, and by the way, the commissioner told her it was a 26-month wait. So that person will be 79, almost 80 by the time they get the risk assessment, plus they have to wait to get scheduled for another parole hearing. And this is a person with an excellent institutional record. They don't have a bunch of tickets, but they have to just go through this process. So I'm concerned about mandating it. If you want to keep it, great, but don't make it law, because people will get locked up. And the same thing applies for that, what was the other thing they wanted? 3 years infraction free. The Maryland Parole Committee, there are 10 statutorily required criteria that they have to look at when determining whether someone is suitable for parole release, if they're safe to release, and if they recommend it. And their institutional record is a part of that consideration. So again, we don't have to mandate it. It's very easy to get an infraction. We're talking about elders here. You get an infraction if your medication is expired. That's fish oil supplements, iron supplements, multivitamins. If that medication or that supplement is expired, that's an infraction. It would be horrible for somebody to be eligible for parole, geriatric parole, and to get denied because 3 years ago or 2.5 years ago, your medication was old and you got a ticket. They have to look at this stuff anyway, so it doesn't make any sense to mandate it. So that's my opinion on that.
Okay. Thank you, panel, for coming in to testify. My question doesn't mean that I'm against this bill, but on the budget, if we want to save some money, the people's money, I think we should put it on the ballot. So I think you're asking the wrong people here to make a decision about the people's money. But what about the people who are under 60? What about those people? If you're terminally ill or something like that, and you're 59, 40, 30, is this fair to those people?
I think that falls underneath for medical. That's where that would fall.
And you said you were denied when you were 40?
Yes.
Okay, and then you were denied again at what age?
Around 50.
And then so you weren't?
I gave up.
You gave up?
I gave up.
That's what I'm talking about.
Yeah.
Thank you very much.
Okay, thank you, Mr. Chair. I want to go back and just
try to figure out what this is really looking at the numbers, all right, and looking at what's in, what isn't in, because some of the questions have had you talking about what is, what isn't. I want to hear, please, what is in, let's start with 190. How many people would that include? If we were to do this now, how many people?
According to the Department of Public Safety and Correctional Services, on January 24th, there were 439 people that would qualify for release under HB 190.
Okay, and there is included risk assessment or not risk assessment?
190 does not have a risk assessment
risk
requirement.
assessment. All right.
So some of these folks may, some of them may not, depending on whether they have a life sentence with parole or, as the chairman said, you know, juvenile lifers and things like that. So that wasn't taken into consideration. We just looked at people who were over the age of 60, who have been incarcerated for 15 years or more, who are serving a parole-eligible sentence. That's who makes up the...
Serving, what was the last thing?
Parole-eligible sentence. So they must have a parolable sentence, they must be over 60, they must have had 15 years in, and also not on the, eligible for the sex offender registry.
And so they have to be parole eligible. And what is parole gonna look like under 190? The same as it looks now, governor in or governor out?
190 removes the governor also.
Governor's out.
All of the parole bills remove the governor.
So both of them, this one and the one we heard before, is to take the governor out, is that correct?
That is correct.
Okay, and in 1123, there is, let me go back to my notes. I want to go back to Delegate Conway's, because I want to make sure I heard it correctly. It's 67, was that the number, who would be eligible?
Yes.
Because I've heard two numbers, I want.
Is that under House Bill 1123?
Yes.
Currently, yes.
67.
All right, and the governor would be out. And both of these are excluding life without parole, is that correct?
That is correct.
Both of these, if you're on the sex offender registry, you're out, is that correct?
Not for 1123, that's for 190.
Not for 1123, so you're in for 1123, out for 190, all right? And so there's a gap there. I mean, that sounds good. There's a big age gap right there from, you talked about younger, they were younger, and we had the juvenile restoration. So unless you need the medical parole and you're in the middle like this gentleman, you went at 40, but you weren't sick at 40.
I wasn't sick at 40. I become sick at 40. I went in at 15.
At 15?
At 15.
Okay, so you went in at 15. You weren't sick at 40. At 50, you were sick.
Upstairs, yeah.
And you
wasn't old enough.
Because it was 60.
Right.
So what would have captured him at 50? Nothing.
None of these two.
Unless he met the medical criteria.
I
But he
met
said he
it,
was 60.
but I still wasn't old enough.
For the medical?
Yes.
Okay.
So when he went in at 50, he wasn't old enough, but he was sick. Okay. Thank you, Mr. Chair.
Further questions for the panel? Seeing none, thank you very much. We're going to go now to Anthony Trustee, Ralph Timmons, Rauf Matten, Gwendolyn Levi, Stanley Mitchell,
We had one more.
And Ms. Clark?
and Ms., I'm getting there.
Okay.
Yeah, and Ms. Clark as well. Lauren Pruitt is virtual and is on. Heather Warnken. I don't see Heather Warnken. we'll start in the room to, well, maybe I have one other person.
Well, start with you. No. Start with you.
No, you see one of them.
Okay. Going to start on my right, moving from my right to my left, left to right for you. We'll start with the gentleman who just sat down. Please give us your name, and you have a minute to testify.
I'm Ralph Mateen. I went to prison when I was 28. I came home when I was 70. A lot of things transpired through that course. When you talk about this risk assessment, 2009 risk assessment saw the people in protection 2011. Risk assessment don't work. We had 3 individuals, Ransom Watkins, Andrew Stewart, and Alfred Chestnut. They went for a risk assessment. They were denied, saying that they would reoffend in 3 to 7 years. They were just awarded $48 million because they were innocent of the charge that they were incarcerated for. A failed system. It doesn't work.
Yes, my name is Ralph Timmons. I went incarcerated when I was 18. I came home when I was 58 and a half. And when I came home, I found out that I was very sick because I didn't know when I was incarcerated because they didn't tell me. I came home with hepatitis C. I got cirrhosis of the liver right now. And I also just recently had 4 stents put in my heart 7 months ago, and which if I'd have stayed in prison, I wouldn't even be here because they told me I should have been dead a long time ago. So it just wasn't my time to go. So the medical parole would be better for the guys in a situation like me that's sick, some that know they're sick and some that don't know that they're sick. I think the guys deserve another chance. I understand how the victim's family feel about this because I'm a victim as well. I lost a sister and a brother to violence. So I understand how their family feel, but I feel if this parole can help these guys that is sick, then I feel that they should be given this.
Hi, I'm Karen Clark, and I'm representing the Unitarian Universalist Legislative Ministry and speaking for these bills. I will not repeat a lot of the things that we've heard here. I will add, my data is a little different, and I got it from the Justice Policy Institute, but I didn't check the date. So that's what there, but I'll go ahead with what I had there. It says that Maryland's history, as we've heard, for implementing the geriatric policy has been sparse. Between 2015 and 20, only 18 were approved, but 253 denied. Now, over 3,000 are over 50, predominantly Black, with 41% of the Black men sentenced under age 25. Maryland has the largest racial prison population disparity in our country. Our state has about 30% Black, and the prison population 70.
That's right.
So I'll stop there, thanks.
Thank you. Hello, my name is Gwen Levi. I entered the prison system at the ripe old age of 59. Working as a suicide operation aide, I saw daily how seniors of all are treated. Eventually, I was diagnosed with 3rd-stage lung cancer and housed in a medical unit. Thank God I was able to take care of myself while receiving chemo and radiation. Not so for others, essentially in isolation. Many could be heard yelling after experiencing uncontrolled bowel movements, vomiting, incontinence, laying in their distress for hours. Yes, I'm going there. I want you to imagine yourself or a loved one in that scenario. Not to shock you, but to emotionally feel why HB 190 must be passed. We cannot continue to allow our seniors or incapacitated residents to be warehoused. I ask you to listen to your heart today. Listen to your heart. Thank you.
Thank you.
My name is Anthony Trusty, and I'm here today to talk about if we have a bill that was passed 10 years ago and one person in it, and now it encompasses 640 people, and only one person been released in 10 years. One person. I have a friend. His name was William Daniels. He was housed in the Maryland Correctional Institute in Hagerstown because he had had a stroke in the previous years. He was 63. He had made medical parole in 22, 3 years ago. He languished in that hospital bed for 2 years and died. He never made it home because he languished in that bed, because they only released one person in 10 years. We know more than one person had to be released in 10 years. We know it's not ideal for the ideal person, but it had to be more than one person. Thank you.
Good afternoon, or good evening now. My name is Stanley Mitchell. I did 39 years in the Maryland prison system. I was released 2013 on the Unger decision. I came out of prison at 65. I had medical issues. I took the so-called risk assessment. The psychiatrist decided that in his report that I would reoffend in 90 days. 90 days from now, I'll be home 13 years without a parking ticket. So the risk assessment obviously don't work.
Ms. Pruitt, please, for a minute.
Capital punishment was abolished in Maryland in 2013, yet allowing individuals to die in custody, whether from illness or old age, contradicts this abolition. As a former corrections officer at MTC, where Maryland's now defunct execution chamber is housed, I witnessed stark realities of our prison system. My first night stationed at Bon Secours Hospital, I found a terminally ill inmate bleeding heavily. They worked on him for over an hour, but since he was in the custody of DPSCS, I could not unhandcuff him or uncuff his shackled feet while they attempted to save his life. Once the doctor declared the time of death, I was then permitted to remove the shackles. On a more personal note, my uncle was incarcerated when I was about 10 years old. By the time I was 13, he had been diagnosed with stage 4 colon cancer and was given a few months to live. He endured prison life with a colostomy bag and inadequate medical care. His cancer was caused by exposure to Agent Orange in Vietnam, where he was a Purple Heart recipient. He was denied medical parole, passing away in prison. At 14, I delivered his eulogy. My name is Lauren Pruitt, and I urge this committee to issue a favorable report on HB 190.
Delegate Conaway.
Thank you, Mr. Chair. Thank you, panel, for coming in to testify. And I'm listening to my heart. So I want to know, do any of the crimes include child sex offenses or serial rapists?
No, we wouldn't be here today if it was.
No, I definitely wouldn't be here.
We wouldn't be here.
No, you're saying you wouldn't be here today because...
No, I wouldn't be here testifying to you today because, for one thing, we know rapists, if you have multiple rapes, you'll be on the registry, and you can't be released on the registry. Okay. That's a hard release for you. You can be released, but it's a hard release. It's going to be one of the most stringent, most hardest you can try to get it released. No, you can't.
Okay.
This bill, you cannot even be considered with this bill.
Thank you for making that clear.
Yeah, I had to clear that up.
Any other questions for the panel? Seeing none, thank you very much. I did not see Ms. Warnken. So we're going to one person in opposition virtually. She's here. Joanna Mupanduki. And there she is.
Good
Please,
afternoon.
if you'd like, for 1 minute.
Thank you, Chair Clippinger and esteemed committee members. My name is Joanna Mupanduki, and I'm here to express my opposition to House Bill 190, a bill that seeks to redefine the standards for medical parole in Maryland. While I wholeheartedly support the rights and health of incarcerated individuals, I cannot support legislation that undermines the public safety and integrity of our justice system. As the Deputy Director of Maryland Crime Victims Resource Center, I've had the honor of standing with victims during the darkest times of their lives. Through my experience, I've seen firsthand how vital it is to protect crime victims and consider their rights, and every legislative decision made regarding parole. There are very profound concerns with House Bill 190. First, the bill's the bill would significantly restrict the discretion of the parole commission. It would mandate hearings being granted whenever raised by any individuals. Further, I would also question the data from the Unger case. There was a case decided in 2012 and released prisoners who were incarcerated prior to 1981. So those are all individuals who served more than 41 years. So I don't believe that's an appropriate population to look at. But thank you for your time.
Thank you. Are there questions? Delegate Kaufman.
Yes. I thank you for being here, and I really appreciate the services of the Maryland Crime Victims Resource Center. I'm missing something, though, because you said you were concerned about public safety, but our first panel of proponents testified that as people age, they become less and less and less likely to commit a crime again, to recidivate. And you heard an individual say that his risk assessment said that he would reoffend in 90 days, and he hasn't. So, in 13 years. So where's the disconnect? Because the data and the anecdotes we heard from the people in the room don't support your public safety concerns, but if you have alternative studies or other points you want to make, I'm really interested in your thoughts.
Certainly, if you look at the data that DPSCS provides, it indicates that individuals, and I believe the oldest group that they did their study on was individuals aged 65 to 75, that they found recidivism rates were at 16%. Which is higher than what was previously provided. And when you look, I think that's a little suspect because they only look at recidivism rates over a period of 3 years. The gentleman that testified as to the Unger, to his recidivism rates and to the Unger recidivism rates, as I tried to briefly get to, as 1 minute is far too short, the Unger recidivism rates, I don't think those are appropriate to look at because this bill is looking at individuals who would be released after serving, it could be only 15 years that they have served. Unger looked at people who had served a minimum of 41 years because it was a court decision decided in 2012 that was releasing people who had been incarcerated prior to 1981. So at a minimum, those people had already been in prison for 41 years, if not longer. So those were individuals who served very lengthy periods of incarceration. So I would say that's a very, very different situation than what this bill proposes. And so they're very different. I think also if you actually look at the federal Bureau of the Bureau of Justice Statistics, which is done by the FBI, and the statistics that they keep, those are for a longer period of time, and they actually have recidivism rates. When you're looking at violent offenders, those rates are much higher, and they have recidivism rates for homicide and murder, people who are convicted of murder and or homicide at closer to 40, 50, and 60%, depending exactly what type of homicide and or murder they are convicted of.
If you can send the committee the data, I'd appreciate it. And I just want to briefly, quickly say that, you mentioned that 1 minute was too short, but I just wanted to say in defense of the chair, the proponents got 1 minute as well, so thank you.
I understand.
All right. Thank you very much. Seeing no further questions, that concludes the testimony for House Bill 1. I'm sorry, it's not 1. Yes, it is, 190. 190. All right, now we're going to House Bill 311. And this is the Vice Chair and Yannette Emanuel. Mr. Ely, please, as you're leaving, please, thank you. Just to get to the bottom line on this, Madam Vice Chair, this bill is just getting the governor out of medical parole. This does not have the geriatric parole side to it. Is that correct?
Yes, Mr. Chair, that is correct.
All right. Well, It is a reintroduction, so 2 minutes for you, 1 minute for everybody else, but
I have
think I- do you have-
5 pages of testimony for you, Mr. Chair.
Oh, great. All right, off
Okay.
you go.
For the record, Sandy Bartlett, it's my pleasure to introduce House Bill 311. And yes, in fact, this bill only does one thing, and that is get the governor out of medical parole, period. Thank you for a favorable report, hopefully.
Good evening. For the record, my name is Yanetta Emanuel, Public Policy Director for the ACLU of Maryland. I feel like you've heard a lot about this subject already. This bill is simply trying to fix it's a technical fix to a problem from a couple years ago where the drafters accidentally omitted the section of the code pertaining to medical parole. So this is just seeking to fix that. So we asked for a favorable report. The Senate's passed this bill 3 years in a row. This is the 4th year it's been introduced, and we ask that you pass it clean. Thank you.
Mr. Chairman, Ernest Sealy Jr. again. I'm here to support House Bill 311, and also that we ask that the add amendments align with House Bill 1123. I'm sorry. For these reasons, the Maryland Parole Commission respectfully requests a favorable with amendments committee report on House Bill 311.
Any questions? Seeing none, thank you very much.
Thank you.
One person unfavorable, Joanna Mupanduki, virtually. Again, the committee understands this bill only deals with the governors being taken out of medical parole, so if you can stick to that within the minute, that would be fine. Thank you. Go ahead.
Yes, thank you. Just briefly to state that I am Joanna Mupanduki, Deputy Director for the Maryland Crime Victims Resource Center. We are opposed to removing the governor from his role in granting medical parole. We would ask that you leave him in. We think he does serve an important role in allowing victims to be heard. The victims are the ones who bear the emotional and psychological scars long after physical wounds have been healed. We believe that the governor has an essential perspective on the actual cost to our communities, and can look at both the safety and the morale of our communities when considering the release of violent offenders. And so we would urge an unfavorable finding. Thank you.
Questions? Seeing none, thank you very much. That concludes the testimony for House Bill 311. We're now at House Bill 308. The Vice Chair, Michael Shire, Angelo Consoli, Daniel Franklin, Clyde Boatwright. 308. I see Mr. Pennock in the back, favorable with amendments. We'll take you next. Favorable with amendment. Yeah, we'll take you next. And then Karen Herron is unfavorable. We'll take you after that.
And
Vice Chair.
3 minutes, Mr. Chair?
Yes.
Okay,
oh, no,
great.
it's a reintroduction?
No, it is not.
All right, 3 and 2.
Thank you. So for the record, Sandy Bartlett, I'm here to introduce House Bill 308. Thank you, Mr. Chair, and esteemed members of the Judiciary Committee. This is my last bill for the night. So House Bill 308 is actually a simple, narrowly crafted bill, and its purpose is to only make the law consistent with the court rulings on SB 1, the Gun Safety Act of 2023. So we have language in 4-111 of the Criminal Code that states where firearms are prohibited in certain areas, and we made an exemption for retired law officers. Therefore, we wish to also make that same exemption for retired law officers under section 6-411. So we just want to fix that inconsistency. The opposition seeks to amend the bill either to make the exception in House Bill 308 for all or for none. They claim one permit holder is the same as all permit holders. But the truth is, an average holder of a wear carry transport license does not have the training or experience of an active duty police officer, and ultimately an officer who later retires in good standing from the force. So what does it mean to be in good standing? It means that it's a determination made by the chiefs. The officer left without an open discipline. If you resign in lieu of discipline or termination, that is not good standing. How many years before a police officer can retire? Most agencies in Maryland, 20 to 25 years. What level of training does an active duty have to have? Well, an active duty officer has to meet the Training Commission entry-level standards, which is usually 2 weeks or so on the range, and every year thereafter, they must qualify. So they have to qualify on training such as target identification and decision-making. And that target identification is crucial. Regular permit holders, as far as I know, don't have that requirement. So retirees have to qualify every year to maintain their LEOSA certification, their retired law officers, and they have a mental health fitness assessment every 2 years when they are an active officer. So for those distinctions between a retired law officer and a regular or anyone else who has a wear, carry, and transport license, I urge a favorable report on the bill so that we can have a clear and unified policy on this issue, which has already been reviewed by the court. Thank you for your attention, and thank you for a favorable report.
Good evening once again, Chair Clippinger, Vice Chair, and members of the committee. Dan Franklin, once again, Morningside Police Department, Prince George's County, representing Maryland Chiefs and Sheriffs Association, testifying in support of House Bill 308. This, to me, is a common sense bill. It is just adds another layer of public safety to the general public while respecting the property rights. I'll make it as simple as possible and short as possible. Sometimes the only way to stop a bad guy with a gun is a good guy with a gun, period. These retired law enforcement officers are required to qualify yearly. They are required to maintain their proficiency. They're required to maintain their accuracy. You don't just hand these out like candy. Their standards are established by the department they retired from. They have to be in line with the Maryland, MPTSC standards. I won't beat it to death. I know you're going to hear a lot out from other proponents. I'm sure I'll agree with every one of them. Just as a footnote, I am a Maryland qualified handgun instructor, so I do teach the wear and carry course for the general public, and the minimum requirements of the wear and carry course certainly are not as high as the minimum requirements for a LEOSA permit for a retired law enforcement officer. I thank you all for your time.
Thank you. Mike Shire with the Maryland Fraternal Order of Police. Thank you to Vice Chair Bartlett for introducing this bill. Thank you to the chairman and the committee tonight. This is also my last bill for the night, thankfully. This is a adjustment to Senate Bill 1 from 2023. As Vice Chair mentioned, there are exemptions in there for law enforcement officers already and retired law enforcement officers. This is something that was kind of missed, so we are hoping to add this in here. Another thing that I want to highlight is there's been questions about, well, does this just allow police officers off duty and retired police officers to go wherever they want? The answer is no. The criminal trespass laws always do apply. If any private property owner wants to exclude a retired police officer or an active police officer who's off duty, they may do that. But this is extremely important to us. We spend our careers sometimes dealing with unfavorable people who do not like us. For me personally, my other half, my wife, my better half walks on my left side, so that if we do run into somebody that I've unfavorably encountered in the past and wishes to do me harm, she's worried that she's going to end up grabbing me for safety, and that leaves my arm and the ability for me to defend myself. This is a serious thing for us. This is something that we live with. They say with great great power comes great responsibility. We've heard that over and over again, but this is a danger that we face and accept throughout our lives, and it carries with us into retirement. So we do ask that you keep us in your hearts and minds, but please pass this legislation and don't have us put in a position where we're unable to defend ourselves and our families. Thank you.
Good evening now, Mr. Chair. Madam Vice Chair, thank you for introducing the bill. I'll have a conversation with Mike Shire about the position of his wife on his side as it relates to curbs. You know, you got to make sure you're on the curb side, Mike. But for the purpose of this piece of legislation, this is the most important priority of the Maryland State Fraternal Order Police to make sure that our retirees are covered. In the event that we have a critical incident where quick response, look, it's no secret that when seconds count, police are minutes away. And so if you have a retired law enforcement officer that can intervene in an immediate situation, you want them to have the tools available to them to be able to intervene into a critical incident. So on behalf of the Maryland State Fraternal Order Police, the 21,000 members strong, I know that are watching, this is, you know, our top priority, and we will ask for a favorable report for this.
Again, I'm Angelo Consoli with Vice President for the state FOP and President for Fraternal Order Police Lodge 89 in Prince George's County. This bill, as you know, was before you last year, and it did pass out, and it made it to the floor. And unfortunately, there was an unfortunate that at the last seconds of signing die, it did not make it through. There's nothing has changed in the fact that this was a bill that unfortunately needed to be done as when Senate Bill 1 was passed in 2023. Inadvertently, this piece was left off, not allowing our retirees to keep the carry rules that they had in place at the time and that still are in place right now, and that would be consistent with the federal LEOSA standard as well. So all we're asking is to fix the wrong of the Senate Bill the 1 omission and put in its proper place this protection for the retirees that is in all other parts of Senate Bill 1 with this exception of this one specific area, as it's consistent for our retirees and makes sense. Thank you.
Questions for the panel? Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So on the trespass and on the real property, one of the panelists said that if they were excluded, how would a person exclude you from the property?
Don't come in here with a gun. They can't come in here with a gun. I can give you an example. The NFL stadiums do not allow off-duty police officers, retired police officers onto private property, their stadiums with guns. We can't carry on. If we say, no, I'm a police officer, I'm allowed to. Nope, that's not true. That is not the case. And if we would try and stay or go onto that property, we'd be liable for criminal trespass.
How about if you were observing some activity in your neighborhood and you wanted to go investigate? Could you do that?
Can you be a little bit more specific as to what the circumstances might be?
Yeah, you think something is going. We had testimony that certain retired officers felt that they could go and investigate suspicious vehicles. And I had questioned, what is a suspicious vehicle? So if you walk up to a vehicle that's suspicious, I mean, but suppose if they're delivering to someone's house or something, and you think that's suspicious, and then you would think that you should go up and you have the ability to go up to their property and ask this person, what are you doing here at this property? I've never seen you here before. I can tell by your vehicle that you're not from around here.
No.
No, what?
That's not the circumstance here. We have to be really careful with understanding that the training that officers have, and I don't agree with that testimony, quite frankly, but the training that officers have, I agree with your reiteration of that testimony. I'm saying I don't agree with that testimony.
Now, I'm looking at trespass on real property. So if one of these officers are retired and they look and see some suspicious activity happening at a private residence, they would have the ability to go on to the property to see what's
at that point, I would have the ability to go on the property, and I'm not a retired law officer. So everyone has the ability to go on the property. It's the action you take from there. So if they ask you to leave, if they ask me to leave, or if they ask a retired officer to leave, they need to leave, period. That's the way it needs to work, unless they have any, unless they have more evidence, and then perhaps they need to call an active duty officer.
But just for the record, you're saying that anybody can go on anybody's property to investigate what's happening?
I'm not saying that anybody, I'm saying that, here's the situation. If I went on your property, right, like for instance, sometimes I collect trash in my neighborhood, right, and I throw it away. So if I happen to go on someone's property, I see trash, and I go to get that trash, and they say, nope, I'm sorry, I don't want anybody on my property, you gotta go, then I gotta go, the trash has to stay.
Suppose they don't say anything to you, but they see you.
And what?
Suppose if you go, you're saying that you could just go on somebody's property and you can assume what is trash, and maybe they're collecting bottles to recycle them.
If they tell me that, then I will give them the bottle.
Why would they have to tell you that? But that's a different situation. Thank you.
I understand your point.
Any further questions?
I said no, but I understand.
Seeing none, thank you all very much.
Went down
We
the
have
slope.
Mr. Panak coming up, favorable with amendments. And then we'll have Ms. Herod. Mr. Panak, please, for 2 minutes.
Thank you, Mr. Chairman. Mark Pennock, I'm president of Maryland Show Issue. I'm an attorney. You have my written testimony. For the record, I am also counsel of record in the ongoing Novotny and Kipney litigation, in which the Maryland provision at issue here, 6-411D, has already been invalidated by the Federal District Court. Similar provisions have been validated by the district courts in New York, New Jersey, and the West Coast of California and Hawaii. The Second Circuit has already invalidated it for New York. That final judgment has been. So these provisions are already pretty clearly unconstitutional. Full stop. So what this provision, if you extended it to all permit holders, would simply moot that aspect of the KIPP litigation. But there's another point I want to make sure that you're aware of. Under the policy note, fiscal note, it makes clear that there are over 202,000 permit holders right now. That's up from 30,000 as of July 2022. And that number grows every day. So the way it works right now, if I wanted to go in Home Depot, I can drive into the Home Depot parking lot, but I have to leave the gun in the car. I can't go inside with it. With every permit holder, all 202,000 of them are leaving their guns in the car, where they can be stolen most easily. Excuse me for saying so, and very respectfully, that's just crazy. Just crazy. The gun, I'm an instructor as well. The gun belongs on the hip of the permit holder. That's where it's safest. That's where it's least likely to be stolen, and that is where it should be allowed to remain if you amend this bill to include permit holders. So I urge amendments to this bill to allow permit holders to carry in these locations.
Delegate Erica.
Thank you, Mr. Chair. Mr. Penna, can you just explain a little bit more about why the Kipke case, like how does that have an impact in this?
The Kipke case challenged the provisions of 6-411D, which bars permit holders from going into a place that's otherwise open to the public. And I use a Home Depot as an example.
Okay.
But the way this SB1 was crafted is that you can still carry as a permit holder into everything around a building, but not into the building. So I can drive into the parking lot.
Okay.
So what the Federal District Court held in a final judgment that's now on appeal, that provision of 6-411D was unconstitutional.
Okay.
And that is the provision, that's the same provision that was likewise held as unconstitutional by the Second Circuit Court of Appeals in the anti-Yuck litigation. And in the Coons litigation and the New Jersey litigation, the Third Circuit's just about to rule on that, and it's been argued for some time. I expect from what I observed from more argument that the Third Circuit will agree with the Second Circuit on that. So it's already unconstitutional. And there's really no reason not to move that aspect of the appeal.
Okay. And so for this bill, what part of this bill does that affect specifically?
Well, all this bill would need to be amended to add new subsection H to the exceptions. In addition to the LEOSA officers, simply say persons with a carry permit as authorized by 5-306 of the Public Safety Article as another exception to the provisions that otherwise ban persons with firearms from going into these locations.
Okay, because otherwise we pass the bill, it's going to end up getting overturned immediately.
It's already been overturned.
Okay, all right, thank you.
Testify. What's the difference in the training between the retired law enforcement officer and a regular citizen?
Oh, it's substantial. Certainly, the retired officers have more training. They have to have. They have to do a qual every year in order to maintain their LEOSA credentials. And I do agree with the observation that sometimes only a good guy with a gun can stop a bad guy with a gun.
Right, I wasn't asking about that, but if a regular citizen gets the extra training that you're talking about, then they should be able to carry into a store just like the retired law enforcement officer?
They can right now, Delegate, because that part of the provision of state law has been validated.
Thank you very much.
Delegate Tolles.
This will be really quick. Thank you so much, Mr. Chair. Would you agree that retired law enforcement would want this provision in order to protect the community? How is that different than versus just the 102,000 individuals you said that are able to carry the gun freely as they want to? How is that any different?
Retired law enforcement, if they have LEOSA credentials, and that's a big if, but retired officers have no more law enforcement authority than I do. They're not cops any longer. So what their motivations for carrying, I'm sure, includes self-defense, as you just heard, but the rights of self-defense.
Or defense of the community, if possible.
Well, they are operating no differently than any other person.
Are they trained differently?
They may be trained differently, but that may be years ago.
In their training, would they have been trained differently when they, as law enforcement officers, are they trained differently than a regular citizen?
They are trained in addition to what we train people as regular citizens, yes. So they have additional training, and there's no doubt about that. But LEOSA doesn't expire as long as you maintain your calls every year. So you could have a person who's been retired for 20 years, and he has exactly the same legal law enforcement authority as I do as a non-officer. They don't have any obligation to come to the aid of anybody or any more than I do. So this is a matter really of self-defense, as you heard earlier from these officers, and I applaud that. They have certainly a need for self-defense, but so do I, and so does every permit holder.
Well, everybody has a need for self-defense. So I would say that I lost my train of point as you were talking. So you would agree that they have different training. They have been trained differently than anyone else.
Sure.
And don't you think that the time that they've served this community for years, 20, 25 years, they should be able to have some of the same ability they have as if they were still law enforcement officers, with the idea that their whole goal, most officers' role is to protect the community?
Again, they have the same self-defense rights as I do, and I applaud their reasoning on that, but I don't think you can expect them to act as police officers once retired.
I'm gonna say, I don't want to belabor this, just in closing, Mr. Chair. How many police officers versus citizen versus a police officer, in your opinion, who is most likely to use stand your ground laws when they feel necessary, a trained law enforcement officer or a Joe Blow citizen?
Maryland does not have stand your ground laws.
I didn't say they had stand your ground laws. Some people think that they do.
Well, they're mistaken.
Correct. Okay. So I'll put my money more on a trained officer who has been trained for, 20, 25 years to protect the community.
The retired
Isn't
officer.
that so? Thank you, Mr. Chair.
No, it's not, actually.
That's what I think. It's not what you think.
Oh, I'm sorry. I thought you asked me if that was so.
Delegate Simmons.
Thank you, Mr. Chair. Can you explain to me what's nomenclature and when it comes to law enforcement training, and weapons retention? What does that mean?
Well, weapons retention means in a confrontation with a suspect or a person that you're seeking to arrest, or defend yourself against, you train to be able to keep your firearm away from being grasped by another individual. I teach people weapon retention. I've been trained in weapon retention.
So that'd be like line of sight as well?
I'm sorry, line of sight?
Line of sight when you're firing a weapon.
Well, line of sight is simply what you do when you shoot your weapon. You have to take into account the whole environment around you, what's behind the weapon, what's behind the suspect, what's behind the person you're shooting at or may not be shooting at. You have to make an assessment. All those factors go into the training. So I train people that when I do instruction. I've been trained to do that. Almost everybody I train is trained in those things. Is it the same amount that the police officers get? No, of course not. But everybody gets exposure to those concepts. But then, as police, retired officers don't have any more obligation to enforce the law as retired officers than I do. And that is the point here. So they're carrying for self-defense. I carry for self-defense. I can't make any more arrests than they can as retired officers. And they can't make any more arrests than I do as retired officers. Bear in mind, what this bill does is allows a LEOSA person or a retired officer with a carry permit who's no longer has LEOSA credentials to enter a home without prior permission, because that's an exception to the whole section. It also allows them to enter places that are otherwise open to the public without permission. Both of those, that's subsection C and subsection D. So this gives a person who's a retired officer basically free rein to enter until he's told he has to leave. In the KIPP litigation, we're only seeking to have the right to enter places that are otherwise open to the public, not private homes. So this is actually granting LEOSA officers and retired officers with carry permits much more leeway to go into private homes. That's really kind of remarkable when you think about it.
Thank you.
Seeing no further questions, thank you very much. Karen Herron.
Good evening. I am Karen Herron, the Executive Director of Marylanders to Prevent Gun Violence, urging an unfavorable report on House Bill 308. This bill is unnecessary, confusing, undermines private property rights, and weakens our gun safety laws. Our concealed carry laws were crafted in response to the Supreme Court's Bruin decision. Subsequently, the KIPP v. Moore ruling enjoined two pieces of the new law, one of which is at issue here, the private building consent rule. That piece had originally stated that there was a presumption that you could not carry onto private property without express authorization by the owner or agent. As a KIPP decision enjoined that piece of the law, essentially the opposite is now true. There is a presumption that a concealed carry holder can carry as long as there is not an express denial. Given that that is the case, a few things are true. First, the current statute is now not clear, since someone reading the statute on its own would not know that the current state of the current state of the case law. HB 308 is attempting to provide an exception for a piece of the law that is enjoined. 2, this legislation is overly broad, allowing any retired law enforcement from any jurisdiction to override private property rights, creating potential for abuse. Retired law enforcement officers no longer acting in an official capacity should not be granted special privileges that infringe on private property rights. And finally, the 23 legislation did provide a narrow exception for retired law enforcement in the case of certain sensitive places, which is now located in Crim Law 4-111. That piece was thoroughly debated and deliberated to provide a narrow exception addressing very specific security concerns, such as Maryland synagogues that employ retired law enforcement officers for security. For all of these reasons, MPGV urges an unfavorable report.
Questions? Delegate Embry.
Thank you. What is your recommendation given the enjoined portion of the law?
I assume the committee would like to wait till the court proceedings play their way out before making any changes, but I would think that that would be the fix. Ultimately would be to conform the statute to what the court decisions come up with. If that private property rule continues as it is currently enjoined, basically on its head, then you'd want to bring it in line with what the case law is saying and make it clear to everybody. The last thing we want to do is be sort of jamming people up because they can't read the statute and understand what the law is.
Seeing no further questions, thank you very much. That concludes the testimony on House Bill 238. Last bill of the night is House Bill 669. Delegate Williams, Daniel Broder.
I'm thrilled.
Okay, Sarah Sample, Peggy Higgins.
You sit here? Yeah.
Daniel Broder may be virtual? No?
Yeah, he's supposed to be virtual.
He is not there.
Not there?
No.
Okay.
Sadly. But go ahead, delegate, for 3 minutes, please.
Okay, good evening, colleagues, Chair Clippinger, Vice Chair Bartlett, and the members of the Best Committee in the House of Delegates, the Judiciary Committee. I know I'm the last bill of the night, and so I am not going to take up my full 3 minutes. Really, the gist of this bill is just to provide some uniformity regarding body camera footage. And you have my written testimony in front of you, so I'm not going to repeat that. I will say, you know, we've been having conversations with a lot of the stakeholders, some of whom are up here, others that you're going to hear unfavorable on this bill. We've been having conversations with them, and we'll continue to have conversations with them trying to address their concerns. And so, you know, that's really the main gist of what I have here. You know, we appreciate the hard work of all of our state and local law enforcement officers to keep our communities safe. And so passing this legislation really for us is just really just ensuring the efficiency of what they do every day to help our communities. And that's really the goal of this bill. And so I'm done.
I can go ahead. So, thank you to the chair, members of the committee for having me. My name is Sarah Sample here with the Maryland Association of Counties, and we support with amendment House Bill 669. Some of this committee might remember that MACO had an initiative for, I want to say it was about 4 or maybe even 5 years, that we're trying to establish some of the guardrails that this bill looks to put in place when it comes to a PIA request for body-worn camera footage. You know, we recognize that this is a very unique public document. It's something that we don't think the PIA, when it was initially written, was able to address. Because it's really unlike anything else that could be PIA'd. So it's hundreds of thousands of hours of footage. It's incredibly sensitive footage. It's got a lot of privacy information on it, and currently it's all PIA-able, even the inconsequential stuff. And that's also why we have custodians that have personal liability when it comes to making sure that everything is reviewed and redacted perfectly. And so we certainly commend the bill sponsor for bringing this, because this is something that's been really important to us for a while. And so we appreciate the PIA components in and the guardrails. The only amendments that we were suggesting is that there's one part of the bill that basically says you would have to get written permission from everybody on the footage to go ahead and be able to release it. And we just wanted some sort of a barrier there, because if it's 10 people on the footage, then we're concerned that we won't have enough time to meet the deadline to release the footage if we have to get written permission from that many people. So we just wanted to have sort of like a barrier there in terms of if it's a video with maybe 3 people on it, then if it's more than 3 people, then you would basically only release it to anybody who was on the footage, ultimately. And then the other thing is there's a lot of very prescriptive standards when it comes to how the footage can be handled and used by law enforcement agencies. There's a lot of regulations currently in place that this bill has pretty much like taken the regulations and put it into the bill. And we're concerned that it's about a 134-page document. We're not sure everything is translated perfectly. And so we're just a little concerned about some of that. But otherwise, we would be favorable with the amendment. Thank you.
Good evening. Last but not least, right? My name is Peggy Higgins, and I'm a longtime resident of Maryland, and I'm in strong support of this legislation with amendments, and thank Delegate Williams for her sponsorship. Body-worn camera recordings are invaluable both to public safety officials and the public in providing a transparent, objective recordings for police interactions with the public. House Bill 669 provides requirements and consistency across jurisdictions. I submit 3 recommendations to enhance this important bill. 1, extend retention of body language, body camera recordings to be in alignment with statute of limitations as a protection not only for members of the public, but for officers as well. The bill currently requires recordings to be destroyed after 90 days, except when recordings are flagged for specific identified reasons. This presumes that everything needed to know is known within 90 days of the recording. Yet lawsuits for personal injury and malicious prosecution, etc., can be filed for several years after an incident. It is important to use Maryland's statute of limitations as the timeline for destruction. 2, amend the bill to continue to allow public access to recordings, of course with the bill's caveat about blurring identification of witnesses, victims, or individuals not arrested. The bill currently stipulates, quote, the custodian shall deny inspection of a recording made with use of a body-worn camera of a law enforcement officer, unquote, except in certain circumstances. Public access to these recordings is enormously important in maintaining and building public trust, especially when controversy exists. And 3, amend the bill to stipulate that the original full recording be retained when there has been a redaction or modification. The bill is silent on this issue. I appreciate your time today and your service, and having been with you since 1 o'clock this afternoon, I'm in awe. I'm in awe. Thank you for your service.
Daniel Broder did arrive virtually. Mr. Broder, for 2 minutes, please.
Hello, greetings, everyone. Can you hear me?
Yes.
Hi, everyone. Dan Broder, Hyattsville, Maryland, District 22, a very proud resident and constituent of Delegate Williams here in Hyattsville, Maryland. Here to speak in favor of this bill with the amendments that have been suggested in this age of increased police presence. I think it is only natural that we should have increased police accountability. Body-worn cameras are a crucial element of this. They provide objective footage as to what happened during police interactions with civilians, and they provide an opportunity for the public, the court system, and the police department to review the footage afterwards. Please support this bill with the amendments suggested. I thank you all for your time, and a very special shout out to Delegate Williams for carrying this important piece of legislation. Thank you.
Questions for the panel? Other nice things that people would like to say about Delegate Williams? Delegate Kaufman.
Well, yes, in terms of nice things, I'd like to say about Delegate Williams, she's my sister from another mother, but I do have a question because DL, I want to make sure you're aware that, because sometimes they give it to us last minute, that unfortunately DLS has given your bill a fiscal note of $2.1 million. So I was wondering, as much as I love it, if you've given any thoughts to ways to reduce it, and if you need more time to think about it, that's fine, because one time I got a fiscal note for a hearing the next day at 4:23 p.m. So if you haven't had time, that's fine too.
Yeah, we haven't had time to digest this, but we will certainly try to work on trying to get the fiscal note down. We understand the budgetary constraints, and that could be an impediment. So yes.
Thank you.
Further questions? Seeing none, thank you very much. 2 people here in person testifying unfavorably to the bill, Chief Morris and Franklin. 2 minutes for each.
Good evening once again, Chairman Clippinger, Vice Chair Bartlett. This is season 4 of Dan Franklin, Chief of Police, Morningside, Prince George's County, testifying in opposition to House Bill 669. I have 3 points to make. First point, not discounting any concerns or issues with the reason the bill has been drafted, but the Maryland Police Training and Standards Commission has been tasked previously with auditing and reviewing all the agency policies. I believe that we should let them do that. This bill kind of sets a precedent of micromanaging type overwatch, if you would. If there is one good point in this bill, page 11, lines 11 to 24, kind of sets forth what we should have them, have the Training Commission be doing. Point 2, requiring or passing this bill could push the investigations that would be taking place beyond some of the established timelines. For example, generally speaking, the AG's IID, they try to release within 20 days of the incident. They try and release video footage. By requiring consent of everybody on a video, that could be absolutely, I don't want to call it absolutely impossible, but pretty close. You have plenty of random people that may be there. It's not always just the cop and the alleged bad guy or contact person. Last point, page 7, line 21. The 90-day retention kind of flies in the face of a lot of the civil litigation statutes of limitations, as well as the lack of time frame that exists for someone to file a complaint against an officer. We wouldn't want to be looked at as destroying evidence if a complaint is filed 5 years down the road, which coincidentally, I believe happens to be the guidelines for filing of a US DOJ complaint. I believe that's 5 years. I will not take any more of your time on this glorious evening. I would just ask that you file an unfavorable report on this bill, and thank you for your time.
Morris.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. Chief Morris, also here on behalf of the Maryland Chiefs and Sheriffs. First, let me state unequivocally the Maryland Chiefs and Sheriffs fully support the use of body-worn camera programs. We have worked closely with this committee and the General Assembly back in 2020 that resulted in a task force under House Bill 739 that established some preliminary recommendations. And furthermore, again in 2021, it resulted in the passage of Senate Bill 71 that further established rules for the Maryland Police Training and Standards Commission to establish policies. Has already been presented, and I think you'll see that we're not far off from those that were here with amendments has already been stipulated to, particularly as it pertains to obtaining written permission of all participants or all those that are captured, as well as the retention. I think from the most important piece of this is we want to be cautious not to codify policies or provisions that should be in a policy under COMAR or under the Maryland Police Training and Standards Commission's regulations, not COMAR, but the regulations that can be adopted and modified and changed as technology changes or as case law might change. So we appreciate the delegate bringing this forward. It's certainly a valid conversation, but we do believe that the policies that are in place and the model policies are in place by the Maryland Police Training and Standards Commission provide the guidance for the policies for the police agencies that use body-worn cameras. So more of a support with amendment than a full opposition, but we certainly appreciate it and look forward to continuing the conversation.
Going to Debbie Levy now, who's listed on my paper as informational, but perhaps is unfavorable. So we're going to give her 2 minutes. She'll tell us what she is, and she's the last person to testify. Debbie Levy.
Well, my fearless leader was out of town when I submitted, so I'm just going to stick with informational. I want to start with, I'm Debbie Levy from the Office of the Public Defender. On the whole, we are the biggest fans of Delegate Williams, and we appreciate her service, everybody's service tonight. And we appreciate Delegate Williams' commitment to this issue. We love the first part of the bill that addresses where there's a pattern of misconduct in failing to activate body-worn camera. But we do believe that the bill is maybe just biting off a little too much right at this time, and we would encourage further conversations. We certainly agree that it's really important for transparency, for IID, for the Attorney General's Independent Investigation Division to quickly be able to release body camera of law enforcement involved fatalities. And this would really chill that goal. Also, every internal affairs file that is disclosed in criminal proceedings through discovery has body-worn camera attached. And we would essentially gut sort of the purpose of the PIA. Also, the Public Information Act, part of the Police Accountability Act's main thrust was to move internal affairs records to discretionary denial. And if internal affairs files hold body-worn camera that are now moving into the mandatory denial space, we're going to have a conflict every time an internal affairs file is ordered disclosed in a criminal matter or through PIA. Already, we have, I think I've testified last year from Montgomery County, we got $1 million fee request to redact body-worn camera in compliance with the provisions that were in the Police Accountability Act. There are so many redaction requirements. In fact, we never even get body-worn camera except for in limited circumstances, and this would make it impossible. So we would encourage further discussions to talk about ways to address issues with body-worn camera, and want to thank everybody for letting us stay this late and voice our concerns, and thank you, Delegate Williams.
Questions? Delegate Erica.
Thank you, Mr. Chair. I just needed to do a little what if thing with you guys. So I had to pull some footage from my sheriff's office recently through MPIA after a domestic dispute that police were present, multiple parties. If this bill passed, would I potentially have to get permission from all the people in that video footage to pull it and use it in the civil trial?
Delegate, I believe that with the way the bill is written, it's very specific that you have to obtain written permission to disclose a recording from each individual captured in that. So it could even be bystanders.
Okay.
And we think
or, for example, the abuser would I'd have to get his permission to use it.
It'd be a very challenging bar.
Okay, thank you.
I just could add, I don't know that it's you, Delegate Erican, but I think the police department would, but it would meet the same end, that written permission is required.
Great. Seeing no further questions, we thank you all very much. That concludes the testimony on House Bill 669. Tomorrow we have hearings. We're going to have a briefing on the audit report for the Department of Juvenile Services. That will begin, I think we're going to begin that an hour after. It's supposed to start at 11, but it's going to be an hour after the end of the floor session tomorrow. Then we're going to see where we are with bill hearings. We're going to try and start the bill hearings as close to 1 o'clock as we can. Tomorrow there are a little over 100 witnesses. Thank you very much. This has been a hearing of the House Judiciary Committee.